ಫಾರೆಸ್ಟ್ ಡಿನೋಟಿಫಿಕೇಶನ್ ಎಲ್ಲ GM ಫಾರೆಸ್ಟ್ ಬರುತ್ತಾ? ಫಾರೆಸ್ಟ್ ಡಿನೋಟಿಫಿಕೇಶನ್ ಆಫ್ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ಸ್ ಆ ತರ ಕೇಸಸ್ ಏನೋ ಅದ್ರ ಮೇಲೆ ಬಂದ್ರೆ GM ಫಾರೆಸ್ಟ್ ಬರುತ್ತಾ? ನಿಮ್ದು ಯಾವ್ದಾರ ಬೆಂಚ್ ಇತ್ತ ಮುಂಚೆ ಯಾವಾಗ? ಹೌದಾ?
ಫಾರೆಸ್ಟ್ GM ಮಿಷನ್ ಸಿಗ್ತಲ್ಲ ಅವಾಗ
ಅಲ್ಲ ಅಂದ್ರೆ ಅಕೌಂಟ್ ಇದೆಯಲ್ಲ ನಿಮ್ಗೆ?
ಏನ್ ಹೇಳಿ
ಒಳ್ಳೆ ಅಡ್ವೊಕೇಟಿಗೆ ರೆಫರ್ ಮಾಡಿ.
ಡಿನೋಟಿಫೈ ಮಾಡಿದಾರೆ ಅದನ್ನ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ನ.
ಡಿನೋಟಿಫಿಕೇಶನ್ ಫಾರೆಸ್ಟ್ ಅವರು ಇದಕ್ಕೆ ಹಸ್ತಾಂತರ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಲೆಟರ್ ಕೊಟ್ಟವ್ರೆ. 2064 ಅಲ್ಲಿ GO ಇದೆ, ಇಷ್ಟು ಹಂಚಿಕೆ ಆಗಿದೆ ಇಂತ ಇವರಿಗೆ ಅಂತ ಒಂದು ಕಮ್ಯುನಿಟಿಗೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 500 ಚಿಲ್ಲರೆ ಎಕರೆ. ಅವಾಗಿದ್ದನು ಅವ್ರ ಹೆಸರಿಗಾಗಿ ಆಲ್ರೆಡಿ ಎಲ್ಲ ಬೇರೆ ಬೇರೆಯವರಿಗೆಲ್ಲ ಮಾರಿದ್ದಾರೆ. ಕೆಲವರು ಪಾಣಿ ಎಲ್ಲ ಅವ್ರ ಹೆಸರಲ್ಲೇ ಇದೆ. ಅದನ್ನ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಇವರು ಡಿನೋಟಿಫಿಕೇಶನ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಅವಾಗ 1964 ಅಲ್ಲಿ ಹೊಡೆದ್ ಕೊಟ್ಬಿಟ್ಟವ್ರೆ ಎಲ್ಲ ಫುಲ್ ಎಲ್ಲ. ಈಗೆಲ್ಲ ಅದು ಫುಲ್ಲು ಕಲ್ಟಿವೇಟೆಡ್ ಲ್ಯಾಂಡೇ. ಇವರು ಬುಕ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ಮೈನಸ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಇವ್ರ ಲ್ಯಾಂಡ್ನ, ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ನ. ಸ್ಟಿಲ್ ಅದು ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಬಟ್ ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ಓವರ್ ಆಗೋಗಿದೆ, ಖಾತಾ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದೆ. ಕೆಲವರೆಲ್ಲ ಸುಮಾರು ಜನ 1964 ಇಂದ ಸುಮಾರು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಈಗ ಅದು ಡಿನೋಟಿಫಿಕೇಶನ್ ಮಾಡಬೇಕು. ಬಟ್ ಇವರು ಇದ್ರ ಪ್ರಕಾರ ಡಿನೋಟಿಫಿಕೇಶನ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಫರ್ದರ್ ಇದ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದಾರೆ. ಸೇಲ್ ಮಾಡೋದು ಆತರ ಇದ್ರೆ ಅದಕ್ಕೋಸ್ಕರ ಅದ್ರ ಮೇಲೆ ಇದು ಕೇಸ್ ಬರಬೇಕು. ಡಿನೋಟಿಫಿಕೇಶನ್ ಪಿರಿಯಾಪಟ್ಟಣ, ಮೈಸೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್, ಕುಶಾಲನಗರ್ ಆ ಸೈಡ್. ನಮ್ಮ ಮಾವರ್ದನೆ, ನಮ್ಮ ಮಿಸಸ್ ಅವ್ರ ತಂದೆಯವ್ರದೇ, ಅವರು ಫ್ರೆಂಡ್ಸ್ ಎಲ್ಲ ಇದೆ ಲ್ಯಾಂಡ್. ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಎಗನೆಸ್ಟ್ ಆಗಿ ಇದ್ ಮಾಡಂಗಿರ್ಬೇಕು. ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಫಿಷಿಯಲ್ಸ್ ಯಾರೇ ಏನೇ ಬಂದು ಇದ್ ಮಾಡಿದ್ರು ಅವ್ರಿಗೆ ಏನಾದ್ರು ಇದ್ ಮಾಡಿದ್ರು ಸ್ವಲ್ಪ ಫುಲ್ ಪ್ರಾಂಪ್ಟ್ ಆಗಿರ್ಬೇಕು. ಆ ತರದ್ ಬೇಕು ಸರ್.
ಹಂಗಂದ್ರೆ ಪ್ರಾಂಪ್ಟ್ ಅಂದ್ರೆ ವಿವೇಕಾನಂದ ಇಟ್ಕೊಳ್ಳಿ.
ಎಸ್ ಸರ್,
TP ವಿವೇಕಾನಂದ TP ವಿವೇಕಾನಂದ.
TP ವಿವೇಕಾನಂದ ಪ್ರಾಂಪ್ಟ್
ವೆರಿ ಪ್ರಾಂಪ್ಟ್.
ಇದು ನಾಲೆಡ್ಜ್ ಇದೆಲ್ಲ
ನಾಲೆಡ್ಜ್ ಎಲ್ಲ ಚೆನ್ನಾಗಿದೆ.
ಹೌದಾ?
ನಾಲೆಡ್ಜ್ ಎಲ್ಲ ಚೆನ್ನಾಗಿದೆ.
ಓಕೆ ಓಕೆ. TP ವಿವೇಕಾನಂದನ
ಪ್ರಾಂಪ್ಟ್ ಅಲ್ಲಿ ಇದಕ್ಕೆ ಅವ್ರನ್ನ ಹೇಳ್ತೇನೆ.
ಗೌರ್ಮೆಂಟ್ ಎಗೇನೆಸ್ಟ್ ಆಗಿರ್ಬೇಕು ಅವ್ರ ಮೈಂಡ್ ಸೆಟ್ ಒಂಥರ.
ಗೌರ್ಮೆಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಇಲ್ಲ, ಅವರು ಏನಿದೆ ಅದನ್ನು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ ಕೊಡ್ತಾರೆ.
ಓಕೆ ಓಕೆ ಓಕೆ.
ನೋಡಿ
TP ವಿವೇಕಾನಂದನ ಸೆಕೆಂಡ್ ಆಪ್ಷನ್ ಇದೆಯಾ?
ಸೆಕೆಂಡ್ ಆಪ್ಷನ್ ಈ ಕಡೆ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಸರ್ ನಮಸ್ಕಾರ. ಚಂದ್ರಕಾಂತ್ ಗೋಡೆ
ಸರ್ ಮೆಮೊ ಹಾಕ್ಬೇಕಿತ್ತು. ಮೆಮೊ ಹಾಕ್ಬೇಕಿತ್ತು ಪೋಸ್ಟಿಂಗ್ಗೆ.
ಬಂದಾಗ
17ರಲ್ಲಿ ಒಂದಿದೆ ಸರ್ ಚಂದನ, ಅಲ್ಲಿ ಕೊಟ್ಟು ಬರ್ಬೇಕು. ಅದಕ್ಕೆ ಲೇಟ್ ಆಗುತ್ತೆ. ಕೊಟ್ಟು ಬರ್ಬೋದಾ?
ಏನ್ ಬೇಕು ಹೇಳಿ ನಿಮ್ಗೆ?
ಅಲ್ಲಿ 17ರಲ್ಲಿ ಒಂದು 2 ಇದೆ, ಕೊಟ್ಟು ಬರ್ಬೇಕು. ಸರ್ ಹೇಗೆ ಸರ್, ಪರವಾಗಿಲ್ಲ ಸರ್ ಸಾಹೇಬ್ರು? ನಾನು ಇವ್ರ ಮುಂದೆ ಬಂದಿಲ್ಲ.
ಬನ್ನಿ ಕೊಡಿ ಸರ್.
CMP ಮ್ಯಾಟರ್
ಕೊಡಿ.
ಅದೇ
CMP ಮ್ಯಾಟರ್.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್
ಆಫ್ ಆರ್ಬಿಟ್ರೇಟರ್ ಕೊಡಿ. ಟೈಮ್ 10:30.
What's the first? ಪಾಸ್ ಅವ್ರು ಎಷ್ಟೊತ್ತಿಗೆ ತಗೋತಾರೆ ಮತ್ತೆ
ಮಧ್ಯಾಹ್ನ
ಹ?
ಮಧ್ಯಾಹ್ನ
ಮಧ್ಯಾಹ್ನ?
ಅದು ಹೆಂಗೆ ನೋಡ್ಬೇಕು ಸರ್, ಅದು ಹೇಳಕ್ಕೆ.
ಇಲ್ಲ ನಾನೊಂದು CP ಪಾಸ್ ಓವರ್ ಮಾಡ್ಸೋಣ ಅಂತಿದ್ದೆ.
ವಿಡಿಯೋ
ನಮ್ಮದಲ್ಲಿ ಬಂದ್ಮೇಲೆ ಕೊಡಿ ಸಾಹೇಬ್ರು.
ವಿಡಿಯೋ ಇಲ್ಲ ಅಲ್ಲ?
ಹ್ಮ್
ನಿನ್ನೆ ಒಂದು ಮ್ಯಾಟ್ರು ನಾಟ್ ಬಿಫೋರ್ ಮೀ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ಫೈಲ್ ಹೋಗಿರುತ್ತಾ?
ನಮ್ಮಂದು ಯಾವ್ದು ನಾಟ್ ಬಿಫೋರ್ ಆಗಿಲ್ಲ.
ನಿನ್ನೆ ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರು
ಏನ್ ಮ್ಯಾಟ್ರ್ ಅದು?
ಅದು KLR ಬೆಂಚಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ.
ಅದಾ?
ಹಾ.
ಹೌದೌದು, ಕೇಳೋರ್ ಬೆಂಚ್ಗೆ ಹೋಗ್ಬೇಕು ಅದೆಲ್ಲ. ಅದು RTC ಎಲ್ಲ
ಅದೇ RTC ಅದು.
ಬಿಲ್ ಮಾಡಕ್ ಬರ್ಬೇಕು.
ಅದು ಆಕ್ಚುಲಿ ಓನ್ಲಿ ಸಪೋರ್ಟಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು, ಅದ್ರ ಮೇಲೆ ನಾನು
RTC ಮೇಲೆ ಕೇಳ್ಬಾರ್ದು.
ಹೇಳಿ. ಇವತ್ತು ಒಂದಿದೆ ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರು, ಅದರಲ್ಲಿ ಕೆಲವು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರದ್ದು ಆರ್ಡರ್ ಹಾಕಿದ್ದೀನಿ. ಅದು KLR ಅಲ್ಲೂ ಆಗಿದೆ, LB ಲೂ ಆಗಿದೆ. ಸ್ವಲ್ಪ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
ನೋಡಿ.
ಯಾವ್ದೋ ಇದು ಬೆಸ್ಕಾಮ್ ಇದೆ ಪಾರ್ಟಿ.
ಮೆಮೊ ಏನ್ ಸಬ್ಮಿಷನ್
ಬಂದ್ಮೇಲೆ ಕೊಡಿ ಸರ್.
ಸರ್ ಸರ್
ಇಲ್ಲಿ ಸರ್
ಸರಿಯಲ್ಲ, ಮತ್ತೆ 39 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ನೋಡ್ಬೇಕಿತ್ತು?
ನಿಮ್ಗೆ ಆಗಲ್ಲ,
ಮೈನರ್ ಇದ್ರೆ ತಗೊಂತಾರ ಸರ್? ಹಂಗೆ ಮೈನರ್ ಇದ್ರೆ
ನಿಮ್ಗೆ ಆಗಲ್ಲ ಸರ್.
ಮೈನರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ತಗೊಂತಾರ ಅಂತ?
ಹಾ ತಗೊಂಡು ಏನು ಹ್ಯಾಂಪರ್ ಆಗಲ್ಲ.
ಫ್ರೆಶ್ ಮೆಮೋಸು CM.
ಬಂದ್ಮೇಲೆ ಕೊಡಿ ಸರ್.
ಆಯ್ತು ಸರ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಅದಕ್ಕೆ ನೋಡ್ಬೇಕಿತ್ತಲ್ಲ ಸರ್ ಏನು ಅಂತ.
ಈಗ ಆಗಲ್ಲ ಸರ್.
ಅಯ್ಯೇ ಹಾಕಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಕೂತ್ಕೊಳ್ಳಿ ನೋಡೋಣ. ಏನ್ ನಾಗರಾಜ್? ಹಾ.
Excuse me, sir. ಮ್ಯಾಟ್ರ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಸರ್.
ಹಾ.
FR ನಂಬರ್ ಬಂದಿಲ್ಲ, ಸೊ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ.
ಹಾ, ಕೊಡಿ ಸರ್. FR ನಂಬರ್ ಕೊಡಿ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಹಾ, ಇಲ್ಲಿಯೇ ಬರೋದು. ಇಲ್ಲೇ ಬರೋದು. ಹಾ, ಇಲ್ಲೇ ಸರ್ ಹೇಳುದಲ್ಲ. ಏನ್ ಸರ್ ನಿಮ್ದು ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರು?
ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಸರ್. ಅಯ್ಯೇ ಹಾಕಿದ್ದೆ ಕ್ಯಾಟಿಂಗ್.
ಹಾ, ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಟು ಬಿ ಸರ್ಡ್.
ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
ಮತ್ತೆ ಏನಕ್ಕೆ ಬಂದಿದೆ ಅದು ಮತ್ತೆ?
ಫೋಟೋ ಸರ್. ಅದೇ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಗೊತ್ತು.
ಹೇಳಿ ಸರ್.
ಇದು ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ನಾಳೆಗೆ ಇದೆ.
ಹಾ,
ಇದನ್ನು ಅದ್ರ ಜೊತೆಲಿ ಬರ್ಬೇಕು. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್.
ನೆನ್ನೆ ಕೊಟ್ರಲ್ಲ ನಂಬರ್ ಅದ? ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್?
ಅಲ್ಲ ಇವತ್ತಲ್ಲ, ನಾಳೆಗಿದೆ. ನಾಳೆ ಬರುತ್ತೆ.
ಹಾ,
ನಾನೀಗ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ನಾನು ಮಾಡ್ತಾ ಇದ್ದೆ.
ಅದು ಬಂದ್ಮೇಲೆ ತಗೊಳೋದು. ಇವಾಗ ತಗೊಳೋದು. ಎಷ್ಟು ಏನ್ ನಡೀತದೆ ಅಂತ?
29 ಸರ್.
ಹಾ,
ಅಯ್ಯೇ ಹಾಕಿದ್ದೆ, ಅದ್ರಲ್ಲಿ ಏನು
ಏನಯ್ಯೇ
ಏನಂತ
ಸರ್? ಅದೆಲ್ಲ ನೀವು ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಕೇಳ್ಕೊಬೇಕು ಸರ್. ನೀವು ಇಲ್ಲಿ ಬಂದು ಇದ್ ಮಾಡೋರು. ಏನ್ ಅಯ್ಯೇ ಹೇಳಿ ಸರ್. ಅಯ್ಯೇ ಯಾವ್ದು?
ವಿಕೆಟಿಂಗ್.
Annexure R14 legible copy to be filed. R14 legible copy act.
ಒಂದೇ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಾ, ಏನು ಹೆಸರು? ಅಂಜಿಲಾ ಇರ್ಫಾನ್
ಸರ್. ಮೂವ್ ಮಾಡಿದ ಮೆಮೊನ ಕಳಿಸಿಲ್ಲ ಇಲ್ಲಿ. ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕಾ?
ಮತ್ತೆ ಯಾರ ಹತ್ರ ಇದೀಮ್ಮ? ಯಾರ ಹತ್ರ? ಸಾಹೇಬ್ರು? ಅಲ್ಲ, ನೀವು ಕಷ್ಟ ಆಗಲ್ವಾ? ತಂಜಿಲಾ ಇರ್ಫಾನ್ ಏನದು? NLADAF ಮೇಡಮ್. ಯಾವಾಗ ಜಾಯ್ನ್ ಆಗಿದ್ದೀವಿ? ಮತ್ತೆ ನೀವು ಯಾರಿಗಾದ್ರೂ ಹೇಳ್ಬೇಕು, ಕಷ್ಟ ಇದೆ ಇಲ್ಲಿ ಮ್ಯಾಟ್ರ್ಗಳು. ಯಾರೋ ಜೊತೆ ಕರ್ಕೊಂಡ್ಬನ್ನಿ. ನಿಮ್ಗೆ ಹೆಂಗ್ ಬರ್ತೀರಾ? ನೀವೇ ಕಷ್ಟ ಆಗತ್ತೆ ನಿಮ್ಗೆ. ತಗೊಂತೀವಿ ಮೇಡಮ್. ಹಾ,
ಮೆನ್ಷನ್ ಮಾಡಿ ಇಲ್ಲ
ಹಾ,
ನಾನು ಒಂದು ವಾರದಿಂದ ಮೂವ್ ಮಾಡಿ 2 ಸತಿ ಮೂವ್ ಮಾಡಿದ್ದೀನಿ.
ಹಾ.
ಲಿಸ್ಟ್ ಆಗ್ತಿಲ್ಲ, ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ ಅಂತ ಹೇಳಿ. ಡೇಟ್ ಕೊಡ್ಬೇಕು.
ಏನ್ ಬೇಡ ಮೇಡಮ್,
ಬರ್ಬೇಕಲ್ವಾ?
ಫಾಲೋ ಅಪ್ ಮಾಡಿ. ಸ್ವಲ್ಪ ನೀವು ಫಾಲೋ ಮಾಡ್ಬೇಕು.
ಏನಿಲ್ಲ ನೋಟಿಸ್ ಸರ್ ಏನಿಲ್ಲ.
ಬರ್ತಾ ಇಲ್ವಾ CMP?
ಇಲ್ಲ ಸರ್, ಅರ್ಜೆನ್ಸಿ ಇದೆ. ಅಂದ್ರೆ
ಹಾಕಿದ್ದಾರಲ್ಲಮ್ಮ ಎಷ್ಟೇ ಅಂದ್ರೆ 12ರಿಂದ
ಯಾವ ವರ್ಷಕ್ಕೆ ಬರ್ತೀನಿ ಸರ್?
12ರಿಂದ 19ವರೆಗೂ CMPನೇ ಇದೆ ಅಡ್ಮಿಷನ್. 22 ಇಂದ 24 ಡೈಲಿ ಬರ್ತಾ ಇದೆಯಲ್ಲ.
ಬರ್ತಾನೆ ಇಲ್ಲ ಸರ್, ಮೆನ್ಷನ್ ಮಾಡ್ಲಾ
ಸ್ವಲ್ಪ
ಇವತ್ತು?
ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್.
ಓಕೆ, ನಾನು ಇವತ್ತು ಮೆನ್ಷನ್
ಅಡ್ರೆಸ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. ಏನ್ ನಂಬರ್? ನಂಬರ್ ಏನು?
452 of 23.
450.
2 ಮೊನ್ನೆ 28 ಮೂವ್ ಮಾಡಿದ್ದೆ.
ಆಯ್ತಾಯ್ತು, ನೀವು ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ಇನ್ನೊಂದ್ಸಲ ಫಾಲೋ ಅಪ್ ಮಾಡಿ.
ಸರಿ, ಇವತ್ತು ಮೂವ್ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು.
ಹಾ, ಸರ್ಗೆ ಕೊಟ್ಟಿದ್ದು ನಾನು.
ಅಲ್ಲಿದೆ ನೋಡಿ. 4 5
ಅವ್ರು
ಫ್ರೆಶ್
ಹೇಳಿದ್ರು
ಮ್ಯಾಟರ್
CM
ಕೊಡ್ಬೋದಲ್ಲ? ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಬಂದ್ಮೇಲೆ
ಬಂದ್ಮೇಲೆ ಕೊಡ್ಬೇಕು.
ಆಯ್ತು.
CMPನೂ ಬಂದ್ಮೇಲೆ ತಗೋತಾರಾ? CMPನೂ ಆಗ್ಲಿಕ್ಕೆ ಕೊಡ್ಲಾ?
ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು ಕೊಡ್ಲಾ?
ಕೊಡಿ ಸರ್, ಬಂದ್ಮೇಲೆ ಕೊಡಿ.
ನಮಸ್ಕಾರ ಸ್ವಾಮಿ. ಯಾರು ಇದು ಬುಕ್ ನಮ್ಮ ಟೇಬಲ್ ಮೇಲೆ ಬಂದಿತ್ತಲ್ಲ? ನಮ್ದಲ್ವಾ?
ಯಾಕೆ ಅವ್ರು ಬಂದಿಲ್ಲ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡಿ ಸರ್. ಅಲ್ಲ ಇದು CH ಸರ್ CH.
Retirement of petitioner counsel.
Ignition, LBP. Fresh, 14% comply ಆಯ್ತು. ಆಯ್ತು ಸರ್. ನೋಡಿ. Sir, I can go now or I have to wait for? Thank you, sir.
ನನ್ಗೊಂದು ಪ್ರಶ್ನೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ here. I asked the PMP.
Other matter is check for tomorrow.
My lordship, one matter,
Fresh matters you can.
my lordship,
ಕೊಡಿ ಸರ್ ಸೇಮ್.
for hearing on IA, my lordship, petitioner is a practicing advocate. There was a temporary electric
Please give it,
tomorrow, my lordship.
please give it.
2023 matter, please, my lord. Court commissioner was appointed by this honorable court. He has submitted a report to the.
You come in the normal course.
My
Yes,
lordship, my lordship, now electricity connection is disconnected, my lordship.
The reason.
no, yes,
My lordship, now electricity connection is disconnected.
Brahma.
Tomorrow, my lordship, please.
please give it.
My lord, old matter, for retirement of the petitioner counsel.
What is the urgency?
That's for the retirement.
Come. Yes.
We have been waiting.
Yes,
May I make 26 and 27, they have become infructuous, your lordships. They are voting matters. Elections have
concluded.
Filing a memo,
I'll file a memo.
20.
Let's kindly.
6 and 27.
You have wakalat in both the matters?
Please,
Huh?
please.
Put a paper, put a. Learned counsel for the petitioner, serial number 26 and 27. Learned counsel for the petitioner has filed a memo dated 5/6/2024 stating that the prayer made in the writ petition will become infectious since the petitioner was permitted to take part in the elections
Vote in the election.
by virtue of the interim orders. Therefore, the learned counsel submits that the petitioner may be permitted to withdraw the writ petition. Full stop. Next paragraph. The memo is taken on record, subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn. Huh? Huh? But our ಬರ್ಬೇಕಲ್ಲ.
Your lordship's leave my serial number 9, your lordship. In this matter, my court directed me to take notice on behalf of the municipal council, my lord, Srirangpatna. I have not yet received the wakalat and the instruction, your lordship. Can I request your lordship to have this?
Petitioner ಇಲ್ವಲ್ಲ sir, please wait.
Yes, the relief sought for by them are to.
ಹೌದು sir, petitioner ಇಲ್ಲ. How, what can I do? Now?
Time ಕೊಡಿ ಅಂತ.
Please wait. No.
Please.
Yes.
List number 1, fresh matter, serial number 1. Madhukar Deshpande.
Learned counsel, Shri T.P. Vivekananda is requested to take notice for both the respondents. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent.
Number 2, Abhijit MM.
The petition. I have challenged the annexure D, E, F, G, that the impugned communication forwarded by the respondent number 2 and 3 in favor of the respondent number 4 to 6 now. And also seeking for issue direction to the respondent number 2 to 6 to permit the petitioner to continue construction work in the revenue site. Brief facts of the case. The petitioner has purchased the site number 242 situated at survey number 52, 53, 56.
Originally Gram Panchayat.
A Gram Panchayat. Now, after lapse of 28 years, they have now tried to stop the construction works. The layout formed in the year 1997. Now they sent their men to stop the construction works in the said layout. In similar matter, this honorable court grant the interim order. Consider the annexure H. The layout owners already filed the writ petition. This honorable court grant the stay order against the said impugned.
Allah, you have not obtained a sanction plan?
Sanction plan obtained.
Huh?
Obtained.
Where is it?
Not, I have not produced. And also, fancy the annexure J, J1, J2. There are similar, the other site owners also approached this honorable court and obtained the similar orders. Against the BESCOM and also Gram Panchayat and also Taluk office and Taluk Panchayat and also the against the said jurisdiction police station. And see the latest order that the annexure J2 in writ petition number 10/802 of 2024. The similar, the other site owners also approached this honorable court and obtained the order. Yeah, annexure J2 in page number 52. See the annexure J1, there is also against the respondent number 6, there is the Westcom.
Lordship, I can see page 37, your lordship. Page 37.
Already,
Annexure
there
E.
is already an order passed by this court.
Annexure E. Why this order is not applicable to his?
ಅದು
It is not
KEB ಅದು.
KB, and also in LB matter also.
What is the prayer in this writ petition?
The permit me to continue her construction and also
Where is the sanction plan?
I have not produced the sanction plan.
Then without producing the sanction plan, how can?
No, they obtained the sanction plan.
Sir, why have you not produced it then?
I'll produce the letter.
And you are saying the similar orders have been passed. That is not the same as this one. That is the question of power
No,
supply.
consider
We
the
are not concerned with that one.
annexure H, there is the
Barkali. Annexure H.
the H, the layout owner already got the order against the entire order. Then the enter the impugned communication. There is the H, annexure H. Consider the observation given by the honorable court, the subject to the further consideration.
That again is a KLR matter.
Yes, madam.
We are not concerned with the land revenue entries, sir. We are concerned with the action sought to be taken by the Bangalore Development Authority for forming a layout without taking the approval.
And although
In terms of the
annexure J,
Karnataka
madam, kindly see the
Development
for a moment, annexure J, there is the ink page number 44, madam. The LBRS. The consider the observation given by the court, the petitioner are admittedly the owners of sites which are typically called revenue sites, and the impugned orders are for cancellation of the CASAs issued by the Bangalore North Taluk Panchayat consequent to the orders passed by the special Tahsildar Bangalore North Taluk. After the orders of this court in writ petition number 5943/2016, however, the special Tahsildar order is called in question in writ petition number 22050.
There is a confusion. We are not concerned with the land revenue entries now. You have made a prayer.
Yes, yes.
Direct them to permit you to construct, permit to continue.
Continue,
construction.
yes, madam.
And I am asking you, where is the sanction plan? You are not able to produce the sanction
No, no,
plan.
I will produce the sanction plan. Ready to produce the sanction plan.
Please produce, we'll see. Learned AGA takes notice for response number 1, 3,
And 6.
and 5.
Yes, 5 and 6.
Learned Counsel Shri K. Krishna is requested to take notice for respond number 2, BDA. Learned Counsel Shri M.S. Devraj is requested to take notice for respond number 4. ಈ ಬೆಸ್ಕಾಂ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
ದೇವರಾಜ್.
ಹಾ?
ದೇವರಾಜ್.
ಯಾರು?
ದೇವರಾಜ್ ಅಂತಿದ್ದಾರೆ ಸರ್.
ನಟರಾಜು ಟಿ. ಸಾರಿ.
ಆರ್ ದೇವರಾಜ್ ಅಂತ.
Learned Counsel Shri Devraj HV is requested to take notice for respond number 6. Learned Counsel for petitioner is directed to serve copies of the petition along with annexures on all the learned counsels for the respondents. Next para. Release this matter on 12th of June 2024 to enable the petitioner to produce a copy of the sanction plan and building license.
Till then, the intimate.
Serial number 3, Venkatesh R. Bhagat.
Petitioner is a meat vendor.
Huh?
Petitioner is a meat vendor. Responsible panchayat closed the shop with the live 31 birds inside and meat, everything, closed the shop on 13/5. Taken the last time your lordship I granted, very same matter, very same panchayat, very same fact matter. In writ petition number 14/152 of.
They have not completed the construction.
Yes, my lords. And
And this is another premises.
my, is a different person. He is running meat as well as the chicken shop. Closed with the live birds inside, all have died.
Which is that writ petition number
14/152 of 2024.
14/152
of 2024. There one
Learned
step
AGA.
we went ahead.
takes notice for respond number 1. Issue notice to respond number 2. Learned counsel for petitioner is directed to serve office of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that under similar circumstances, this court in WP number 14152 of 2024, by order dated
35/2020.
30/5/2024 has passed interim orders
Restraining the panchayat from not to interfere with the
restraining
yes.
the second respondent, Gram Panchayat, from interfering with
directed not to interfere with the
peaceful possession
business activity of the petitioner.
With the business activities of the petitioner.
Petitioner in the
in the
petition scheduled premises.
Petition scheduled premises.
Premises.
Stop. Learned counsel prays for similar order.
Yeah.
Stop.
And another one order, madam.
Correct.
In this case, they have locked the premises to break open the lock, madam.
Consequently, the second respondent, Gram Panchayat, is hereby directed not to interfere with the business of the petitioner in the petition schedule property. Full stop. It is also directed that the Panchayat Development Officer, Tuntikoppa Gram Panchayat, shall immediately remove the locks put on the premises, petition schedule shop, to enable the petitioner to carry on the business.
Yes.
Yes.
Hand delivery. Hand delivery.
Yes.
Number 4, Sandesh TV.
Or Lords. Lords, the exponent number 3, society election was held on 10/1/24, my lords. Kindly see the annexure A, my lords, page number 13. Lords, in the last serial number 14, ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧಿಸುವ ಅಭ್ಯರ್ಥಿಗಳು 2022-23ನೇ ಸಾಲಿನಲ್ಲಿ ಕನಿಷ್ಠ 180 ದಿನಗಳು ಹಾಲು ಸರಬರಾಜು ಮಾಡಿದ್ದು, ಅಂದ್ರೆ 1/4/22ರಿಂದ 31/3/23ರವರೆಗೆ ಅಂತವರು ಮಾತ್ರ ಎಲೆಕ್ಷನ್ಗೆ ಕಂಟೆಸ್ಟ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿ ದೇ ಹ್ಯಾವ್ ಇಶ್ಯೂಡ್ ಎ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. Then my lords, the society have announced the eligible voter list for the contest of the society. ಅದರಲ್ಲಿ 180 ದಿವಸದ ಯಾರು ಹಾಕಿದ್ದಾರೆ ಅವ್ರ ಅರ್ಹತೆ ಇರೋರು ಯಾರು ಅನ್ನೋದಿದೆ. ಅದು kindly see the my lords, the page number 18, serial number 224. The second petitioner 240 Ramesh.
224.
Please, page number 18. Saubhagyama Boregowda she is the second petitioner. Ramesh son of Boregowda is the first petitioner. Ultimately, my lords, the petitioners contest the election and won the election also. Now, my lords, the for a moment, kindly see the annexure E, page number 40, my lords. ಅದರಲ್ಲಿ 38 section 38 in ಬೈಲಾದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಾಗಿ ಆಯ್ಕೆಯಾಗಲು ಅರ್ಹತೆ, ಅದರಲ್ಲೂ ಕೂಡ ಸಬ್ ಕ್ಲಾಸ್ 8 ಅಲ್ಲಿ ಹೇಳುತ್ತೆ, ಆಕೆ ಹಿಂದಿನ ಸಹಕಾರಿ ವರ್ಷದಲ್ಲಿ ಕನಿಷ್ಠ 180 ದಿನವಾದರೂ ಸಂಘಕ್ಕೆ ಹಾಲನ್ನು ಮಾರಿರಬೇಕು. No doubt, my lords. Now the Assistant Registrar of Cooperative Societies have issued a show cause notice, annexure D, my lords, stating that you have violating the bylaw 38 subclass 8. Therefore, they have issued a show cause notice to the petitioner. Only,
So
alla, ಈಗ
how
already-
can you question a show cause notice before this court? Go give a reply.
alla, no doubt, my lords, we have given a reply also.
He can't
Definitely,
entertain a
because
writ
this is,
petition on a show cause notice, sir.
alla,
Statutory authorities has issued a notice. It is your duty to go give a reply, give the requisite information. And if he passes any adverse order, only then you will get a.
alla,
cause of
even
action.
though the third respondent CEO has given a report, ಆದ್ರೂ ಕೂಡ consider ಮಾಡ್ದೇನೆ they have issued a.
He has only issued a show cause notice.
Please,
It is your duty to give a reply.
ಅಲ್ಲ, of course, my lords, yeah, but ಏನಾಗತ್ತೆ ಅಂದ್ರೆ ಇಲ್ಲಿ political motivation ಇರೋದ್ರಿಂದ they have issued such a notice, my lords.
Learned AGA takes notice for response number 1 to 3. Notice to respond number 4 is not necessary for the following reasons. Next para. The petitioners who contend that in a recent election conducted on
Conducted on 10/1/24.
10/1/2024,
Please,
the petitioners were permitted to contest for the managing committee
please,
huh,
managing.
of the fourth respondent, Milk Producers Cooperative Society. And they have also succeeded in the elections. Full stop. However, the third respondent, Assistant Registrar of Cooperative Societies, Pandavpura Subdivision, has issued show cause notices at annexures D and D1, alleging that the petitioners have not complied with the requirement of law and the bylaws, namely, that they have not supplied milk for a minimum period of
180 days.
180 days. And therefore, they could not have been permitted to contest in the elections. Full stop. Next para. Learned AGA raises a preliminary objection that the petitioners are before this court challenging a show cause notice issued by a statutory authority. Stop. The learned AGA would therefore submit that the petitioner, the writ petition cannot be maintained. And on the other hand, the petitioners should be directed to give a reply to the show cause notice and proceed in accordance with law. Full stop. Next para. Upholding the objections raised by the learned AGA, the writ petition is dismissed while giving liberty to the petitioners to cause a reply to the impugned show cause notices. Full stop. At the same time, the third respondent, Assistant Registrar of Cooperative Societies, is also directed to consider the reply that would be given by the petitioners in a manner known to law, hear the petitioners and thereafter pass orders in accordance with law. Full stop. Ordered accordingly.
Fine. Srinivasa SB.
Petitioner. This matter, my lord, petitioner is the license holder for laying the advertisement board in the Sarjapura Road, my lord. He has given the permission in 2019, my lord. He is giving the tax payment, my lord. He has paid in last year also, my lord. In the meanwhile, my lord, in last occasion, my third respondent, he is one Rohit Kumar. He lays the flex board, my lord, in between the place of the petitioner, your lordship. Therefore, I have approached this honorable court, my lord. The order was passed in annexure L, my lord. the specific direction to the second and fourth respondent,
Annexure,
L, my lord, in the page number 39. Page number 39, annexure L. In that, my lord, in second para, my lord, that is the Shri Vijay Kumar Bhatt, the London Council for the third respondent is categorically admitted that her respondent has not put up the advertisement hoardings, and that insofar as the third respondent is concerned, the court could direct demolition. M. Pradeep, the London Council for the Sarjapura Gram Panchayat, from this court order 532 is categorically that general license is issued to the petitioner and no permission is granted for construction of any advertisement hoardings. If any permission is to be granted, it can only be by the fourth respondent. Shri Samant Naik, the learned High Court Government Feeder submits an instruction that even the fourth respondent has not granted any permission for the construction of advertisement hoarding for respect of the third respondent. Your Lordship. Thereafter, my lord, there is a direction, my lord, with both the second and fourth respondent taking the categorical stand that advertisement hoardings are without permission. The offending hoardings, only the offending hoardings must be removed, but there cannot be any positive direction in the writ petition because why the petition? Here, my lord, in the only the offending hoardings has to be removed, my lord. Here, my lord, without taking any inquiry.
operative portion of the order, it simply says
Yes, sir.
the competent authority shall take a decision
Yes, sir.
as to who has put up the advertisement hoardings,
Yes.
and if it is not in accordance with law, to
Yes.
remove it.
That is made in respect of the third respondent, Your Lordship.
Yes.
Or after due inquiry of the second and fourth respondent.
Yes.
But here, my lord, without making any inquiry, because I am the license holder, I have produced the license, my lord, I have taken the NOC from the PWD. Then I approach this honorable court, saying that, my lord, I have leave the places of 200 meters. In the between, my lord, he lay the
What is
foundation.
the prayer in the writ petition?
Prayer I have produced the copy of the writ petition copy also in annexure K. Prayer is.
ಅಲ್ಲಮ್ಮ, ಈ petition ಅಲ್ಲಿ ಏನು prayer ನಿಮ್ದು?
Prayer ಸ್ವಾಮಿ ನಮ್ದು ಎಲ್ಲದನ್ನು ಅವರು ಇಡೀ ಸರ್ಜಾಪುರ ರೋಡ್ ಅಲ್ಲಿ ಇರುವಂತದ್ದು ಎಲ್ಲದನ್ನು they have removed the PWD.
They have removed.
Yeah, only 3-4 ನ remove ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. That time I have approached the PWD. I have given the representation to the PWD. In our board also they have removed, my lord. We are requesting them to, this is our board and this is not a third respondent board. Some of the boards are led by the third respondent.
There is a direction, Lordship, to submit the report on or before 36/2024, Your Lordship. For having taken action in accordance with law.
ಅದಿನ್ನೂ ಟೈಮ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
Learned AGA takes notice for response number 1 and 4.
Pradeep.
Learned Counsel Shri M. Pradeep. Is requested to take notice for response number 2. Sarjapur Gram Panchayat.
Three is the private one.
Issue notice to respond number 3. Learned Counsel for petitioners is directed to serve copies of the petition along with annexures on the learned AGA and learned counsel for respond number 2. We'll stop. Release this matter on 10th of June, Monday. Yes.
Number 6. Prakash T. Abba.
Lord, the second respondent Gram Panchayat Lord issued a license as per the permission, Lord, granted at ink page 19 for installation of the advertisement holding, Lord. They have sanctioned 8 numbers of advertisement holding to be put, Lord, from Karmalaram Gate to Muttanallur Cross. Accordingly, Lord, by spending a sum of rupees 80 lakhs, Lord, I have erected all the thing in accordance with the permissions granted. Lord, on completion of the period, Lord, I have applied for renewal of the license. There is a provision for renewal. At that time, Lord, the manual application as according to the prescribed format is required to be submitted. Accordingly, I have submitted in accordance with the format. Now, they have issued an endorsement as per Annexure A in page 14. Saying that they have, there is a direction for them to not to receive the application and documents manually, as the online submissions is being introduced. But in that they say, ಆದರೆ in page 14, Annex A, the last 4 line. ಆದರೆ ನಾಮಫಲಕಗಳಿಗೆ ಸಾಮಾನ್ಯ ಲೈಸೆನ್ಸ್ ನೀಡಲು ಪಂಚತಂತ್ರ 2 ನಲ್ಲಿ ಅವಕಾಶ ಕಲ್ಪಿಸದ ಕಾರಣ ತಮ್ಮ ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡಲಾಗಿದೆ. They are not receiving my application even online also, because there is a direction. And now the Panchayat.
AGA takes notice for response number 1 and 3. Issue emergent notice to response number 2. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA. Full stop. The petitioner is also permitted to take out hand summons to respond number 2. Full stop. Release this matter.
One submission.
12th of June.
Annexure G is the resolution passed by the Panchayat saying that my license has expired, therefore I am unauthorized holder of the holding, so it should be removed.
Till the next date of hearing, the second respondent is directed. Yaru, Annexure G, yar model.
Annexure G is the Gram Panchayat. It has directed the PWD
Directed not to take any precipitative action against the hoardings put up by the petitioner.
Great. Lord, I may be permitted, because tomorrow they wanted to remove. Grateful.
The petitioner. Number 7. Was in this matter, the petitioner was working as a bank manager. He was dismissed from service. Thereafter, he has challenged that order of dismissal, and the same was set aside by the second respondent by an order dated 30/12/2022, which I have produced at Annexure C. So I am before Lordship seeking implementation of the order because it's been 1.5 years since the order is implemented. It's not been challenged, and all the service benefits are yet to be given to me, Lords, as per the order. The order is on page 40.
Annexure B is an order passed by the tribunal.
Lords, Annexure B.
Annexure B.
Please, my Lords, Annexure B is an order passed by the tribunal. That was when the third respondent had challenged an interim order of the stay against the order of dismissal. Thereafter, the matter was heard fully and then fully disposed on 30th December 2022. And that order says that it's been partly allowed and not.
Learned AGA takes notice for response number 1 and 2. Issue notice to respond number 3. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA. So, release this matter on 19th of June.
Preliminary, of mandamus, Your Lordship, the term of the board has expired on 8/11/2021. But till today, special officer was appointed, and thereafter, special officer has appointed returning officer also who had annexure L on 18/5/2022. But till today, no election has been held. I have sought for mandamus to hold the election, and also since the term has expired in the year 2020-21, in view of the COVID, there was an amendment to bylaw which the society has brought into. So the bylaw 7A was introduced, wherein it was mandated that the members should attend. There should be a minimum transaction of one transaction in 2 years. So to be eligible to participate in the election. But since there was COVID, at that point of time itself, we had requested, since there is no provision under the Act as provided under Cooperative Societies Act, we had requested the authorities to exempt that period and permit all the members to participate.
Lord, my
That is the request
instructions
we
are
are-
election is already been completed.
ಹೇಳ್ದ?
ಆಗೋಗಿದೆ. And managing committee board has also been constituted. If it is passed over, I will take instructions and I will submit.
No, we'll have it day after tomorrow. You can get it.
Please.
Learned HCGP. Takes notice for response number one
Two bit
and
ಎಲ್ಲರಿಗೂ.
three to one,
Three and four.
Release this matter. On 7th of June, day after tomorrow.
Please.
Huh? Come on, at the request of the learned HCG. Yes.
CM9, Ajit PB.
I appear for respondent.
I appear for petition. My lords, petitioner was granted with a site, my lords, and as a Vasati
For
Yojana.
2 weeks' time, my lord, I have not yet filed wakalat or received the instruction. Kindly have this matter after 2 weeks. In the meantime, I will file wakalat and as well as the objection also.
Town municipality.
Srirangapatna.
Ah,
I have called them, I have sent the details, my lord, but not yet received the wakalat. And I think I was told that the case worker has been transferred, therefore it was not given to me. In the morning, they told.
at the request of learned counsel Sri H.E. Shivaram, appearing for the respondent. Release this matter.
After 2 weeks, my lord, in the meantime, I will receive instruction and if possible, I will file objection also. So that matter itself.
ಏನು, what is the
Seeking alternative allotment of site, your lordship. Their case is that their previously site was allotted, it was portion was not given.
19th of June?
Yes.
Great.
Let appear for petition. Lord, in this case, I am seeking for quashing of annexure H, that is the trade license to run the health care center in the name of sixth respondent in the premises of the seventh respondent, who is a doctor, THO, government doctor.
Learned AGA takes notice for response number 1 and 2.
One, my lord, 1 to 5.
Chikballapur CMC garadira ನೋಡಿ.
Devaraj.
ದೇವರಾಜ್
Devaraj.
ಇಲ್ಲ.
Okay.
ಇದಾರಾ? AGA 1, 2, 4 and 5. Learned counsel Sri MS Devraju is requested to take notice for respond number 3. Issue notice to respond number 6. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA and learned counsel Sri MS Devraj.
Lord, there is respondent number 7 also.
Take notice.
6 and 7, yes.
6 yaru?
6 is the license holder, my lord. 7 is the doctor, yes.
6 and 7. Issue notice to response number 6 and 7. Yes.
CM 11.
Date may be fixed, my lord.
Yes.
7, Manoj Jason.
Because the respondents are the immediate neighbors of the petitioner in the northern portion. Because the petitioners are assailing the illegal constructions of the respondent number 1 and 2 without leaving any setback. And they have put on more than 4+1 floor.
Any
on a
directions for
30, 40 dimension.
No directions. Tell him.
My lord, I just filed the wakalat day before yesterday, my lord. In fact, going by the document J.
Learned counsel for the respondent BBMP is directed to secure instructions from the 5th respondent AEE, ward number 129 as to the action taken on the complaint made by the petitioner.
At page 49, they have issued a show cause
In respect of the illegal construction being made by response number 1 and 2. Full stop. Release this matter on 12th of June.
till such time interim production.
Without even getting information, how can we stop them, sir?
For the petitioner, my lord, tell the CMP to appointment of arbitrator, my lord. Any retired judge can be appointed in this.
Huh?
matter. Any retired session judge may be appointed, my lord. The claim amount is 44 lakhs. The bank matter, my lord.
The CMP, first paragraph, ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಮಾಡಿ ನಮ್ಮ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ. ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್, although notices are served on the respondents, comma, there is no representation. Full stop. ಅಂತ ಮಿಕ್ಕಿದೆಲ್ಲ ಸೇಮ್ ಫಾರ್ಮ್ಯಾಟ್. What is the claim amount?
44 lakhs, my lord.
Huh?
44 ಲಕ್ಷ. 44 lakhs.
Lakhs.
44 lakhs.
You want High Court judge to be appointed or
Sessions,
district judge?
district judge.
The IS until retired district judge.
Much of it.
Serial number 13.
For the petition under 11(6), my lord, the petitioner, my lord, is a technological company, my lord, providing services to businesses. Therefore, my lord, respondent approach.
Objection?
I have an objection, my lord, because proceedings have already been initiated.
Lord, may
under
I,
the
may I
MSA.
please answer?
No, I'm asking him if he's got any objection. Yes.
Proceedings have already been initiated under the MSME Act, and arbitration proceedings are pending before the Delhi International Arbitration Center. Now they are seeking to withdraw those proceedings and file these present arbitration. That is my objection. Number two is also that the mandate under the Act has not been followed, under the arbitration agreement has not been followed, and therefore this petition is also not maintained.
Yes.
My lord, it is true that we approached, my lord, the MSME council in Delhi. My lord, we later realized that the MSME provisions are not applicable to us. And therefore, my lord, we withdrew that proceedings. Kindly see, my lord, the reply only, in the reply, my lord, kindly see my letter, my lord, to the arbitration center in Delhi. Kindly see page 76, sorry. In fact, your lordship see from 74, dated 28th April 2022. My lord, your lordships may note, my lord, this was at a time when the arbitrator was not even appointed. We've written to the arbitration center in Delhi. Page 74 of the reply.
What annexure?
This is annexure R5
R5.
of the reply, my lord.
My statement of objections, my lord.
Oh.
They rely on my statement of objections.
In fact, there they object that the MSME Act is not applicable to us because the MSME registration is after the claim. And therefore, I promptly withdrew those proceedings. And after withdrawing the proceedings, I issue a fresh notice. Well, thereafter, I've come before your lordships.
Yes.
Kindly see the reply at page 74.
Yes.
We are the counsel for the claimant so-and-so in the arbitration matter between so-and-so. On 19/1/2022, we sent an email to the registered email of DISC with a copy of the statement of claim on behalf of the claimant along with receipt of so-and-so. Present mail is sent in the same mail trail for your reference. Due to unforeseen circumstances, the claimant has decided not to pursue the claim before the DISC. We, on behalf of the claimant, are withdrawing the claim filed with the email dated so-and-so. Please note, proceedings are at very initial stage and the arbitrator is yet to be appointed, reserving the right and liberty to proceed in accordance with law. Copy of so-and-so. Therefore, we request your good office to allow us to withdraw the claim filed on so-and-so. Please note the withdrawal is without prejudice to claimant's right to pursue other legal remedies available to them. And this is in 2022. The matter stands withdrawn. Thereafter, my lord, my notice of arbitration, my lord, is dated 11/7/2022.
Such a liberty is also reserved.
Please,
No orders passed.
No orders passed this is in February 2022, my lord. From there on, there has been no progress. And in July of 2022, I sent the present notice for arbitration and initiate, my lord, the present proceedings before your lordships.
That is annexure R.
The arbitration notice, my lord, is K. Annexure K at page 66 of the.
They have not produced along with in the statement, along with the statement of objections.
They have not.
No, their arbitration notice, they have produced it with their petition. my lord.
Page 66. I'm so sorry to be troubling your lordships. No, this is dated 11th July. After the withdrawal, I have made a fresh notice for arbitration.
Yes.
Page 66, annexure K.
Did they give any reply?
They gave a reply, same objection, my lord, that the matter is pending before the Delhi Arbitration Center. We withdrawn those proceedings.
Although you have stated in the notice.
Please.
That you have withdrawn the.
Please.
They still say no, it is pending.
Pending, please.
Yes.
No, the fact is the matter is still pending before the Delhi
How
International.
can you say that, sir?
Because the withdrawal, no order has been passed on the withdrawal, my lord. My counterclaim is also pending there. And I have filed a counterclaim, my lord. My counterclaim is at page number 40. I have filed a counterclaim for 1,36 lakhs and that is pending, but they file an application without stating that the MSMED Act is not applicable. They say due to unforeseen circumstances. My lord, page 40 is my counterclaim, my lord, annexure R4.
Why have you not secured an order at the hands of the
Well, because
MSME?
the arbitrator was not appointed, this is the administrative wing of the arbitration center. We write to them that we will not proceed with the claim and they leave it at that. There is no arbitrator appointed.
Yes.
But even that, there has to be formal withdrawal because the problem is, my lord, my counterclaim is pending and my counterclaim.
Ultimately, the issue has to be decided.
Precisely.
Not taken up there. They are before this court. What is your difficulty?
Two positions here, my lord. One, when my counterclaim one is pending there, which can be entertained under the MSME.
Not being pursued because they have clearly stated we are withdrawing it. Because the MSME has no jurisdiction.
That is not this. That is precisely my point. That is not their claim that the MSMED does not have MSCFC
You
does
yourself
not
have
have.
raised an objection.
I have not raised any objection on that point. Kindly see the email, my lord, page 74. They do not say that the MSMED Act, they do not fall within the jurisdiction of the MSMED Act. Kindly see the first line. Due to unforeseen circumstances, as the claimant, page 75, the first line. Due to unforeseen circumstances, as the claimant has decided not to pursue the claim before the DIAC, we on behalf of the claimant are withdrawing the claim filed. So all the DIAC is saying, I'll pass orders, kindly clarify that you want to withdraw unconditionally. That is what, kindly look at the next line, the next page, annexure R6. Annexure R6, page 76. I submitted my objections via an email dated 12/5, my lord.
Yes.
In response to the application filed by the claimant's counsel, I state that if the claimant's withdrawal is unconditional, without reserving any liberty, the opposite party has no objection to the same, it can be allowed. This is my contention. Now, next page, my lord. In the rejoinder also they've produced the email from the DIAC, wherein they are saying that this is the objection. My lord, they have filed a rejoinder. The claimant has, a petitioner has filed a rejoinder. Page 20 of that rejoinder, the DIAC is asking, just please clarify on this position and we'll pass orders. All I'm asking is let those orders be passed, let the matter be withdrawn at the DIAC formally, and we can come before this honorable court. Two proceedings cannot be continued simultaneously is my position.
Page 22.
Of my lord, 20 of the rejoinder that the petitioner has filed. I don't have a copy of this. Page 20 of the rejoinder dated.
Lord, if need be, we'll make a formal statement before your lordships also, my lord, that we will not pursue those proceedings, assuming, my lord, that those proceedings are still pending. It's an administrative wing, my lord. Obviously, no such judicial orders could have been passed.
So what happened, my lord, questions of limitation, all of those aspects arise. I have filing a counterclaim there. Now, there's a doctrine of election of remedies.
Decided by the honorable arbitrator then. All
My lord, page 20, my lord. 18th March 2023, the DIAC writes to the claimant, that is the petitioner. This is with reference to the caption subject matter. We have received an email from the counsel for the respondent stating that the respondent has no objection in the withdrawal of the petition if it is unconditional. And if the claimant wishes to withdraw with liberty and to proceed in accordance with law, the same is being opposed. The email dated 16/7/2022 received from the respondent is being forwarded to you for your reference and the needful. You are therefore required to give clarification about the same so that the matter may proceed accordingly. This they are not, they are refusing to give.
No, what do you mean unconditional?
They have sought for withdrawal, my lord, their application, kindly look at their application. They have said, we'll withdraw it and we'll proceed with any other remedies that are available with us. Which that such an withdrawal with liberty is not contemplated because the remedy under the MSMED Act, which also contemplates arbitration. So all I said is let arbitration continue. Before the DI, I have filed my counterclaim. Limitation also started there. Now let us have it adjudicated before the arbitration center there. That is all I said.
Why do you want to withdraw? Why did you want to withdraw from that?
My lord, the very reason, my lord, because we realized after they pointed out that MSME Act, it is my mistake, my lord, MSME Act was not applicable, is what we realized much later, my lord, that the MSME registration comes after my claim. Therefore, the MSME Act was not applicable and therefore we withdrew. My lord, the withdrawal, my lord, cannot be unconditional. I cannot forgo my claim.
I'm sorry, I don't find that in my objections, but nevertheless, if that is the, let them at least state that much.
Your lordships may
The
take
proceedings will become, will
I'll make a
automatically get
statement here
dismissed.
before your lordships, my lord, if need be. Lordships may record my statement.
My lord, respectfully, this court cannot record the statement to the DIAC. That is, I don't. Can they make that statement before the DIAC and the matter be closed
we
before
made
the
that
DIAC is
statement.
what I'm stating. That statement is not forthcoming in any of the withdrawal applications. My lord, even Order 23 states that if they make a statement that there is a technical defect, then they can withdraw the proceedings, reserving liberty. Here it is a technical defect. Let them withdraw those proceedings and be present before this honorable court.
The difficulty is this: once we go to the arbitration center in Delhi, they say you have to withdraw it unconditionally, else we will not give consent to withdraw it. Well, I am only withdrawing with liberty to come before your lordship.
Problem is you have not stated in clear words,
Please.
that you have realized that this application is not maintainable here for so and so reason.
Please.
You have not stated.
We have not
That is the
stated so.
problem.
We have not stated so, my lord, but that is my remedy. I have withdrawn and I'm coming before your lordships.
No order has been passed. That is the problem.
No, because it's my lord, it's on the administrative side. No judicial officer has been my lord, appointed. It's on the administrative side from 2022 till now. Let my learned friend say any proceedings have taken place, my lord. There have been no proceedings from 2022 till now. There have been 2 full years. The arbitration center, we've written to them and they've left the matter as is.
As a matter of fact, after the filing of the CMP, I moved this CMP for the matter to be listed. So they have not moved. I will not, my only request is let them withdraw those formally and I'm ready to participate in any proceedings.
But you can't say unconditionally and foreclose all their other options.
I concede. Well, as I said, Order 23, if there's a technical defect, let them make that statement before the arbitration center, let them withdraw formally, and then it will come before this honorable. This proceedings can be kept pending till then, my lord. I have no.
You please get an order from them.
Well, this is the administrative.
We will record your submissions. Please. You please place the same orders before them.
Please.
And get a order permitting you to withdraw the proceedings.
Please.
The only objection that is sought to be raised at the hands of the respondent to this civil miscellaneous petition is that the petitioner had already approached the Delhi International Arbitration Center seeking appointment of an arbitrator under the provisions of the MSME Act.
Seeking adjudication of disputes, my lord. Appointment that was in pursuance to MSFC. MSCFC in the refer again.
Appointment of
Seeking appointment on seeking adjudication of the disputes. And the respondent has submitted its reply.
And counterclaim.
Huh?
And counterclaim.
And counterclaim. Full stop. Nevertheless, it is the contention of the petitioner that the petitioner Where is that, the document where you sought for withdrawing?
On page 74, my lord, of the reply, of the counter, sorry, statement of,
Statement of
reply.
objection.
ಏನಿದೆ? That the petitioner has communicated to the coordinator of the Delhi International Arbitration Center on 28th of April 2022, as could be found at lecture R5, filed along with the statement of objections of the respondent, stating that the claimant has decided not to pursue the claim before the DIAC, and the claimant are withdrawing the claim A request was therefore made by the petitioner to permit the petitioner to withdraw the claim without prejudice to the claimant's right to pursue other legal remedies available to them. Full stop. Learned counsel for the respondent therefore submits that even the petitioner is not able to produce any documents to show that the claim petition has been withdrawn. Full stop. On the other hand, a communication was thereafter made by the coordinator of the DIAC to the petitioner, bringing to its notice the objection raised by the respondent that if the claimant wishes to withdraw with liberty to proceed in accordance with law, then the same will be opposed by the respondent. And on the other hand, if the petitioner seeks to withdraw the petition unconditionally, the respondent will have no objection. Full stop. Next para. At this juncture, learned counsel for the petitioner submits that the petitioner has made it known to the respondent the reason why the petitioner is seeking to withdraw claim petition filed before the DIAC, namely that the registration of
The petitioner MSME registration comes after the claim.
the petitioner's MSME registration happened after the claim, and therefore the petitioner will have no jurisdiction to approach the authorities under the provisions of the MSME Act. Full stop. Next para. Having regard to the submissions made by the learned counsels, this court is of the considered opinion that the petitioner is required to get a formal order at the hands of the DIAC permitting it to withdraw the petition, irrespective of the objections sought to be raised at the hands of the respondent. Full stop. A copy of this order may be furnished by the petitioner before the coordinator of the DIAC to enable the coordinator to formally permit the petitioner to withdraw the claim. Full stop. Next para. The learned counsel for petitioner is permitted to move a memo after securing orders at the hands of the DIAC.
Please.
Yes.
So great.
Serial number 14. Premnath NT.
Pay for petitioner,
Yes,
the appointment of arbitration.
yes.
Huh?
You know?
Complete copy, not served on.
ಕಂಪ್ಲೀಟ್ ಕಾಪಿನೇ ಕೊಟ್ಟು ಆದ್ಮೇಲೆನೆ ಪ್ರೋಸೆಸ್ ಕಳ್ಸೋದು.
ಆಯ್ತು, ಕೊಟ್ಬಿಡಿ, ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. We will list it next week. Please give a copy.
ಸರಿ, ಮಂಡೇ
Learned counsel for the petitioners is requested to serve the complete set of the petition along with annexures on the learned counsel for the respondent. Full stop. Release this matter on 12th of June.
12th ಬೇಡ, ಮಂಡೇ.
Huh?
ಮಂಡೇ
Monday ಆಗಲ್ಲ.
11th ಇರೋ lordship.
We'll have it on 13th if you want.
Yes, sir.
13th.
15. C. Shankar Reddy.
15, I appear for the respondent minutes. We have given a proposal for settlement. Basically, they are asking for the specific performance. So I'm a builder. So I'm saying that if you want a refund, in the sense, how much refund you want?
Refund ಪರವಾಗಿಲ್ಲ sir. ಯಾಕಂದ್ರೆ like complete.
This court cannot say you agree for this or you don't agree for that. It is between, it is left to you. If you come before this court saying, yes, we have settled, fine. Otherwise, I'll proceed to consider.
Please, the matter may be listed next week.
ಈಗ ಕೋರ್ಟ್ ಮುಂದೆ ಈಗ ಹೇಳ್ತಾ ಇರೋದು ಯಾವ್ದು ಸೆಟ್ಲ್ಮೆಂಟ್ ಇಲ್ಲ sir.
So basically, we have terminated the agreement, Manoj. I spoke to his.
Entire amount ಫೈಲ್ ಮಾಡಿದ್ವು ನಾವು.
This matter may be listed next week, Manoj. By then, we will agree.
At the request of the learned counsel for the respondent, release this matter on 12th of June.
Grateful.
To enable the parties to arrive at a settlement. Yes.
Yeah, appear for the petitioner, my lord. And this is a petition seeking appointment of an arbitrator. We are the contractor. We were supposed to construct dwelling houses under the Pradhan Yojana scheme. Due to various delays committed by the respondent, the contract has been terminated due to efflux of time. And I have incurred a lot of expenses.
Municipal Corporation, CMC, Gadag.
Gadagali, we were supposed to construct some 3,600 dwelling units.
Hmm.
So ಅವರು they delayed in giving us the land, drawings and soil test ಆಗ್ಬೇಕಿತ್ತು, ಅದ್ರ delay ಮಾಡಿದ್ದಾರೆ. Then contract was terminated due to efflux of time. ಅದನ್ನ extend ಕೂಡ ಮಾಡಿಲ್ಲ in spite of our request. So we had to undertake few extra additional works also. ಅದ್ರದ್ದು payment ಮಾಡಿಲ್ಲ. There were variation works. So the notice of dispute was issued by us. That is at page 70, my lords. Annexure D. There has been no reply to this notice of dispute. We have claims of over 100 crores against them.
What happened to the emergent notice taken up after the orders were passed on 22nd of November 2023?
We have paid the PF and all. ಅದು issue ಆಗಿದೆ, court ಇಂದ ಹೋಗಿದೆ. If it has not been served, I may be permitted to take hand summons.
You please take out handsome.
Yes, my lord. A
Because
date may
the
be fixed next week.
municipality, the petitioner is permitted to take out hand summons to the respondent.
Yes, my lord. Next week on date code.
Release this matter. ಆಗುತ್ತಾ 12th ಒಳಗಡೆ
Yes, my lord.
on 12th of June.
Much of.
Number 17. Nischal Dev BR.
Bearing for the petitioner, my lord. The dispute has arisen between the parties regarding a contract dated 28/5/2018. It was regarding construction of dwelling units in Bhadravati town, in the slums of the Bhadravati town. And the respondent was supposed to hand over the sites to the petitioner, but they have made substantial delays in handing over the sites. We have issued several letters to the respondent and they have remained unresponsive. We have even issued a letter to the principal secretary of the Karnataka Housing Department and we have received no response till date, my lord. We have issued a notice of arbitration on 8/1/2024 and we have still not received any response. So we are filing the present petition, my lord.
Where is the arbitration clause?
Arbitration clause in page number 70, my lord.
70.
70.
70.
Clause 4, my lord.
Yes. When did you issue the arbitration notice?
On 8 January 2024. Page number 192.
190.
2.
They didn't give a reply.
No, no, my lord.
Issue notice to the respondent. The petitioner is also permitted to take out hand summons.
Number 18.
Same parties, my lord.
Yes, same mode.
Number 19. Aditya D.
This is a petition for appointment of arbitrator. It was a tender for Tumkur Smart City, which is the
Notice has been
respondent.
issued.
Hello?
Notice has been issued.
Notice has been issued. They appeared last two occasions, they've appeared, my lord. They sought an adjournment in the last occasion last. Tumkur Smart City. Smart City.
Matter is called out. There is no representation for the respondent.
I'm sorry.
Yes.
Only one submission. Kindly come to page number 82. With due respect to this honorable court, my lord, clause 6, my lord, arbitration.
Yes.
the last para, my lord,
Hmm.
last 3 lines. The sole arbitrator shall be appointed by agreement between the parties. Failing such agreement by the appointing authority, any one of the organization as per the list enclosed at annexure E. Annexure E.
That annexure E.
Next
Annexure E
page,
is a-
madam.
is a
That is
main-
annexure. List of organization.
Next page.
Next page. Page number 83. E, annexure. List of organization who are considered as appointing authority for appointing of arbitrators. They have to write the letters to them for appointment of. This is the procedure.
My
Whether
lord, I agree. Kindly have a look at annexure Q, my lord, which is the arbitration notice. I have appointed an arbitrator from the list of arbitrators that is mentioned in the arbitration clause, and I've asked them for their consent.
Arbitration clause.
Arbitration clause, page number 82, man.
Hmm?
Page number 82,
Huh?
it talks about arbitration.
Yes.
And there is a list of arbitrators as per this particular annexure of the institute. I have named one of the arbitrators and asked for their consent. In fact, they have refused the appointment of.
Where do you get that? In clause A,
Yes.
there is no mention of any list of arbitrators.
My lord, the
Other
list
than
is part of annexure E, my lord. I can produce the list. I can produce the list. My lord.
No. There should be provision.
My lord,
6A.
yes, my lord, it should be read with 6A, should be read with 6E, 6E, which is the list of organizations that my learned friend has pointed out.
Yes.
I have chosen International Center for Alternative Disputes Resolution in my notice, my lord. 2E, it can be seen in.
No. You are not permitted to directly take the list and.
No. My lord,
not what is provided
the
here.
rule, I can produce the IC ADR rules as well before this honorable court. The rule says that I suggest a particular arbitrator and seek a consent of the other side. And if such arbitrator is not appointed, I can go before the appropriate authority. And I've come before this court under section 11.
You will have to go before the International Center for Alternative Disputes Resolution.
That I will produce the rules, my lord. I may be permitted because the rules says otherwise.
Learned counsel for the respondent points out to the arbitration clause. Tender notification tender document ಅಲ್ಲಿ ಇದೆಯಾ ಇದೆಲ್ಲ?
Part of tender document.
It is part of tender document.
Contained in
Conditions of contract.
tender.
Conditions of contract ಅಂತ. Page number 60 ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Conditions of contract. Page number 60, condition of contract.
Contained in the conditions of contract.
Clause 24.
In the tender document.
In the tender.
Namely, clause. ಅದೇನ್ರಿ ಈ ಕಡೆ 6 ಅಂತ ಇದೆ, ಈ ಕಡೆ 24 ಅಂತಿದೆ.
ಎರಡಿದೆ ಸರ್. ಅದು 6 ಅಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಆದ್ರೆ ಏನು ಅಂತ ಹೇಳಿದರೆ, ಅದರಲ್ಲಿ ಆರ್ಬಿಟ್ರೇಷನ್ ಕ್ಲಾಸ್ 24 ಅಂತ ಹೇಳಿದೆ. 24 ಅಲ್ಲಿ ಇಲ್ಲಿ ಬರುತ್ತೆ. Clause 24 is disputation. Clause 24, page number 46. Oh, sorry. Page number 69. 68. Page number 68 ಅಲ್ಲಿ ಪ್ರೊಸೀಜರ್ ಫಾರ್ ರೆಸೊಲ್ಯೂಷನ್ ಆಫ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಈ ನಂಬರಿಂಗ್ ಯಾಕೆ ಈ ತರ ಆಗಿದೆ? ಈ ಕಡೆ 6 ಅಂತ ಕೊಡ್ತಾರೆ, ಆ ಕಡೆ 24.
ಹಾ ಅದೇ 24 ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಪೇಜ್ ನಂಬರ್ 68. 68 ಅಲ್ಲಿ 24 ಪ್ರೊಸೀಜರ್ ಫಾರ್ ರೆಸೊಲ್ಯೂಷನ್ ಆಫ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಅಂತ ಇದೆ. ಅದಲ್ಲಿ ದಿ ಕಾಂಟ್ರಾಕ್ಟರ್ ಇಸ್ ನಾಟ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಹೇಳಿ ಅದು 24 ಪ್ಲೀಸ್ ರೆಫರ್ ಟು 6 ಅಂತ.
ಏನ್ ಹೇಳ್ದಮ್ಮ? Clause 24. Read with subclause 6 bracket A to E.
Please.
And submits that the sole arbitrator is required to be appointed by agreement between the parties, comma, plus semicolon, failing such agreement, comma, by the appointing authority. Bracket ali, any one of the organizations as per list enclosed in annexure at bracket ali E, close brackets, which means it is for the appointing authority.
Hello, yes.
To appoint.
The section 11 also.
This is not the appointing authority. The appointing authority will be that
Please.
No,
one of those.
The rules, I'll produce the rules, my lord. The High Court can't sit in the shoes of appointing authority when it has been rejected outrightly by the respondent. That is why the intent of section 11 is that is what I wanted to point out, my lord. I'll produce that rules, my lord. When it read, there'll be clarity.
That has not happened.
Please.
See, after going before this authority, if the respondent declines or one of the party declines, then they'll say, okay, you go before the court.
No, at the threshold itself,
But
they have declined.
what you have done is, where they have declined?
Annexure R, my lord.
In your notice, you are simply name the arbitrators.
No, I have also marked the institute, my lord.
Sir, you have to go before them.
No, I agree, my lord. Let me produce the rules before this court and I'll bow down if there is otherwise, ma'am.
The learned counsel therefore submits that having regard to the arbitration notice issued by the petitioner, comma, it is clear that they have not complied with the requirements of the arbitration clause. Full stop. Next paragraph. Learned counsel for the petitioner, however, seeks for a short accommodation to produce
the rules of
a copy of the rules of the International Center for Alternative Disputes Resolution, bracket India.
I see India. Yes, India.
Full stop. Next paragraph. Release this matter on 12th of June.
Much of it.
Please.
On compliance for second time, the Ramesh.
Petitioner one.
I'm for you participated in the election.
Yes, ma'am.
Entry matter ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ.
So the election has been conducted.
Yes, ma'am.
Learned AGA submits that the prayer in the writ petition has become infructuous since no interim orders were passed in favor of the petitioner. And on the other hand, the elections have been held. Elections to the respondent society. Your respondent?
Nelligere society.
Your respondent? Seventh respond number 7 society. Full stop. Next para. Learned counsel for the petitioner does not dispute the fact that the elections have been held. Full stop. Next para. Consequently, the writ petition stands disposed of as the prayer made in the writ petition has become infructuous.
Orders, serial number 21.
I appear for the petitioners in this matter.
Not filling of objections on one.
My lords, on the last occasion, my lords, I filed a memo for withdrawing the name of different respondent number 7, my lords, who is deceased. Respondents have not been appearing, my lords, for the past 1 year. Last date, they were asked to file their objections finally. The arbitration clause in the JDR, my lords, is in page number 36, paragraph number 10.7.
There is a learned counsel appearing for them.
Please.
Response number 1
Please,
to 7.
there is a counsel appeal. They stopped appearing,
But it has been recorded that
please, it's been recorded, my lords.
they
His name
take
is,
time to file objection.
my lords, the last time, my lords, Justice Krishna Kumar, my lords.
Yes. Learned counsel for response number 1 to 6
Please, my lords, 1 to 6.
takes time to file objections.
He already sought, my lords, a long time back. The last time, my lords, learned counsel for respondent seeks time to file objections.
Yes,
Release list finally.
correct.
But he did not appear, my lords.
How can it be recorded like this then? Matters called over. There is no representation for the respondents. Full stop. On the previous occasion, it has been recorded that the learned counsel for the respondents sought for some time to file objections to the submission made by the learned counsel for petitioner for deletion of respondent number 7.
And for the main petition.
Huh?
And for the main petition also, he thought, the objection is still pending, my lords. They have not filed any objection for the CMP.
And to file objections to the petition. Full stop. Next para. Release this matter on 12th of June 2024. Stop. If there is no representation for the respondents of the next date of hearing, this court will proceed to hear the learned counsel for petitioner and pass orders.
And for petitioner.
Yes.
Matter is listed for uncomprehensive office objection, my lord, on serial number 8 only. How the respondent 3 and 4 are made parties in CMP.
Yes.
When those are not parties in the agreement.
Yes.
My lord, 3 and 4 are companies, first respondent company directors. First company, first respondent company ಇದೆ. ಅದು directors. So ಹಾಗಾಗಿ ಅವರನ್ನ ಪಾರ್ಟಿ ಮಾಡಲಾಗಿದೆ.
ಎಲ್ಲಾರ್ನು ಮಾಡಕ್ ಬರೋದಿಲ್ರಿ.
My lord.
It will be represented by one managing director.
ಹೌದು my lord, but ಅವರು ಲಯಬಿಲಿಟಿ ಆಗ್ತಾರೆ. ಸೊ ಮೆಮೊರಂಡಮ್ ಮಾಡ್ಕೊಂಡಿರೋ ಪ್ರಕಾರ MOU ಪ್ರಕಾರ ಅವರು ಸುಕಡ
All
ಲಯಬಿಲಿಟಿ
that is
ಆಗ್ತಾರೆ.
not going to be considered here, sir. Here we are only concerned of appointing of the arbitrator.
Yes.
Whether they are liable or of them are liable or issue, that will be decided by the arbitrator.
Yes,
Objection that is raised is that you have entered into an agreement with respondent number 1.
Yes, ma'am.
Why are you showing the names of all the directors?
But
here it is not necessary for appointment of an arbitrator.
Please.
So restrict it to the managing director.
Please.
That's the end of it.
Please.
Please comply with the office objections.
Please.
A week's time is granted at the request of
Any date
learned
may be
counsel
given.
for petitioners for compliance with the office objection.
Next week, any date may be given, my lord.
Release this matter on 12th of June.
Please, ma'am.
Prasad Fayaz.
Appear for the respondent 3 and 4.
This matter is likely to be settled, my lord. Almost.
2018 matter.
Almost.
What is the issue?
This is the husband bought a loan from the bank. He expired.
Yes.
No, that some loan has been taken and the main borrower died. His wife
is a judgment debtor.
1
Now the
lakh rupees
question-
have paid, my
now
lord, and the
they have paid the
45,000,
Huh?
45,000 we have pending. 1 lakh is already been paid. So the money is being, now the money is being deducted from the guarantor. I being a principal borrower, my husband being a principal borrower, I paid 1 lakh rupees principal amount. So another 2 months time may kindly be given, my lord, by then the matter will be closed. Report settlement.
Shall I record it?
Yes, ma'am.
Huh?
Yes, ma'am.
Learned counsel for the petitioners submits that if 2 months' time is given, the petitioners will,
No, the guarantor, my lord, guarantor is paying now. The understanding, my lord, we are supposed to pay the principal amount to the bank. We paid 1 lakh rupees.
the petitioners also includes the guarantor, isn't it?
Yes, ma'am. No, they are the respondents here.
Huh?
They are the respondent.
Guarantor.
Guarantors are respondent. What happened, my lord, my.
And how can you make a submission on behalf of the respondent?
I am for the bank, my lords.
Guarantor also is a respondent, he is saying.
Yes, they are responding.
Yes, the bank is
How
getting.
can you make a submission on behalf of another respondent? It is your duty to return the money. I can't record it that the guarantor will be paying.
My lord,
I will
then-
record it that the petitioners will pay the outstanding amount along with the interest and close it.
Settle the matter is,
Yes.
time may be.
You may get the money from the guarantor and pay it, but I can't record it like that unless the guarantor himself is here and says, yes, I will pay it.
Writ petition, my lord, is that I am not liable to make the payment. That was the writ petition, my lord,
How can you say, sir?
because the,
How can you say the guarantor is liable and I am not, the principal borrower is not
my
liable?
husband is the principal borrower, my lord.
Yes,
They
that
are-
is an understanding between
Yes.
you and the guarantor. We
The
can't record it here.
No, my husband has got properties, my lord. They can attach that property. That is, I filed an affidavit also. I filed RTCs also.
Sir, you are saying it's only about 25,000 or 30,000.
45,000.
Down.
Yes.
Please close it down. ಏನ್ ಹೇಳ್ದಮ್ಮ? The petitioners by themselves or through the guarantor will clear the entire outstanding amount along with the accrued interest. Full stop. Next para. Placing the submission of the learned counsel for petitioners on record. Release this matter. On 6th of August, 2024. Yes.
So 24 Suresh K.
Excuse me, for the petitioner, my lord. The government had granted 7 acres of land in Agra village, 728, my lord, to be, that land has to be converted to sites, and those sites has to be allotted to the depressed class who are residing in the Bangalore city, in the BBMP limits, my lord. And have just I draw your lordship attention at page number 93, where the government has allotted the land. 93, my lord. And 94, ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. Shall I read it, my lord? 93, 94 ಅಲ್ಲಿದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ RD 375 LGB 2014 ಬೆಂಗಳೂರು ದಿನಾಂಕ 27/3/2015 ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇನ್ನೊಂದು ವಿಶೇಷ ಪ್ರಕರಣವೆಂದು ಪರಿಗಣಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ನಿಯಮಗಳ 1966 ನಿಯಮ 108I ರಲ್ಲಿ ನಿಬಂಧನೆಗಳನ್ನು ಸಡಿಲಿಸಿ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ದಾಸನಪುರ ಹೋಬಳಿ ಲಕ್ಷ್ಮೀಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 24ರಲ್ಲಿ ಎಕರೆ ಜಮೀನು ಅಂಡ್ ನದರ್ ಲ್ಯಾಂಡ್ ಇಸ್ ದೇರ್. ಹಾಗೂ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ಅಗರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 28ರಲ್ಲಿ 7 ಎಕರೆ 7 ಎಕರೆ 7.05 ಎಕರೆ ಒಟ್ಟು 29 totally. All these lands have been granted by the government so that the residents who are residing in the BBMP limits, they have to be identified and the sites have been made and they should be allotted to the beneficiaries. On that noble intentions, the government has allotted this land, my lord. This land has been transferred to the commissioner. The commissioner in turn has transferred this property to the BBMP commissioner. I have furnished the RTCs at page number 99. ಈಗ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ 1900 in 2015 these lands have been transferred. Until now, the commissioner has not taken any action to allot these lands to the depressed class. So recently what I made, my lord, in last year 2023, I made a representative to the commissioner to allot these lands to the depressed class, my lord. And I made a representation at page number 63. 65, my lord. Page number 65. Annexure A. To the Commissioner of Brihat Bengaluru Mahanagar.
For appearing for the BBMP.
Yes, my
Yes.
lord, may I request, my lord, matters for mandamus, my lord, there are 355 petitioners, my lord. Let them give their representation individually, my lord. We will consider each and every cases. And I will also call for everybody in the BBMP limits. As my learned senior said, it is for the entire BBMP limits, my lord. I will call
here,
for
what
the
happened
entire
is-
BBMP limits, my lord. I will take a decision once. And I will allot a land, my lord. The RA is also present. Under his instructions, my lord, I will.
Lord, this
If that has
property
been-
doesn't falls in the BBMP limits at all, my lord. It is away from the BBMP. That is what the difficulty is with the BBMP officials. ಈ ಜಮೀನ್ ಬಂದ್ಬಿಟ್ಟು BBMP ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರ್ತಕ್ಕಂಥದ್ದಲ್ಲ. BBMP ವ್ಯಾಪ್ತಿಗಿಂತ ಹೊರಗೆ ಬರ್ತಕ್ಕಂಥ ಜಮೀನ್ ಇದು. ಸೊ ಅದರಿಂದ ಹೌದು ಸರ್ವೆ ನಂಬರ್ 20 ಅಗರ ನೈಸ್ ರೋಡ್ ಇಂದ ಹೊರಗೆ ಇರ್ತಕ್ಕಂಥದ್ದು.
ಯಾವ್ದು ಅನೆಕ್ಷರ್ ಈ ಕೆಂಗೇರಿ RTC ಹಾಕಿದೀರಾ?
ಕೆಂಗೇರಿ ಅದು ಅವ್ರ ಸರ್ಕಾರದವರು ಈ 7 ಎಕರೆ ಜಮೀನ ಬಂದ್ಬಿಟ್ಟು BBMP ಕಮಿಷನರ್ಗೆ ಆದೇಶ ಮಾಡಿ BBMP ಕಮಿಷನರ್ ಅವರು ಬೆಂಗಳೂರು ಮಹಾನಗರದಲ್ಲಿರ್ತಕ್ಕಂಥ ನಿವಾಸಿಗಳು ಯಾರು ನಿವಾಸಿ ಇಲ್ಲದಂತ
ಅಲ್ರಿ ಯು ಆರ್ ಸೇಯಿಂಗ್ ಯಾವ್ದೋ ಬೇರೆ ಕಡೆ ಇರೋದು ಅಗರ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಬಟ್ ವಾಟ್ ಇಸ್ ದಿಸ್ ಅನೆಕ್ಷರ್ ಈ ದೆನ್?
He is the same land.
This is Agra village is the RTC, my lord, which I have furnished.
ಕೆಂಗೇರಿ 3 ಅಂತ ಇದೆಯಲ್ರಿ?
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ ಕೆಂಗೇರಿ 3 ಬಂದ್ಬಿಟ್ಟು ಹೋಬಳಿ ಅದು. ಗ್ರಾಮ ಬಂದ್ಬಿಟ್ಟು ಅಗರ. ಕೆಂಗೇರಿ ಹೋಬಳಿ ಬಂದ್ಬಿಟ್ಟು ಕೆಂಗೇರಿ ಹೋಬಳಿ.
ಅಗರ is within the limits of.
No, it's not in the Agra, it's not in the.
It is not within the limits of BBM.
It's outside.
Agara is not within.
ಇಲ್ಲಿರೋದು ಇದ್ರಲ್ಲಿ HSR ಲೇಔಟ್.
ಅಲ್ಲಲ್ಲ
ಕೆಂಗೇರಿ ಆಗ.
ಈ ಕೆಂಗೇರಿ
ಕೆಂಗೇರಿ
ರಸ್ತೆ ಇದೆ.
ಈ ಕಡೆಗ
ಕನಕಪುರ ರಸ್ತೆ. ಕನಕಪುರ ರಸ್ತೆಯಲ್ಲಿ ನೈಸ್ ರೋಡ್ ಆದ ನಂತರನೇ ಒಂದು ಗ್ರಾಮ ಬರುತ್ತೆ ಅಗ್ರ ಅಂತ.
But that land is been allotted to us, my lord. Now that is the difficulty which we were also facing.
That land has been allotted to the BBMP commissioner.
ಓದಿದ್ರಲ್ಲ ನೀವು ಆರ್ಡರ್?
ಹೌದು ಸರ್.
ಯಾರಿಗೆ ಅದು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿರೋದು?
ಸರ್ಕಾರ ಬಂದ್ಬಿಟ್ಟು ಕಮಿಷನರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವ ಕಮಿಷನರ್?
Urban commissioner, and subsequently the urban commissioners transfer the land to the Tahsildar.
Page 93.
It is at page number 98, my lord.
ನಿವೇಶನ ನೀಡಲು ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಇವರಿಗೆ ಉಚಿತವಾಗಿ ಈ ಕೆಳಕಂಡ ಷರತ್ತು ನಿಬಂಧನೆಗಳು ಒಳಪಟ್ಟು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದಾರಲ್ಲ ಆರ್ಡರ್.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರು ಅದನ್ನ he has to identify the beneficiaries and allot the sites.
Correct.
And he has not exercised that power, my lord.
ನೀವೇನ್ ಹೇಳ್ತಾ ಇರೋದು?
My lord, what I am saying, my lord, we will consider all the 351 applications. With all the other applications, we'll also have to call for the other applications and see if they are also eligible. In 6 months' time, my lord, we will see that it will be allotted. We will try allotting to all these lands to all the members.
With a noble cause, 2015 in the land ಕಾಪಾಡ್ಕೊಂಡು ಬರೋದೇ ಕಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದೆ. ಒತ್ತುವರಿ ಆಗ್ತಾನೆ ಇದೆ ಪ್ರತಿ ದಿವಸ.
Problem ಅಂದ್ರೆ ಅದು ಒತ್ತಿಗೆ ಆಗಿತ್ತು. ಆಮೇಲೆ ನಾವು we tried dispossessing all of them. Now it is free of all encumbrances. Now, my lord, it is free. Now we will take 6 months, my lord. We will identify all those, allot the land to them.
Lord, may I make a submission, my lord? Let the committee
only
be
this
formed.
355,
A nodal officer may be appointed, and all this representation who have given to the commissioner may be made to a nodal officer. Let the nodal officer identify the criteria, and if they are really eligible, their sites can be allotted to them, my lord. Because the officers also there, when we had gone and personally met the officials, they find it very difficult. They said, oh, we don't have any powers to identify this residents. So the application will be called out. Because even when we went and met the ARO, the Kengeri ARO, he also felt the same thing.
Purple. This writ petition has been filed by 355 persons. Seeking directions to the third respondent, Commissioner, Brihat Bengaluru Mahanagar Palike, to form a layout and distribute sites to eligible persons, residential sites to eligible persons in terms of the government order bearing number RD 375 LGB 2014, Bengaluru dated 27/3/2015 at annexure B. Full stop. Next para. Learned counsel for the petitioners submits that it is clear from a plain reading of the government order that the state government thought it fit to relax the rules governing allotment of lands in terms of Rule 108I of the Karnataka Land Grant Rules, 1966, to an extent of 29.07 acres.
Lord, that is totally, my lord. This petition is pertaining only to survey number 28, 7 acres, 5 quintals. ಕೆಳಗಿದೆ ಅದು ಪೂರ್ತಿ ಎಲ್ಲ 3 ಕಡೆ ಅವರು ಲ್ಯಾಂಡ್ ನ ಗ್ರಾಂಟ್ ಮಾಡಿರೋದು ಹೇಳಿದ್ದಾರೆ 29 ಎಕರೆ 7 ಗುಂಟೆ. I am before this honorable court with respect to only one particular survey number, that is survey number 28 of Agra Grama. Agra village, survey number 28. Survey number 28 of Agra village to extent of 7 acres 5
7
acres.
acres 5 ಗುಂಟೆ. ಏನ್ ಹೇಳ್ದೆ? ಅಲ್ಲ ಅದು ಇನ್ನೊಂದ್ಸರಿ ಓದಿ. For in terms of for the purpose of formation of residential layouts and allotment of residential sites to eligible persons, at 3 different places around, in and around Bangalore city. So, one such land identified and directed to be allotted is survey number 28 of Agra village, Kengeri Hobli, Bangalore South Taluk, extent 7.05 acres. Full stop. The responsibility was entrusted with the Brihat Bengaluru Mahanagar Palike. and the land was granted free of cost to the Palike so that the layout is formed and sites are distributed in terms of the conditions imposed in the government order.
Exclusively for scheduled castes and scheduled tribes.
ಅದಕ್ಕೆ ರೀ, in terms of the conditions imposed there.
That like.
Full stop. Nevertheless, comma, it is the contention of the petitioners that although the government order was issued during the month of March 2015, comma, till date, action has not been taken by the BBMP to form a layout and distribute the sites to the eligible persons in terms of the conditions imposed in the government order. Full stop. The petitioners are therefore before this court seeking a writ of mandamus directing the commissioner, comma, BBMP to take action in terms of the government order. Full stop. Next para. Learned counsel for the respondent BBMP, however, submits that
Lord, on instructions.
submits that the land in question is outside the jurisdiction of the Brihat Bengaluru Mahanagar Palike. Full stop. Nevertheless, comma, since it has been specifically directed in the government order itself that the land is allotted free of cost to BBMP, comma, it would become the responsibility of the Chief Commissioner, BBMP, to
Identify.
form the layout and sites, comma, identify the eligible persons and allot the same. Full stop. However, it was found that many portions of the lands were unauthorizedly occupied by some persons, and action has been taken to clear the unauthorized encroachment, comma, with the help of the revenue authorities. Full stop. Learned counsel further submits that if a reasonable time is given to the Chief Commissioner, comma, the Chief Commissioner will proceed to form the layout and residential sites and call for applications, comma, scrutinize them and take a decision for identification of the eligible persons to be allotted with the residential sites. Full stop. Next para. In the considered opinion of this court, comma, although the responsibility should be taken by the Chief Commissioner, comma, BBMP, comma, nevertheless, having regard to the large extent of claim for allotment that may arise, comma, the Chief Commissioner may appoint
This one. A nodal officer.
a special commissioner or any other responsible officer to take the responsibility of
Allotting.
calling for applications, comma, scrutinizing them and identifying the beneficiaries for allotment of the sites. Full stop. The next para. Consequently, the writ petition stands disposed of with a specific direction to the Chief Commissioner, comma, BBMP to ensure formation of a layout in 7.05 guntas, 05 acres of land in survey number 28 of Agara village, Kengeri Hobli, Bangalore South Taluk. Carving out residential sites along with civic communities and to appoint a competent officer to oversee the scrutiny of the applications for allotment of the sites, identify the beneficiaries and thereafter allot the sites. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 6 months.
6 months, madam. Forming of layout ಆಗಿಲ್ಲ ಅಂತ 12 months ಕೊಟ್ರೆ ನಾನು
Within a period of 1 year
1 year.
from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
May I request also on the instructions, they are also present in the court. Their instructions, our instructions in the objections file ಆಗಿಲ್ಲ.
The officers are before the.
Officers are before this.
They are what?
ಇದ್ರಲ್ಲಿ objections file ಮಾಡೋದು ಏನು ಇಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ instructions
They are
only
only seeking, they are only seeking.
taking a mandamus.
ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ಏನಿಲ್ಲ.
Much.
25. Raj Babu. against.
Election petitioner contesting and voting right minutes. Writ petition became infectious minutes.
They have participated,
Please participate.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದೇನ್ರಿ. ಸೇಮ್ ಆರ್ಡರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 25, 26. ಸೇಮ್ ಆರ್ಡರ್.
Please.
Number 25, 26, 26, 27 ಬೆಳಿಗ್ಗೆ ಪಾಸ್ ಮಾಡಿದ್ದೀನಿ. ಇದು 25.
Number 28.
The order passed on.
Now Kumar.
15/12/83 making. Order sheet dated 15/12/83 making. 15/12/2023. Earlier council will respond 5 to 7. Submit that the respond number 15 is seeking to make use of the plot reserved for allotment of homeless persons under the Ashraya scheme for the purpose of construction of a temple. If that is so, it is for respond number 2 to take necessary action forthwith so that no construction of temple or operation of temple takes place in a plot coming under Ashraya scheme and the plot is only for residential purpose. A on-site report as regards action taken. Next.
ಏನು ಪ್ರಾಬ್ಲಮ್ ಏನು ಹೇಳಿ?
ಇದ್ರಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ 1 to 14, 15 is a trust. ಅವರು ಟೆಂಪಲ್ ಕಟ್ತೀವಿ ಅಂತ ಹೇಳ್ಕೊಂಡು 2023 ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂತಾರೆ. ಮಾಡಿ 80 to 110 feet. Then the petitioners, other petitioners, they encroach upon some land. They are residing some other place. They have given the addresses also where they are residing. In the cost title address ಕೊಡ್ತಾರೆ. ಅಲ್ಲಿ ರಿಸೈಡ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲಿ ಸುಮ್ಮನೆ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದಾಗ ಮಾಡ್ತಾರೆ. Preventing the authorities from farming the layout, farming the sites and farming the layout. Forcing them. See, selection has to be made by the Gram Sabha. We do not have any power. Site has to be formed. For the formation site, these people are not allowing.
Talkadu
How?
village.
If I may
So,
kindly,
my statement of objection, can you look into me?
5 minutes, my lord, if I may kindly brief what the factual circumstances are.
Yes.
My lord, as far as the submission of petition number 15 is concerned, there's a specific order of this honorable court by Honorable Mr. Justice Sunil Dutt Yadav, my lord. We have said specifically that the petition be dismissed as against petitioner number 15. So the petitioner number 15 is out of picture. That is the temple trust. Now, my lord, what had happened is there is a certain extent of land of about 3 acres and odd, which is there near Talkad, which was allotted for Ashraya scheme, wherein Nirgatigirge land ಅನ್ನು allot ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ. From 2014, the petitioners number 1 to 14 have been making representations to the government. In 2014, what happens, my lord? The deputy commissioner, on the instructions of the government, issues a direction to the assistant commissioner, saying that you please go conduct the survey there
and see who are all the people living there, identify them, furnish a report. That report was furnished. Subsequent to that, what happens is the Tahsildar also goes there, and then he also sees that these people are there, makes note of it, and a report is furnished. Thereafter, they say that this land which is there does not fall under our domain. It is being handed over to the village panchayat. So let the village panchayat conduct a meeting, call for a meeting, and identify, because this is a fact-finding situation. So identify all these people who have been residing there and see whether they are eligible or ineligible to get a site under the Ashraya scheme. This was the situation. From past 8 years, for whatever the reason best known to them, the panchayat is deliberately not conducting the meeting. Even as of latest situation, even the government, even the respondent number 2, even today, says that, look, it is for the panchayat to conduct the meeting, let them conduct the meeting. The issue is fairly simple. Now they are saying about the temple and trying to confuse things here. Yes, there is a temple. They were trying to put up construction. There was an interim order saying that you should not put up construction of the temple. By that time, the temple was already constructed and in place. The petitioner number 1 to 14 have nothing to do with the temple. They are not the trustees of the temple. They are nobody with the temple. We have no connection with the temple. Then what happened was, my lord, in the previous occasion, it was discussed as to whether they submitted that they are trying to conduct the consecration ceremony. And consecration ceremony prana pratishtapane ella mabididare, etc., etc. Our submission was that prana pratishtapane maduvanta situation illa ali. It is not that kind of deity which requires all that consecration ceremony. So what happened was the Honorable Court directed the Deputy Commissioner, respondent number 2, to go conduct one survey and see if, first thing, whether the temple is in place. Second thing, whether the consecration ceremony, etc., have been happened or not. This was the situation. Now, my lord, all that the Gram Panchayat has to do, and in that purview of the matter, an interim order also was granted saying that you are not supposed to dispossess these people because it's in the Ashraya scheme.
Report submit madra.
Adan madila. Adu ivaga respondent number 2 has to furnish that report before this Honorable Court, which is not done.
In terms of which order?
In terms of that previous order, which my learned friend is quoting.
May I submit, my lord? One side he has left out. He is encroaching upon the land. He's petitioners, they are encroachers. Only encroach madi.
They are saying they are residing there.
Illa. They are
saying that yes, we are residing there.
Not residing. ಯಾಕಂದ್ರೆ ಅವರು ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಅವರ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. They are residing those addresses. Address ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲ. ಒಂದು ನಂತರ
ಏನು ನೀವು ಲೇಔಟ್ ಫಾರ್ಮ್ ಮಾಡಬೇಕು.
ಲೇಔಟ್ ಫಾರ್ಮ್ ಮಾಡಬೇಕು.
ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಅದನ್ನ ಅಲಾಟ್ ಮಾಡಬೇಕು.
ಹೌದು, ಸೈಟ್ ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇವರು ಅಲ್ಲಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ. ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ರಿಮೂವ್ ಮಾಡಿದ್ರೆ ವಿ ಕ್ಯಾನ್ ಫಾರ್ಮ್ ಸರ್. ಟೆಂಪಲ್
ಅದಕ್ಕೆ ಏನ್ ಆಕ್ಷನ್ ತಗೋಬೇಕು ತಗೊಳ್ಳಿ.
ಅದಕ್ಕೆ
ಆಲ್ಸೋ ಪ್ರಿಪೇರ್ಡ್ ಟು
ಅದಕ್ಕೆ ಮೈ ಲಾರ್ಡ್ ಇಸ್ ಅಬ್ಯೂಸ್ ಆಫ್ ಪ್ರೋಸೆಸ್ ಕೋರ್ಟ್. ಐ ಸಬ್ಮಿಟ್ ಮೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಿಸ್ ಮೈ ಕೈಂಡ್ ಲುಕ್ ಇಂಟು. ಅಬ್ಯೂಸ್ ಯಾಕಂದ್ರೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ತಗೊಂಡು ದಟ್ ಐ ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ ಇನ್ this one called 13/10/2023 granted interim order. May read from second paragraph itself. Land bearing survey number 94/1 measuring 1 acre 20 guntas and para 2 measuring 1 acre 21 guntas acquired for
1310 1310
statement of objection. Statement of objection. Second para. Land bearing survey number 94/1 measuring 1 acre 20 guntas and survey number 94/2 by 1 acre 21 acquired for formation of sites, distribution of those sites to the landless poor people under Ashraya scheme. Petitioners have put up huts and huts-like structures in portion of this land so as to create right in them. They are not residing in this land. They are residing in the addresses mentioned in the cost title. These petitions and others are preventing the authorities from formation of sites. The petitioner 21/9/2023 requested for 1 month's time and they agreed to remove authorized sites. On writing will put here, number 3 there. It appears the petitioner 1 to 4 filed this petition at the instance of petition number 15. Admele, my lord, this one court on 13/10/2023 granted interim order that it responded not to dispose the petitioner. Petition number 15, taking advantage of this interim order, continued the construction and installed idle on 15/11/2023.
This one 24/11/23 directed petition number 15 to not to carry on any construction subject property. On 15/12/20 directed Deputy Commissioner Mysore take action forthwith so that no construction temple or operation take place in the plot coming under hostage scheme and plot be used only for the same purpose. That is to file on-spot report regards so and so. If it has not complied with this direction, so and so. It is the duty of Gram Panchayat to identify and select most eligible person for this one side. The list prepared by Gram Sabha will be approved by executive officer. ಇದು Gram Sabha has to approve, then procedure ಇರ್ತದೆ. Now, the petitioner is seeking, my lord, for allotment of it. Unless the petitioner, para 6, unless the petitioner vacate and remove the enclosure, it is not possible to form the sites, roads, and not possible to provide basic facilities. Gram Sabha has to select the eligible benefits of allotment site. After if the petitioners are eligible, they will select for the Gram Sabha. Since the power is conferred on Gram Sabha to select petitioners, it is not possible for otherwise to give any assurance to the petitioners. Number 15 cannot encroach upon the land reserve for so and so. Now what happened? This repetition filed by another advocate. Then when all this pointed out, these people after NVC files on petition 1 to 14, the temple, unless the temple is evicted, the temple like structure is the temple, and these people remove that, it is not possible to form the sites. Then it will form, sites will form, road will form. ಆಗ ಸೈಟ್ಗಳು ಎಷ್ಟೆಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಎಲ್ಲ ಗೊತ್ತಾಗ್ತದೆ, ಎಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ನಮ್ಗೆ ಏನ್ ಮಾಡೋದು, ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. Under the act, my lord, it is only.
What do you say? Lord, that 2 points I will just cover this man. Firstly, he is going back to the same question of the temple.
If it is constructed.
If it is constructed, my lord, may kindly take the objection of respondent number 4. ಒಂದೇ ಶೀಟ್ ಇದೆ, ಅದನ್ನ ಓದ್ಬಿಟ್ರೆ ಫುಲ್ ಹಿಸ್ಟ್ರಿ ಕೇಸ್ ಗೊತ್ತಾಗೋದು. ನಾನು ಯಾವ ಅನೆಕ್ಷರು ನಾನು ರೆಫರ್ ಮಾಡೋದಿಲ್ಲ.
ಯಾವುದು?
R4 ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 ಫೈಲ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
4 ಯಾರು?
ತಹಸೀಲ್ದಾರ್. R4 ಅಬ್ಜೆಕ್ಷನ್ ಇರುತ್ತಾನೆ.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ.
ರಿಪೋರ್ಟ್
ರಿಪೋರ್ಟ್ಗಳು ಹಾಕ್ತಾರೆ.
ತಹಸೀಲ್ದಾರ್ ಫೈಲ್ ಮಾಡೋ ರಿಪೋರ್ಟ್ ಅದೊಂದನ್ನು ನೋಡ್ಬಿಡಿ. ಗೌರವಾನ್ವಿತ ನ್ಯಾಯ, ಇದು 1 ಪೇಜ್ ಇದೆ. ಐ ವಿಲ್ ರೀಡ್ ಇಟ್ ಔಟ್ ಸೊ ದಟ್ ಇಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್. ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸುವುದೇನೆಂದರೆ ಟಿ ನರಸೀಪುರ ತಾಲೂಕು ತಲಕಾಡು ಹೋಬಳಿ ಒಡೆಯಾಂಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 94/1 ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 94/2 ರಲ್ಲಿ 1 ಎಕರೆ 21 ಗುಂಟೆ ಜಮೀನು, ಒಟ್ಟು 3 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನನ್ನು ವಸತಿ ರಹಿತ ಫಲಾನುಭವಿಗಳಿಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ಉದ್ದೇಶದಿಂದ ಸರ್ಕಾರದ ಪರವಾಗಿ ನಂಬರ್ so and so 1863 of 93/94 ದಿನಾಂಕ 14/2/1994 ರಂದು ಕ್ರಯವಾಗಿದ್ದು ಅದರಂತೆ MR ನಂಬರ್ so and so ರಂತೆ ಖಾತೆಯಾಗಿರುತ್ತದೆ ಹಾಗೂ RTC ಕಾಲಮ್ 9 ರಲ್ಲಿ ದಾಖಲು ಮಾಡಲಾಗಿದೆ. ನಂತರ ದಿನಾಂಕ 26/7/2016 ರಂದು ಸದರಿ ಒಡೆಯಾಂಡಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಮೈಸೂರವರು ಭೇಟಿ ನೀಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ನಿರ್ಗತಿಕರು, ವಿಕಲಚೇತನರು, ಮಹಿಳೆಯರು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 94/1 94/2 ರಲ್ಲಿ ಗುಡಿಸಲುಗಳನ್ನು ಕಟ್ಟಿಕೊಂಡು ವಾಸಿಸುತ್ತಿರುವುದನ್ನು ಗಮನಿಸಿ. 1 moment pause here, my lord. We are not encroachers as he submits. We have been there already from that time. From before 2014 also, when this land was allotted to the government, from that time onwards, we have been there, and from 2014, we started saying that please recognize our right and allot this site under the Ashraya scheme. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಒಟ್ಟು 3 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನನ್ನು ಆಶ್ರಯ ಯೋಜನೆಯಡಿ ಕಾಯ್ದಿರಿಸಿದ್ದರೂ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡದೆ ಇರುವುದನ್ನು ಗುರುತಿಸಿ, ಯಾರು ಗುರುತಿಸಿದ್ದು? ಇದನ್ನ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳೇ ಗುರುತಿಸಿರೋದು. ಮಾಡದೆ ಇರುವುದನ್ನು ಗುರುತಿಸಿ ತಕ್ಷಣ ಗ್ರಾಮ ಸಭೆಯನ್ನು ಕರೆದು ಆಯ್ಕೆ ಪಟ್ಟಿಯೊಂದಿಗೆ ಹಕ್ಕುಪತ್ರ ವಿತರಿಸಲು ಸೂಕ್ತ ನಿರ್ದೇಶನ ನೀಡುವಂತೆ ಅಂದಿನ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ತಾಲೂಕು ಪಂಚಾಯತಿ ಟಿ ನರಸೀಪುರ ರವರಿಗೆ ದಿನಾಂಕ 3/9/2016 ರಂದು ಪತ್ರ ಸಂಖ್ಯೆ so and so ಅರೆ ಸರ್ಕಾರಿ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತು ಕಡತ ಪುಟ so and so ಗಳನ್ನು ಕಳಿಸುತ್ತಾರೆ. Annexure 1, they have filed that letter. ಸದರಿ ಅರೆ ಸರ್ಕಾರಿ ಪತ್ರಕ್ಕೆ ಪ್ರತಿಕ್ರಿಯೆಯಾಗಿ ದಿನಾಂಕ 18/11/2016 ರಂದು ಅಂದಿನ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ತಲಕಾಡು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳಿಗೆ ಪತ್ರ ಸಂಖ್ಯೆ so and so ರಂತೆ ತುರ್ತಾಗಿ ಗ್ರಾಮ ಸಭೆಯಲ್ಲಿ ಅರ್ಹ ಫಲಾನುಭವಿಗಳನ್ನು ಗುರುತಿಸಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸುವಂತೆ ಸೂಚಿಸಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ದಿನಾಂಕ 12/12/2016 ರಂದು ತಲಕಾಡು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳಿಗೆ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ 12/12/2016 ರಂತೆ ಮತ್ತೊಂದು ನೆನಪೋಲೆಯನ್ನು ಬರೆದಿರುತ್ತಾರೆ. ಆದರೆ ತಲಕಾಡು ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಿಂದ ಈ ತಹಲ್ವರೆಗೂ ಯಾವುದೇ ಕ್ರಮ ವಹಿಸಿರುವುದಿಲ್ಲ. ಆದರೆ ಪ್ರಸ್ತುತ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 94/1 ರಲ್ಲಿ ಮತ್ತು 94/2 ರಲ್ಲಿ ಜಮೀನು ಒಟ್ಟು 3 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ಅಂದಾಜು ಅವ್ಯವಸ್ಥಿತವಾಗಿ ನಿರ್ಮಾಣಗೊಂಡಿರುವ 40 ಗುಡಿಸಲುಗಳು ಹಾಗೂ 2 ಮನೆಗಳು ಮತ್ತು ಒಂದು ಸಿದ್ದಪ್ಪಾಜಿ ಮಂಟೇಸ್ವಾಮಿ ದೊಡ್ಡಮ್ಮ ತಾಯಿ ಎಂಬ ಹೆಸರಿನ ಚಿಕ್ಕ ದೇವಸ್ಥಾನವಿರುತ್ತದೆ. ನಾಟ್ ಲೈಕ್ as though some huge temple is constructed. ಒಂದು ಚಿಕ್ಕದೊಂದು ದೇವಸ್ಥಾನ ಒಂದು ಅವ್ರು ಕಟ್ಕೊಂಡಿದ್ದಾರೆ, ಅದೆಲ್ಲ ಇದೆ. ಅದು ಸದರಿ ಗುಡಿಸಲುಗಳು ಮನೆಗಳಿಗೆ ಯಾವುದೇ ಮೂಲಭೂತ ಕಲ್ಪಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಎಂದು ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿಗಳು ಮತ್ತು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ತಲಕಾಡುರವರು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾ. ಆದ್ದರಿಂದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸುವುದೇನೆಂದ್ರೆ, ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಆಶ್ರಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಟಿ ನರಸೀಪುರ ತಾಲೂಕು ತಲಕಾಡು ಹೋಬಳಿ ವಡೆಯಾಂಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಜಮೀನು ಒಟ್ಟು 3 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನನ್ನು ಈಗಾಗಲೇ ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಹಾಗೂ ಪಂಚಾಯತ್ ರಾಜ್ ಇಲಾಖೆಗೆ ವರ್ಗಾಯಿಸಲಾಗಿದ್ದು, ಅಲ್ಲಿನ ಅಧಿಕಾರಿಗಳು ಸದರಿ ನಿವೇಶನ ಹಂಚಿಕೆ ವಿಚಾರದಲ್ಲಿ ಸೂಕ್ತ ಕ್ರಮ ವಹಿಸಬೇಕಾಗಿರುತ್ತದೆ. And this is the stance of the DC also. All that we are saying is, now they are saying because of the interim order, I am unable to do it. The court has said that you cannot evict them just like that. Let them be there. You collect the records, conduct the meeting, collect the records. You see if they are eligible or not. If you say that they are ineligible, you give it in writing for so and so reason you are ineligible and ask them to move out. For those who are eligible, you ask them to stay there, you form a layout and you do whatever you want.
Will you form the layout?
Now, as far as farming of the layout is concerned, my lord, all that they have to, it is not some constructed houses with RCC roofing, etc. ಗುಡಿಸಲುಗಳಲ್ಲಿ ಇದ್ದಾರೆ. ಇವ್ರು ಏನ್ ಮಾಡ್ಬೇಕಾಗಿದೆ, ಸರ್ವೆ ಇಷ್ಟು ಮಾಡ್ಬಿಟ್ಟು ಆ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಹಂಚಿಕೆ ಮಾಡೋದಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ಟು ಫಾರ್ಮ್ ಎ ಲೇಔಟ್ ಪ್ಲಾನ್. ಆ ಪ್ಲಾನ್ ಮಾಡೋದಕ್ಕೆ ಇವ್ರೆಲ್ಲಿರ್ಬಾರ್ದು ಅವ್ರೆಲ್ಲಿರ್ಬಾರ್ದು ಅನ್ನೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಅಫ್ಕೋರ್ಸ್, ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ಡಿಮಾರ್ಕೇಟಿಂಗ್ ದಿ ಲ್ಯಾಂಡ್, ಅಲ್ಟಿಮೇಟ್ಲಿ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ದಿ ಪ್ಲಾನ್.
Possible, sir. Not possible.
And that plan, my lord, it has already been done.
Who have to go out, they will form a layout, they will take action only in accordance with law.
No, my lord.
ಗ್ರಾಮ ಸಭಾದಲ್ಲಿ they will have to prepare a list. ಈಗಾಗಲೇ ಮುಂಚೆ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ರೆ
ಮಾಡಿದ್ದಾರೆ.
They will have to take action on that list.
Yes, that is the exact point, no, my lord. What happened was, the assistant commissioner.
But all of you have to go out.
No, the assistant commissioner also has.
It is not possible to form a layout in your presence. Not possible.
My lord, just one more document, my lord.
If you agree to go out,
my lord,
and we will fix a particular time frame where the layout will be formed, and they will take action to identify the beneficiaries, and it will be distributed.
ಮತ್ತೊಂದು ಸ್ವಾಮಿ 21/9ಕ್ಕೆ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, 1 ತಿಂಗಳಲ್ಲಿ ಬಿಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಮಾಜೂರಲ್ಲಿ ಇದೆ.
Yes.
ಒಂದ್ ನಿಮಿಷ ಸ್ವಾಮಿ, ಈ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಜೊತೆಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 ಹಾಕಿರೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಜೊತೆಗೆ ಅದರಲ್ಲೇನೆ the third page.
We will not permit the formation of the layout even as you are squatting there. That is not possible.
No, my lord.
From
2000.
Please go out. We'll ask them to form a layout and take action in accordance with law. ನೀವು ಯಾವ ತರ ಹೇಳ್ತಾ ಇದೀರ ಅಂದ್ರೆ, ನಾವು ಯಾರು ಎಲಿಜಿಬಲ್ ಅವ್ರವ್ರಿಗೆ ಅಲ್ಲಲ್ಲೇ ಇದ್ಕೊಂಡು ಅಲ್ಲಲ್ಲೇ ಅವ್ರಿಗೆ ಅಲಾಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡ್ಬಿಡ್ಬೇಕು, ದೇ ವಿಲ್ ಕಂಟಿನ್ಯೂ ಅಂತ. ಹಂಗಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
ಇದು
ಒಂದೇ ಒಂದು ಪೇಜ್ ರೆಫರೆನ್ಸ್
for all encroachers only.
No, one page I will just.
What is the ground on which you have put up the construction there?
We have not put up any construction, my lord.
Even if you have put up the sheds there or huts there, how did you do it?
It was based on R4 report, my lord.
If you agree,
R4.
If you agree, I'll record the submission, and I'll ensure that after you evict from there, within a time frame, they will form the.
In that case, my lord, I will ask all of them, my lord. I will consult them. I'll ask them because I cannot, because there are so many petitioners and they have been living there. So I cannot make a submission of that nature. Kindly 2-3 weeks time may be given. What I will do is I'll talk to them. I'll ask them their view and I'll submit, my lord.
Yes. 2-3 weeks ಎಲ್ಲ ಆಗೋದಿಲ್ಲ.
2-3 weeks, my lord. ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಅವರೆಲ್ಲರೂ ಯಾರು ಓದು ಬರಾಗೊತ್ತಿಲ್ಲ.
Orders will be passed next week. We will give them some time to clear. Not that they will be asked to clear on the same day.
ಇಲ್ಲ ಇಲ್ಲ 21/9ಕ್ಕೆ ನನಗೆ ಒಂದ್ ತಿಂಗಳು ಟೈಮ್ ಬೇಕು ಅಂತ ಅವರೇ ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ.
ಆಮೇಲೆ ಏನು sets ಹಾಕೊಂಡಿದ್ದಾರೆ ಅದನ್ನ ತೆಗಿಯೋದು ಎಷ್ಟೊತ್ತು? ಎಲ್ಲ ಬೇರೆ ಕಡೆದಲ್ಲಿ
ಅವ್ರಿಗೆ ಬೇರೆ ಎಲ್ಲೂ ಹೋಗಕ್ಕೆ ಜಾಗ ಇಲ್ಲ.
ಎಲ್ಲರೂ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಇಟ್ಕೊಂಡು ಲೇಔಟ್ ಫಾರ್ಮೇಶನ್ ಮಾಡಕ್ ಸಾಧ್ಯ.
Because this same submission came up and my lord, the previous bench, my lord, what they also identified and said was, see, ultimately it is to be given under the Ashraya scheme.
Yes.
That is a given. It can't be given to somebody else. Now, considering that they have been here and writing representations from 2014.
ಏನಾಗುತ್ತೆ, ನೀವು ಈ ತರ ಕೇಳೋ ತರ ಮಾಡಿದ್ರೆ, if they identify you as ineligible, you will say, no, I am not going to vacate.
No. That, my lord, that was discussed.
ಆಗೋದಿಲ್ಲ sir, not possible. That will not be possible. You have to vacate, and if you vacate only, all these things can be done in a timely manner.
My lord, on alternative thing is, my lord, let the panchayat conduct that meeting at least.
No.
We will go and furnish our details.
There.
No, we'll go and furnish our details. If they say that no, you are ineligible, we'll go out.
No. ಹಂಗಾಗೋದಿಲ್ಲ. Having heard the learned counsel for the petitioners and the learned counsel for the respondent, Gram Panchayat, and the learned HCGP, this court finds that as long as the petitioners are squatting over the property, it will not be possible to form a layout and allot the sites. Full stop. The Gram Panchayat will have to take a decision regarding identification of the beneficiaries in accordance with law. That is, in terms of the provisions of the Karnataka Gram Swaraj and Panchayat Raj Act. Full stop. For that purpose, if the petitioners agree to clear from the property in question, the same will be recorded and a time frame will be fixed to enable the Gram Panchayat to proceed in accordance with law. Full stop. Next para. At the request of the learned counsel for petitioners, release matter on 12th of June.
My lord, the interim order may also be extended till then.
Interim order granted earlier stands extended till the next date.
Please.
Number 29, Badri Vishal.
Lords, appearing for the petitioner, my lords.
Yes.
Your lordship may see the order dated 14/3/24, my lords.
Advocate for respondent 1 to 4.
Yes.
Praise 2 weeks time.
14/3.
14/3/24, my lords. We had submitted a memo, my lords, along with a new design plan, my lords. The BBMP had to reply with whether they were agreeable for the said plan, my lords.
What was that? What was that plan?
My lords, it's a covering structure over the garage car.
Where do you get that? Memo for consideration of interim prayer.
No, my lords. Memo filed on 14/3/24, my lords. Last memo, my lords. We had given some new plans, my lords, for a covering structure over the Raj Way. The BBMP had to reply whether these designs for the covering structure, my lords, would be agreeable with them or not.
What is the prayer in the petition?
My lords, your lordship will find the prayer, my lords, at page number 17.
Yes.
To declare that the action of the respondents in demolishing the covering structure on 28/10/23 and 29/23 constructed over the storm water drain is illegal and mala fide.
So you had put up the cover.
Please, my lords, with the permission of the BBMP.
It has been demolished.
It has been demolished.
Ah.
Now they said they want a different
Sorry
structure.
for the BBMP.
Yeah.
Ah. Who demolished it? BBMP.
Please, my lords. Please, my lords.
Ah, yes.
My lord,
Who is, where is Mr. Prashant?
my lord, praise
Huh?
time for 2 weeks, like we need to get directions from
Huh?
him. Praise time for 2 weeks, my lord. We have informed the petitioner about like 2 weeks time.
About?
Seeking adjournment.
Is it right?
Please, my lords, they had informed us.
Ah.
They said they'll take instructions from the BBMP, my lords, regarding the new design.
At the request of the learned counsel for the respondent BBMP, release this matter on 19th of June.
Great.
Yes.
Please, I'm grateful.
Number 30. Naveen GA.
It's a writ petition seeking mandamus to conduct elections. The administrator was appointed on 25/8/2018. From that date, my lords.
23. Lord, may I request, my lord?
Hmm.
What was happened, the society doesn't have a money.
The last
He
date, my
himself
lords.
has accepted that we will pay, we will deposit the money to the society account.
But,
After that, we will start in process ಅಂತ ನಾವು
on
ಹೇಳಿದ್ವಿ.
29/5, my lords, they have given an estimate of 17 lakhs to conduct the elections.
17 lakhs. sir.
Yes, my lord, sir. 17 lakhs, my lords, for 1,383 members. In that, my lords, only 300 or 400 members will be active members for the reasons all other members have been allotted sites. And only those members who will pay 1,000 rupees as a fee will be allotted, will be given will be permitted to vote, my lords. Kindly, my lords, in their estimation, my lords, they have given 17 lakhs and they have stated like 2 lakhs for ಸಿಬ್ಬಂದಿ ಮತ್ತು ಸದಸ್ಯರಿಗೆ ಊಟದ ವೆಚ್ಚ.
Copy ಕೊಡಿ.
In the last date of hearing, my lords, this honorable court had directed them to give the estimation because we had undertaken that we will bear the bare minimum expenditure to conduct the elections. And this is the estimation that has been given to us on 29/5, my lords.
Wind up ಮಾಡೋದಕ್ಕೆ ಇದಾಗಿದೆ. Actually, my lord, this society ವೈಂಡ್ ಅಪ್ ಮಾಡೋದಕ್ಕೆ ರೆಕಮೆಂಡೇಶನ್ ಆಗಿತ್ತು. ಬಟ್ ಅವರು ಎಲೆಕ್ಷನ್ ಮಾಡ್ಲೇಬೇಕು ಅಂದಿದ್ಕೆ ದೇ ಅಗ್ರೀಡ್ ದಟ್ ವಾಟ್ ಎವರ್ ದಿ ಎಕ್ಸ್ಪೆನ್ಸ್ ದರ್ ವಿಲ್ ಬೇರ್ ಇಟ್. ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಇದನ್ನ ಮಾಡಿದ್ರು.
17 lakhs.
If they are not eligible, my lord.
For 17 lakhs, my lords.
ಹೌದು.
Even if we consider it as a bare minimum, my lords, it will be conducted within 5 lakhs, my lords. If they properly see into the records and look into the matter, my lords, it will be conducted in a bare minimum things. But what they have given is 17 lakhs. And I think it's a copy paste for the reason, my lords, in some of the things it states that ಅವರು ಮಾಡಿರೋ ಯಾವುದೋ ಒಂದು ಎಲೆಕ್ಷನ್ ಹಾಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕಾಣಿಸ್ತದೆ, my lords, because it says ಚುನಾವಣೆಗೆ ಬ್ಯಾನರ್ ವೆಚ್ಚ, ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಅಳವಡಿಸಿರುವ ವೆಚ್ಚ. ಯಾವುದೋ ಒಂದು ಎಲೆಕ್ಷನ್ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿ ಇದಕ್ಕೆ ಏನೋ ಅಮೌಂಟ್ ಫಿಗರ್ಸ್ ಹಾಕಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. And from 2018, they say that the records are has been confiscated by the police and it is in a criminal case. And they have not made any efforts to get the certified copy of the records also.
ಏನ್ರಿ ಇದೆಲ್ಲ ನೋಡಿದಿರಾ ಇದು?
ನೋಡಿದ್ರೆ
ಇವಾಗ
ಈಗ
ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಟ್ರೈನಿಂಗ್ ಗೆ 2 ಲಕ್ಷ ಅಂತೆ. CCTV ಕ್ಯಾಮ್ರಾ 1,10,000.
Lord, may I request, I will take instruction next week, it may be taken. What is that?
ಅವ್ರು ಬರಕ್ಕೆ ಹೇಳ್ಬಿಡಿ.
ಅವ್ರಿಗೆ ಬರಕ್ಕೆ.
You are ready to deposit 5 lakhs?
My lords, I have given affidavit also.
5 lakhs?
Yes, my lords, bare minimum, whatever they say that we are ready to deposit.
The process is like that, my lord. Before that, every member should get an notice as per the 13.
Let that officer be present before the court and explain.
Let them
what are the expenses, actually expenses.
Let them
ಅಷ್ಟೊಂದೆಲ್ಲ ಆಗಲ್ರಿ.
Let them
5 ಲಕ್ಷ ಒಳಗಡೆ ಎಲ್ಲ ಮಾಡಿ ಮುಗಿಸಿ ಅಷ್ಟೇ.
ಇಲ್ಲ, ನೋಟಿಸ್
ನೋಟಿಸ್ 75,000, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ,
ಮೆಂಬರ್ಸ್ ಎಷ್ಟಾದ್ರ
ಅದರಲ್ಲಿ
ಹಾಕಿದಾರಲ್ಲ 1,383.
ಅಷ್ಟ್ ಮೆಂಬರ್ಸ್ ಬರೋದೇ ಇಲ್ಲ.
ನಂಬರ್ 4.
My lords, ಅಷ್ಟ್ ಮೆಂಬರ್ಸ್
ಬರೋದಲ್ರಿ, ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಗಿವನ್.
ಅಲ್ಲ,
there is a requisite that 1,000 rupees has to be paid by every member. Some around 800 to 900 members have been allotted sites. They won't even pay 1,000 rupees for the reason that already they have been given sites. Only remaining 300 or 400.
ಹಂಗಲ್ಲ ಮಾಡಕ್ ಬರಲ್ರಿ. We are talking of elections.
Millets.
All persons who are
members.
eligible to participate in the election, they have to be issued notices.
Yes, my lords, for that eligibility, my lords, 1,000 rupees.
ಆಯ್ತು ಬಿಡ್ರಿ, ಅದಕ್ಕೆ ಯಾವ್ದು ಇದು ನೋಟಿಸ್ ಕಳ್ಸೋದಕ್ಕೆ 75,000 ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ.
Kindly, my lords.
No problem.
For ballots,
Get instruction and make my.
ಅಲ್ಲ, ballot papers ಗೆ they have stated 5 lakhs rupees at serial number 5.
Learned counsel for the petitioner submits that
ಸಾಮಾನ್ಯ ಮತಪತ್ರ ಅಂದ್ರೆ ಬ್ಯಾಲೆಟ್ ಪೇಪರ್ಸ್.
in terms of the directions issued by this court on 23/4/2024, it appears that the administrator has prepared an estimate for the expenses that could be incurred for holding the elections. Please. Full stop. Learned counsel submits that the administrator is of the opinion that the entire process may incur expenditure to the tune of rupees 17 lakhs. Full stop. This court has gone through the estimates and find that many of the requirement may not be necessary. Full stop. Next paragraph. Consequently, release this matter on 12th of June 2024 to enable the learned counsel.
13th, my lords. I may seek for 13th.
For the respondent, ಯಾವ್ದು ನಿಮ್ದು ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್?
ಎಲೆಕ್ಷನ್ ಅಲ್ಲ, ಇವರು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್.
Respondent number 5, my lord.
Administrator ಅಲ್ಲ, ನಾನು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್.
Respondent number 5, my lords.
Subsequent.
Enable the administrator of the fifth respondent.
Yes.
Society.
To be present before.
To be present before this court.
And explain them.
And explain the estimates prepared by him. Please. Full stop. 13th. You want?
13th.
March 13th.
In the orders list, my lords, there is no interim order, sir.
ಬರುತ್ತಾರೆ
ಅಲ್ಲ, B group ಹೋಗ್ಬಿಡುತ್ತೆ, my lords. B group ಅಲ್ಲಿ ಬಂದ್ಬಿಡುತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ.
ಯಾವ್ದ್ರಲ್ಲಿ ಬಂದಿರೋದು ಇವಾಗ ಇದು?
Orders ಅಲ್ಲ, my lords.
Orders ಅದೇ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಬರುತ್ತೆ.
Kindly, my lords. Grateful.
ಗೋವಿಂದರಾಯ ಕಾಮ.
In this case, I appear for the petitioner, my lord.
Yes.
Respondent number 3 is the neighbor of the petitioner who was constructing illegally. So therefore, notices were issued to 1 and 2. Subsequently, they have appeared before this honorable court and they have stated that they have initiated proceedings under 248. But I would request this honorable court kindly go through the order dated 21/2/2024, Sami. Adರಲ್ಲಿ our complaint was that third floor construction illegal ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they have filed a memo by stating second floor demolish ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ. So therefore this court directed the respondent ಅದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಸ್ವಾಮಿ to take a correct stand, clarify ಮಾಡಿ ಅಂತ ಹೇಳಿ respondent ಹೇಳಿದ್ದು. So far they have not clarified.
Where is the sanction plan?
We'll get the plan. Filing an application. Objection just ಹಾಕಿದ್ದು sir.
You are appearing for the private respondent.
I'm respondent number 3, man.
Private respondent.
Yes, sir.
You are
The matter will be stayed in
BBMP.
Yes.
The matter will be stayed in BBMP, man.
ಏನು?
Stay ಆಗಿದೆ BBMP ಅಲ್ಲಿ ಕಮಿಷನರ್ ಮುಂದೆ ಸ್ಟೇ ಆಗಿದೆ.
Commissioner ಮುಂದೆ.
ಹೌದು ಸರ್.
ಆಯ್ತು.
ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಅಂತಾನೆ BBMP ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದು. ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಪರ್ಮಿಷನ್ ಆಲ್ರೆಡಿ ವಿಲ್ ಗೆಟ್ ದಿ ಪರ್ಮಿಷನ್. ಸೆಕೆಂಡ್ ಫ್ಲೋರ್
ಥರ್ಡ್ ಫ್ಲೋರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದಿರ ಏನ್ರಿ?
ಇಲ್ಲ, ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಅಂತೇಳಿ ಅವರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ BBMP ಅವರು.
ಅದಕ್ಕೆ
ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಅಂತ
ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಇಗ್ನೋರ್ಡ್.
ಇಲ್ಲ, ಪರ್ಮಿಷನ್ ಅವ್ರು ಏನು ಇದು ಮಾಡ್ಕೊಂಡಿದ್ರು ನಾವು ಅದರಲ್ಲೇ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿರೋಂಥದ್ದು. ಥರ್ಡ್ ಫ್ಲೋರ್ ನಾವು ಇದು ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಸರ್. ಥರ್ಡ್ ಫ್ಲೋರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿಲ್ಲ.
Where are the photographs? Where are the photographs, sir?
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. ನೆಕ್ಸ್ಟ್ ಡೇ ಬೇರೆ ಫೋಟೋಗ್ರಾಫ್ಸ್.
What do you
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ನಮ್ಮ BBMP ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಗ್ರೌಂಡ್ ನ ಸ್ಟಿಲ್ಟ್ ಗ್ರೌಂಡ್ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರ ಪೆಟಿಷನ್
ಗ್ರೌಂಡ್
ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರ ಪೆಟಿಷನರ್ಸ್ ಏನು ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರೆ ದಟ್ ಇಸ್ ಕನ್ಸಿಡರ್ ಆಸ್ ಎನ್ ಥರ್ಡ್ ಫ್ಲೋರ್ ಅಂತ ಅವ್ರ ಅಲಿಗೇಷನ್ಸ್. ಅದು ನಾವು ಆಲ್ರೆಡಿ 248(3) ಇಶ್ಯೂ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀವಿ ಸರ್.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಚೀಫ್ ಕಮಿಷನರ್ ಮುಂದೆ ಹೋಗಿದ್ದಾರೆ.
ಹೌದು.
ಹಾ?
ಹೌದು.
All right, we will await the orders of the chief commissioner.
Yes, madam.
Let the chief commissioner consider and pass orders.
Much obliged.
Learned counsel for the third respondent submits that the third respondent has filed an appeal before the chief commissioner. What do you have? In appeal number 46 of 2024. And an order of stay has been granted by the chief commissioner. Chief commissioner. Full stop. Next para. The petitioner will have to await the orders that could be passed by the chief commissioner. Full stop. ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಾರೇನ್ರಿ ಅಲ್ಲಿ? petitioner party
ಇಲ್ಲ ಇವರು ಪಾರ್ಟಿ
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಸರ್.
ಬಿಬಿಎಂಪಿ ಆರ್ಡರ್ ಬಿಬಿಎಂಪಿ ಒಂದು ಪಾರ್ಟಿ ಮಾಡಿ.
The petitioner is also permitted to take part in the proceedings before the chief commissioner and raise any objection. Full stop. Next para. Liberty is granted to the learned counsels to move a memo for posting, after orders are passed by the chief commissioner.
ಆಗ್ಬೋದು.
What are ವಾಪಸ್
Number 31, Govindra Kamath.
Yeah, same thing, my lord. What 31 we just now got.
32 re.
32.
My lord, we have filed the wakalat for respondent BBMP on 3rd of June, that is the day before yesterday, your lordship. You have not received the petition copy. The name of the council may be brought on record, Sachappa PB.
We will furnish you.
This is regarding assessment.
Yeah, yes.
Yes, your lord.
Assessment.
Yes.
You will have to make a inspection and
Yes,
submit
your
a
lordship.
report.
Yes, your lordship. Yes, your lordship.
Kindly extend the interim order.
The name of the council may be recorded, Achappa PB.
Learned counsel Sri
Achappa PB.
Achappa BB.
PB.
You have filed wakalat.
Yes, your lordship.
Submits that he has filed wakalat on behalf of response number 2 and 3 BBM.
Yes, your lord.
Stop. Office to verify and show the name of the learned counsel in the cause list while removing the name of learned counsel Sri Pawan Kumar. Full stop. Learned counsel for the petitioners. Petitioner is directed to serve a copy of the petition along with annexures on the learned counsel for the respondent BBM. Full stop.
Kindly extend it.
Next para. Release this matter on 12th of June. Full stop. Interim order granted earlier stands extended till next date of hearing. We will see what happens tomorrow in all those matters.
Yes, your lordship.
Yes.
Excuse me.
33, Naveed Ahmad, inspection report.
Proxy counsel of the respondent number R1, R2.
Yes.
Miller, kindly give me short accommodation, Miller, to file my inspection report. And I have not received the repetition copy also.
Sumana Paliga's entered appearance, is it?
Yes, I'm,
Huh?
yes, Miller.
Sumana Paliga.
Yes,
Since learned counsel, Srimati Sumana Paliga has entered appearance for response number 1 and 2, BBM.
yes.
The name of learned counsel Sri Pawan Kumar may be removed from the cause list. Full stop. Learned counsel for petitioners is requested to serve a copy of the writ petition along with annexures on learned counsel for the respondent BBM. Full stop. Next para. Release this matter on 12th of June 2024 to enable the respondents to furnish a copy of the inspection reports. Full stop. Next para. Till the next date of hearing, the interim order granted earlier stands extended.
Number 34, कि मंजुनाथ गौड़ा के
Petitioner Malad. This matter R4 and R5 again I'll taken steps Malad.
Huh?
R4 ಮತ್ತೆ R5 ಗೆ again I'll
Each time
taken
is granted at the request of learned counsel for petitioner to take steps for
R4 and
service
R5.
of notice on respondent number 4
4 and 5.
and 5 are
4 and 5.
4 and 5.
35.
Kindly extend the interim order.
Interim order granted earlier stands extended till the next date of hearing.
35 रविशंकर के
The respondent number 3.
Seeking mandamus against the respondent bank, my lord. My lord, the bank has issued NOC and 2/5/2023 annexure B, my lord, page number 25, my lord. All outstanding dues has been cleared. NOC has been issued, my lord. Page number 55, my lord.
55?
55. Page number annexure B, my lord. Loan clearance certificate, my lord. As per the loan availed by the petitioner, my lord, 1 to 7, entire loan amount has been cleared, my lord. As against that, my lord, there are 2 properties has been mortgaged, my lord. Then, my lord, I am seeking the return of the original title deeds, my lord. They are declined to return the title deeds because of, my lord, I am the guarantor in another one bank, one loan account, who is obtained by my father, my lord. I have guaranteed more than 11 properties has been executed
You are put
mortgage.
as a guarantor for many other persons.
Yes.
No, only one, who is principal borrower is my father, my lord. In the said loan account, my lord. I executed
Adರಲ್ಲಿ ನೀವು
guarantee.
But ಅದಕ್ಕೆ separate ಆಗಿ you will have taken the mortgage of another property.
Another property, my lord, kindly see, take only one minute, my lord. Kindly see, my lord, page number 5 of my statement of objections, my lord.
Statement of objections.
Yes, my lord. Last occasion filed, my lord.
ನೋಡಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ ಅಂತೆ ಇಲ್ಲೇನು ಇಲ್ಲ.
ಎಷ್ಟಿದೆ ಜಾಸ್ತಿ? ಕಾಪಿ ಇದೆಯಾ? ಪಾಸ್ ಆನ್ ದಿಸ್ ಕಾಪಿ
ಕೊಡಿ. ನಾವು ಪೋರ್ಟಲ್ ರಿಸೀವ್ ಮಾಡಿದ್ರೆ ಇದೇ ಪ್ರಾಬ್ಲಮ್.
ನಾನು after hearing, my lord, I'll file in office.
ಅದೇ ಆಫೀಸಲ್ಲಿ ಹಾಕ್ಬಿಡಿ.
My lord, see, sir, petitioner and family members and parents, my lord. Is a firm and partners, my lord. Another, see, other loans, my lord. Total outstanding is, my lord, 27 crores, 28,733,600, my lord. See, all the other deposit of title deeds, my lord. A separate class, all title 4 MOUs, my lord. Kindly see, my lord, page number 5 of the page number 14, my lord. Page number 14, my lord. So memorandum of deposit of title deeds dated 30/12/2021. So Roman 5, my lord. The second party Sahakar is entitled to all the B schedule title deeds as a security till the entire loans facilities now availed from time to time either by the firm. Firm is the firm, my lord, and proprietor also, my lord. See, and it's a partners, their individual capacity, my lord, guarantor also sureties are completely discharged, my lord. This is a clause, all the other memorandum of title deeds, my lord, total is
So if
28
you
crores,
agreed
my
for
lord.
that one, nothing can be done.
Out of 11 properties, my lord, I am seeking only 2 properties because of, my lord, I am in the said account, my lord, I am not a principal borrower. My father is a principal borrower. Moreover, my lord, till today we are paying regularly without having any.
Sir, but you have agreed in writing, it's a registered document.
Please,
ಮತ್ತೆ
ಅಲ್ಲ, because of, my lord, ಅವ್ರು ಏನಂದ್ರೆ ನಮ್ ರಿಟರ್ನ್ ಕೊಡ್ತೀವಿ ಅಂತ entire amount has been remitted to the bank, my lord. In this regard, my lord, on the consent given by the petitioner, respondent bank, my lord, the bank has issued NOC, my lord. NOC in respect of only 2
where is that communication made by between the two of you?
It is oral communication, not a.
ಏನ್ ಮಾಡೋದು? See, contrary to the registered document, how can this court issue directions?
Moreover, my lord, in the said document, my lord, we have deposit 11 properties only for collateral purpose, my lord. out of which, my lord, my major properties also mortgaged by the.
You have agreed that it shall be retained till all the loan is cleared anta.
Because subsequently, my lord, entire loan has been discharged. The authority, the respondent
ಹೌದು,
number
but
also issued.
you have agreed in writing, it's a registered document. ಆಗೋದಿಲ್ಲ. The petitioner is seeking return of the title deeds.
Madam, permit me to withdraw the petition, madam.
ತೆಗ್ದ್ಬಿಡಿ. ಒಂದು ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ.
Today.
When it comes in for the petitioner has filed a memo seeking leave of this court to withdraw the writ petition. Full stop. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn. Or ವಾಪಸ್ ಕೊಡ್ಬೇಕು.
Oh, please.
Number 36, Srikanth, yes.
My lords, I appear for the petitioner, my lords.
Report.
Yes.
That's a report has been, not has been filed. my lord.
My lord, my colleague Pawan Kumar, my lord, is unable to appear today, my lord. The connected matters, I'm told, my lord, are listed on the 12th of this month, my lord.
12th.
12th ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು.
ಇದು
My lord, ನಮ್ಗೆ ಗೊತ್ತು.
reassessment.
ಇರ್ಬೋದು.
Please, my lords.
12th, we have listed it for tomorrow, 6th ಅಲ್ವಾ?
6th,
We have listed.
ನಾನು ಹೇಳ್ತೀನಿ.
ಬಟ್ ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ.
ಅದು ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, my lord.
ಇಲ್ಲ, ಇನ್ಸ್ಪೆಕ್ಷನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಗಿಲ್ಲ.
ಇಲ್ಲ.
At the request of learned counsel for the respondent BBMP, release this matter on 12th of June.
Very well.
Grateful.
Number 37, Ajay Prabhu M.
My lord, I appear in this matter, my lord, for the respondent
Points as
BBMP, my lord.
Yes.
My lord, I was directed to seek instructions as to whether 356 notices, my lord, has been issued, my lord, by the BBMP pursuant to the 248, 123 and notices, my lord. My lord, I've just got instructions, my lord, that 356 notice has been issued also to the respondent number 5. But respondent number 5 ಅದು ಜಾರಿ ಆಗಿಲ್ಲ.
I have taken second time process, my lordship. It is awaiting.
ಅದು I will file this into court also, my lord, by tomorrow, my lord. $356 is the demolition order.
Orders, if orders have been passed,
Please, my lord.
then you'll have to take action.
Yes, I
Further
will
action.
take action. I will take action. ಯಾಕಂದ್ರೆ 356 action, my lord, it is a prolonged process. ಯಾಕಂದ್ರೆ ಪರ್ಮಿಷನ್ ತಗೋಬೇಕು, ಮತ್ತೆ ಅದಾದ ನಂತರ ಅಪ್ರೂವಲ್ ತಗೋಬೇಕು, ಪ್ರೈಸ್ ಎಸ್ಟಿಮೇಶನ್ ಎಲ್ಲ ಮಾಡ್ಬೇಕು. We are in the process. ಅದು ಫಸ್ಟ್ 356 ನೋಟಿಸ್ ಕೊಟ್ಟಿದೀವಿ. ಅದಾದ ನಂತರ we will take it to its logical end, my.
No, we have recorded that you have passed orders under 356.
356 ಅಲ್ಲಿ, my lord, the process had been initiated. ಯಾಕಂದ್ರೆ assistant executive engineer ಇಂದ it will go to the executive engineer. Executive engineer, he in turn passes the 356 note. So the notice, it has been passed, my lord.
No, you are only awaiting further orders for demolition.
ಹೌದು, my lord, that is a long process, my lord. ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಎಸ್ಟಿಮೇಶನ್ ಮಾಡಬೇಕು, ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಬೇಕು, ಎಸ್ಟಿಮೇಟ್ ಮಾಡಬೇಕು, ಎಸ್ಟಿಮೇಶನ್ ಆದ ನಂತರ then again we will have to get approval for that price estimation. We will have to identify a third contractor to execute.
ಯಾವಾಗ ಅದು ಆರ್ಡರ್ ಆಗಿರೋದು?
My lord, 31/5 ಅಲ್ಲಿ the order, my lord, it was passed on 10/4/2024, but the approval, my lord, for
proceeding with the 356, my lord, was issued on, 31/5, my lord. 31/5/2024.
Last only after getting all the estimation.
Allah, my lord, may I just clarify, my lord? Iga, if at all 248(3) confirmation order, if at all it is not complete.
If you are going to take 8 months, 10 months for this one, what is the use then?
True, my lord. I do understand, my lord. We will take, now pursuant to the orders passed by.
Bartana illa ನೋಡಿ.
Allowed.
They have not even appeared.
They have not.
Then
We will take orders. It may be kept pending, my lord, after 2 weeks or 3 weeks. I will again update as to what actions we have taken, my lord. That being the situation.
Could you please give us the dates when the action was
My lord, from the
notice was issued in the month of April 2020?
Allah.
3.
The correspondence from the assistant executive engineer to the executive engineer, it was passed on 10/4/2024, my lord.
10/4.
10/4/2024. Ad nantara, order under 356 has been approved by the executive engineer on 31/5/2024. So 31/5 andre just last week, my lord. Ad nantara, my lord, again now the assistant executive engineer, he has to conduct spot inspection and then prepare a price estimation. So Adrinda, if at all it is adjourned by a period of another 2 weeks, my lord, by that time I will get the price estimation also. I will conduct the spot inspection. I will get the price estimation also.
Please give it.
My lord, I've just received it like this, my lord.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. In terms of the directions issued by this court on 28/5/2024, learned counsel for the respondent BBMP submits that the assistant executive engineer commenced the process and sought the approval from the executive engineer in terms of section 356 of the Act on 10/4/2024. Full stop. The executive engineer passed orders on 31/5/2024. Full stop.
Order is at that a flag hakidin, my lord. That is the order passed.
And a demolition order was also passed on 31/5/2024. Full stop. Learned counsel for the respondent BBMP, however, submits that an estimation of the
work order. Price estimate.
Expenses required for undertaking the demolition will have to be made by the
Assistant executive
engineer. And thereafter, the same is required to be intimated to the owner of the building, and the demolition work order has to be issued. Full stop. Learned counsel submits that this may take some time. Full stop. Next para. having regard to the fact that the demolition order was issued on 31/5/2024, the officers have to take action as expeditiously as possible. Full stop. Next para. Release this matter on 19th of June 2024.
We make one submission, Your Worship.
Huh?
On 19/4/2024, this honorable court, after considering this sublanded illegal construction, has given liberty to file, my lordship, to seek for interim order. On 19/4, after considering this illegal construction, has given me liberty to file, my lordship, seek interim order.
Further
The file
construction ನಡೆಸಬಾರ್ದು.
from, my lordship, stopping.
You are the complainant or you are the owner of the building?
No, I'm complainant.
Complainant.
ಹೌದು.
ಏನ್ interim order?
ಅಂದ್ರೆ not to create any third party rate and not to create further construction.
Re, ಅವ್ರು demolition ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನೀ ಏನು not to put
ಅಲ್ಲ,
up further
ಇಲ್ಲಿ
construction?
bring you to notice of court.
They are going to demolish the construction that is put up now.
Please.
Yes. ಅವ್ರು ವಾಪಸ್ ಕೊಟ್ಟಿರೋದು.
38,
Oblige.
Pawan Chandra Shetty M.
Lordship, kindly pass over, my lord. Senior is held up in another court. Kindly pass over, my lord.
Well, in this matter, the other day, my lord, your lordship wanted to,
Yes, yes.
from Abdullah, my lord, whether the parking area, my lord, which either lies with the municipality area or it's a private property, which your lordship wanted to ascertain from Mr. Abdullah, my lord.
Yes.
It's not municipal property, my lord. It is a private property, not municipality property.
Private property belonging to the trust.
Pratisthana.
ಮತ್ತೆ how can you permit the sewage line to be
No,
drawn?
in the condition itself, my lord, ಮಾಲೀಕರ ಒಪ್ಪಿಗೆಯನ್ನು ಪಡೆದುಕೊಂಡು. Condition itself, my lord, while granting, my lord, with that condition it was given. ಮಾಲೀಕರ ಒಪ್ಪಿಗೆಯನ್ನು ಪಡೆದುಕೊಂಡು ಪೈಪ್ಲೈನ್ ಅಳವಡಿಸುವಂತೆ ಷರತ್ತು ವಿಧಿಸಿ ಅನುಮತಿ ನೀಡಲಾಗಿದೆ.
ಆಯ್ತು, pass over. Please get him.
Please.
39.
The respondent has filed a vacating application. I'll file statement of objection. It may be taken up day after tomorrow.
There is.
It may be taken up on day after tomorrow.
For
I'll file statement of objections to the vacating.
For respondent 2 and 4, my lord.
Dumping the wastage of the meat.
My lord, in the vacating application, he had made certain allegations against the petitioner. I have to counter those allegations, my lord. 2 writ petitions are pending before this court. I'll place on record, my lord, those documents. Interim order granted in those writ petitions.
Stopped by both parties, my lord, on the strength of the interim order. They filed the.
What's the impugned work order at annexure A? This work order is what?
My lord, work order is
ಪಾಲಿಕೆಯ
for
ವ್ಯಾಪ್ತಿಯಲ್ಲಿನ ಬೊಮ್ಮನಹಳ್ಳಿ ವಲಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ
collection,
ಉತ್ಪತ್ತಿಯಾಗುವ ವಾಣಿಜ್ಯ
my lord,
ತ್ಯಾಜ್ಯವನ್ನು
meat waste, animal meat waste, which is generated in, my lord, chicken shops, my lord, fish stalls, all those meat waste is to be collected, and my lord has to be processed by the petitioner. And he can utilize, my lord, the processed product, either he can sell or he can utilize. That was the order, my lord. Now, my lord, there are certain allegations made in their application for vacating. That, my lord, so far as there are action taken against me.
Who is this respondent number 5?
Respondent number 5, my lord, in whose favor, my lord, annexure A, my lord, the order dated 5/4/24 was given.
Now, what is that work order?
Work order is to lift, my lord, the animal waste for a period of 3 months. Prior to him, my lord, by the committee, my lord, 8 zones are there, my lord, in Bangalore city. 8 zones, my lord, for each zone, a separate contractor has been nominated by the committee, my lord. Pursuant to the nomination made, my lord, selection made by the committee, my lord, work order is to be issued by the BBMP for either for a period of 3 months or for 6 months. Every quarterly, my lord, we are required to approach them, or they would automatically renew and issue work order. My lord, in view of the election notification issued, my lord, the election code of conduct, they did not accept, my lord, application for renewal. They said, my lord, that after the election process, the code of conduct is over, we will renew your application or we will extend the order, fresh order will be issued. In the meanwhile, my lord, during the course of operation of, my lord, the election code of conduct, this impugned order annexure A came to be issued. He was not even, my lord, selected for the particular zone, selection made by the committee. Committee selected, my lord, for 8 zones, 8 separate contractors. For Madhepura zone, my lord, the petitioner was selected. And my lord, accordingly, they are required to issue work order. My lord, instead of issuing work order for a longer period, the practice being followed by, my lord, the solid waste management, my lord, the company, is to issue only for a period of 3 months or for sometimes 6 months. Now, my lord, there are allegations made against me in, my lord, in the vacating application saying that, my lord, action has been taken to close the unit. Insofar as action initiated, my lord, is concerned, I had filed, my lord, to.
No, you see, they are also doing this
Same one.
business of processing.
My lord, business of processing
See,
is not in Madhepura.
There are two things.
Please.
Contractors appointed to lift the waste material from the shops.
Please.
That is different from a person who is processing the material.
Please. I am lifting and processing. I am lifting as well
What
as
about you?
processing.
Same work by me also. After that only permission given by the BBMP, that is the order challenged by me, my friend, my lord. Kindly.
When contract has been given to him,
Their contract was being closed. After that only.
How?
permission. Kindly.
and why it was closed down?
Because of public letter. Well, I take page 28 of the my interim application. Madam. Along with interim application, I filed the documents. Page 28. R4, my annexion R4. ವಿಶ್ ರವರಿಗೆ ಅಧ್ಯಕ್ಷರು ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಇಂದ ಪೆಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮಸ್ಥರು ಮೇಲೆ ವಿಷಯ ಪೆರಿಕೋಸ್ ಬಯೋ ಫರ್ಟಿಲೈಸರ್ಸ್ ಕಂಪನಿಯ ಮೇಲೆ ಪೆಮ್ಮನಹಳ್ಳಿ
ಆಯ್ತು. There is some complaint.
As per that annex page 50, kindly turn to the page 53 of the same page book ಮೇಲೆ ಕೋಳಿ ತ್ಯಾಜ್ಯದಿಂದ ಉತ್ಪತ್ತಿಯಾಗುವ ವಿಷಪೂರಿತ ದ್ರವ ಪದಾರ್ಥಗಳನ್ನು ಕೆರೆಗೆ ಬಿಡುತ್ತಿರುವುದರಿಂದ ಹಾಗೂ ತ್ಯಾಜ್ಯ ಶೇಖರಣೆಯಿಂದ ದುರ್ವಾಸನೆಯಿಂದ ವಾಯು ಮಾಲಿನ್ಯವಾಗುತ್ತಿರುವುದರಿಂದ ತಮ್ಮ ಕಾರ್ಖಾನೆಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವ ಬಗ್ಗೆ ವ್ಯವಸ್ಥಾಪಕರು ಪೆರಿಯೋಸ್ಕೋಪ್ ಲೆಟರ್
ಗ್ರಾಮ ಪಂಚಾಯತ್.
ಎಸ್ ಮೇಲ್ after that my lord, last para page 54
Against which, my lord, a writ petition is filed, interim order is granted, which is pending for consideration.
on the oral submission taken by my friend. My lord, next page was 55. Next 55 BBMP. ವಿಷಯ ಘನತ್ಯಾಜ್ಯವನ್ನು ವೈಜ್ಞಾನಿಕವಾಗಿ ಸಂಸ್ಕರಿಸಿ ವಿಲೇವಾರಿ ಮಾಡಲು ಪೆಮ್ಮನಹಳ್ಳಿ ಬಳಿ ಇರುವ ಪೆರಿಕ್ಯೋಸ್ ಬಯೋ ಫರ್ಟಿಲೈಸರ್ಸ್ ಅವರ ರೆಂಡರಿಂಗ್ ಘಟಕವನ್ನು ಮುಚ್ಚಲಾಗಿರುವ ಬಗ್ಗೆ. It is closed by the BBMP ಲಾಂಗ್ ಬ್ಯಾಕ್.
ಮುಚ್ಚಲಾಗುವ ಬಗ್ಗೆ.
ಲಾಗಿರುವ ಬಗ್ಗೆ.
That has been challenged by him.
Yes, I've challenged.
That has been challenged by him. He says there is a.
And my lord, there was an order by this court to forthwith open the lock.
My lord, that is not challenged. He is challenged my order.
Anyway, you have subsequently been awarded the contract, and he is saying the actions ought to be taken against me has been questioned, and there is an interim order. So till
my lord,
the action sought to be taken against the petitioner reaches a logical conclusion.
My lord, only
I don't think you can proceed. You are asking for vacating of this order.
Yes, my lord. Allah, strength.
We will consider after at the time of final hearing.
This is R4 is my letter, permission given by the.
Having regard to having regard to the submission made by the learned counsel for petitioner, that the actions ought to be taken
R5 there
against the petitioner
then this period is
by the respondent BBMP to put an end to the contract awarded to the petitioner, the petitioners have approached this court in another writ petition, WP number.
But I'll furnish the fund. Action initiated by Sompura Gram Panchayat. Sompura Gram Panchayat, pursuant to which, my lord, BBMP has given letter saying that, my lord, Sompura Gram Panchayat has locked the premises and in regard to clarify. Subsequently, we have approached and said, but my lord, there is an interim order granted by this honorable. And still that matter.
Also, writ petition number?
Writ petition number I'll furnish. There are 2 writ petitions filed.
Only BBMP.
My lord, 25974.
Sompura Gram Panchayat.
25974/2023. 25,974/23. And prior to that, one more writ petition, my lord.
Comma,
ಆರ್ಡರ್ ಕೊಡ್ಬೇಕಾದ್ರೆ 3 ತಿಂಗಳ ಪೀರಿಯಡ್
Unless and until-
ಕ್ಲೋಸ್ ಆಗಿದೆ ಸರ್. Kindly
the said writ petition is disposed of, comma, the BBMP the interim relief granted to the petitioner cannot be vacated, full stop. IA number 2 of 2024 filed at the hands of the fifth respondent will be considered along with the main matter.
Interim order may kindly wait.
Interim order granted earlier stands extended until further orders.
Much.
Date may be serial number 40.
ಅದು ಡಿಸೈಡ್ ಆಗ್ಬೇಕು ಆ ರಿಟ್ ಪಿಟಿಷನ್. Yes.
Respondent to this matter.
That's
Kindly praise for a week's accommodation to file the affidavit of the
Huh?
affidavit file madam ADTP ಅವರು.
You are the complainant,
I'm the, no, I'm the, my lord, the,
owner of the,
I'm the,
owner of the property.
not owner, my lord,
Huh?
I'm the company which has erected the mobile tower. But I have taken permission. It is, this tower is in existence since 2006. Subsequently, my lord, in view of the introduction of the rules, my lord, new rules of the year 2022, I have taken the license also from the BBMP. Now, my lord, based on some complaints, no inspection, nothing. There's only on the apprehension that if tower, if falls, it may cause the problem to the neighbors. There we should, my lord, they have unilaterally withdrawn the license. But this honorable court on last occasion found that there is no subjective satisfaction on the part of the respondents. That is the reason, my lord, they were directed to file an affidavit. Because lordship could look into the impugned order.
At
There is
the,
no-
at the request of learned counsel for the respondent, BBMP, release this matter on 12th of June, 2024. Full stop. In the meanwhile, the directions issued by this court on 23/5/2024 to the assistant director shall be complied. Yes,
Interim order make it.
interim order granted earlier, stands extended till the next date of the.
Hearing interlocutory application, serial 41, P. Ananda.
Okay, for the petition.
Yes.
Application brought for the service of notice to second respondent.
Huh?
Second respondent brought the notice issued by this honorable court.
For publication.
Also. Because that's the last known address. It is mentioned even in the order passed in the dispute petition filed.
What is the matter about?
About my lord, termination of service of the second respondent. She filed a dispute, my lord, the address is same. Notice.
Still working with you?
No, my lord. She was a contract employee. Her services were terminated by passing an order. That she challenged by filing a dispute petition.
Correct.
Dispute was allowed.
Yes.
Against which we filed appeal before the Karnataka Appellate Tribunal.
Yes.
Appeal is also dismissed confirming the order of the
Correct.
registrar. Now the writ petition is filed by the.
Which
client.
means she should have been reinstated.
No, she did not come, my lord, after the order because the termination was not stayed by the authority. She raised a dispute. There was no interim order. She has been relieved from the service.
What is the order passed now by the tribunal?
Tribunal, my lord, passed an order dismissing the appeal and confirming the order of registrar.
What is the order of the registrar?
Order of the registrar is to reinstate her back to.
That is what I am asking.
Yes, please. Yes, please.
She is not reinstated?
She is not reinstated.
Why?
No,
Is there any interim order in your favor?
No, she did not show any interest, my lord. After that, my lord, she is not, my lord, even the service.
How many
is not
times have you taken notice?
Lord, 2 times.
Huh?
2 times it taken.
3 times you'll have to take.
Yes.
In terms of the provision.
Yes, I'll take.
Minimum 3 times you'll have to take.
I'll take.
Pending consideration of IA number 1 of 2024, the petitioner is directed to take fresh steps for service of notice for the 3rd time on the second respondent. A week's time is granted to do the needful.
God bless.
Serial number 42, Vijay D.
Yeah, for the respondent number 10, my lord.
Yes,
Being led by senior advocate Mr. Srinivas Raghavan.
GM,
Please, my lord. Lord,
special orders.
yes, my lord.
What is it?
Lord, what has happened on the last date of hearing, my lord?
Actually, this is pertaining to the modification of the order dated 26/9/2023, passed by this honorable court. Because this honorable court has granted relief, interim relief for the petitioner. It is pertaining to modification of the order and clarification of the order dated 26/9/2023. They have filed an interim application.
26/9.
26/9/2023.
Passed by this honorable court. Shall I read the order?
Yes.
My lord, before my
Learned
learned,
counsel for the petitioner has filed a memo along with
No,
hand
no,
summons.
I'm not going to say
Illa,
that you have to argue the matter today.
no, my lord.
I only want to understand what was the order that I.
Along-
passed.
Only the last portion
Along
of
with
the
the
order.
hand summons to show that he has served the hand summons to on respond number 6,
All right.
7 and 8.
Yes,
Learned counsel for the petitioner submits that respond number 5 and 6 non-banking financial institutions, for short NBFC, NBFIs, have not only violated the instruction circular issued by the Reserve Bank of India on 3/9/2023 at Annexure B, but also putting pressure on the petitioner to continue to service the loan account, although they are aware that it is not the petitioner who is not liable to pay the amount towards the loan, but it is respondent number 7, 8, and 9 who are responsible for making such payments. Learned counsel would draw the attention of this court to a decision of a coordinate bench of this court in the case of Mr. Modi Saxena versus Union of India and others in WP number 17696/2021 and connected matters dated 14/9/2022, wherein under similar circumstances, a writ of mandamus was issued restraining the NBFCs therein from taking any coercive measures against the petitioners for recovery of any amount comprised towards loan agreement and tripartite agreements. Learned counsel prays for similar interim orders. Learned counsel for respondent number 8 and 9 submits that respondent number 8 and 9 are not parties to the tripartite agreement, and whereas said response of the owners of the land where construction was to be put by a respondent number 7 builder. Nevertheless, the learned counsel for the petitioner has made out a prima facie case to call upon respondent number 5 and 6 as to why action should not be initiated against the said respondent, while directing the RBI to look into the matter and take action against the NBFC. 2 weeks time is granted for respondent number 5 and 6 to answer the query raised by this court as to why the RBI should not be directed to inquire into the matters and take action against the said respondents. Until then, the respondents are also directed not to take any coercive steps against the petitioner for recovery of the EMIs, since admittedly the petitioner has been paying EMIs regularly till last month. As requested by the learned counsel for the petitioner, respondent number 10 is also directed not to take any prescriptive action against the petitioner in view of the interim directions given by this court in relation to the present loan transaction. Release this matter on 11/10. So this is the order which has been passed by this honorable court, Your Lordship. It is as far as the respondent.
when do you want the matter to be listed?
Subject to your lordship's convenience, my request for Friday, my lord,
Friday, not.
or any date next week. My lord.
In the meantime, I will file my statement of objections for the application also. Or interim application file.
Objection I passed an order. They are asking for some clarification. You make your submissions. Other objections
The clarification I'm seeking will not prejudice the right of the petitioner in any way, my lord. I'm undertaking.
We'll consider.
Any date next week.
Release this matter on at the request of learned counsel for the
Respondent number 10, my lord.
respondent. Release this matter on 12th of June.
I'm grateful, my lord.
With respondent number 5 and 6. In spite of the order has been passed, they have already initiated the recovery process, Your Lordship. Other than the email correspond, other objections.
Contempt
Other contempt issuance letter. They have also corresponded to us that they have applied just for the same. I will file my statement of objections for the application because there is action taken by 5 and 6. See, the whole issue here is they are taking.
Please come on 12. We'll see.
I'm grateful.
Much over, much.
Huh? Huh?
12th or 13th.
Other side illa yaru
Appear for the respondent.
56 sir.
46.
My lords, may I make a submission, my lords? My lords, 46, my lords.
Yes.
My lords, in this matter, I have filed a impleading application, my lords. That has to be put up, my lords.
Opposite parties are also there.
In all the three matters.
Please, my lords, please, my lords.
First petition.
46, 46 and connected matters, my lords.
In all the three.
Please, my lords.
No, I think he filed in 46, madam, cell number 46.
Serial number.
Council Srikanth submits that he has filed interlocutory applications for impletement. Full stop. Office to verify and list the matter along with the applications. Full stop. List the matter on 12th of June.
Serial number 42, extension of interim. Serial number 42. Let the interim order be extended until such time.
Yeah, the previous matter. Yes. Interim order granted earlier since extended till next date.
Much obliged.
Previous matter.
Much obliged.
My lord, serial number 43, my lord.
My lordship, serial number 43 with. I'm actually occupied after.
Allowing the including application. Copy na ಕೊಟ್ಟಿಲ್ಲ.
I've not got a copy of the incident.
ಅದು ಕೊಟ್ಟಿಲ್ಲ. ಇದು ಕೊಟ್ಟಿಲ್ಲ. ಅದೇ ಸರ್ 49 230 ಮ್ಯಾಟರ್ ಇದೆ ಮುಗ್ದೋಗುತ್ತೆ. ಜಿದ್ದಿ ಹೊಡೆದಾಡಕ್ ಹೋಗಿದ್ರು.
ಪಾಸ್ವರ್ಡ್ ತುಂಬಾ ಇದೆ ಸರ್.
ಕಾಂಗ್ರೆಸ್ ಪಾರ್ಟಿ ಅಲ್ಲೇ ಸ್ಪ್ಲಿಟ್ ಆದ್ರೂ ಕಾಂಗ್ರೆಸ್ ಬಿಜೆಪಿ ಅಂತ ಹೊಡೆದ.
Anytime after 2 weeks.
ಸರ್ ಯಾವ್ದಾರ ಇದೆಯಾ CS ಮ್ಯಾಟರ್? CS ಮ್ಯಾಟರ್
ಯಾವ್ದು ಸರ್? CS ಇದೆ ಸರ್ ಒಂದು 230 ಅಲ್ವಾ? ಬಬುಲ್ 230 ಮ್ಯಾಟರ್ ಸರ್. ಇನ್ನೂ ಒಂದಿದೆ. ಇವಂದು ಯಾವ್ದಂದ್ರೆ 48 ಒಂದಿದೆ. 48 ಅಷ್ಟೇ. 52 ಅದು ಹಿಯರಿಂಗ್ ಅದೇ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಂದಿರಲ್ಲ 4 ಜನ.
ಮತ್ತೆ ಇನ್ನೊಂದು 47 48 ಓದ್ಬಿಟ್ಟು ಕೊಟ್ರೆ ಇದೇ ಮಾಡೋದು.
Court officer?
230 metro. Kritis.
Plus 45 ಅಥವಾ
Fast
50?
over metro.
45 ಅಥವಾ 55 ಯಾವ್ದು next ಚೆನ್ನಾಗಿ?
ಯಾವ್ದು ಅರ್ಜುನ ಆಯ್ತು? ಜಾಕ್ಪಾಟ್ ಬಂದಿದ್ದಾರೆ. ಈಗ ಬಂದ್ರಾ? ಅವ್ರು ಇನ್ನೂ ತಿನ್ಕೊಂಡಿದ್ದಾರೆ. ಬಂದಿ ಏನ್ ದಿಕ್ಕ ಆಗ್ತಾ ಇದೆ? ಏನ್ ದಿಕ್ಕ ಆಗ್ತಾ ಇದೆ? ರಿಪೀಟರ್ ಬೀಚ್ ಬರ್ತದೆ. 6 ನೋಡಿ. 6 ರೇಟ್ ಇದೆ.
My lord, serial number 43, the next matter, my lord, I pray for 2 weeks. Senior counsel, we have engaged, he has underwent knee surgery, I pray for 2 weeks. Next matter.
Correct ಇದೆ.
House, please.
ಹೇಳಿ.
Pass over matter.
ಯಾವ್ದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಂತ ಕರ್ದ್ಬಿಡ್ರಿ 43.
43.
43.
Please. The senior counsel is engaged, my lord.
In that, I have made an application for impleading certain petitioners, please, my lord. I think that any of the party.
Impleading petitioners.
Petitioners only. So this is a matter where Guru Raghavendra Bank is put under 35A imposition of banking regulation act, please, my lord. For the last 4.5 years, nothing has happened. The petition is for a direction to direct the government to elect a body of the directors, please, my lord. To elect a body of the board of directors. That is the prayer, please, my lord. Some of the petitioners have already filed and 3 more petitioners, they wanted to join the petitioners, please, my lord, for which I don't think that any of the parties have got.
Copy,
any
sir,
objection.
just.
Copy is just served now.
We'll find out.
We'll
It
seek
is only just
instruction.
to support the petitioners, that's all, please. my lord.
Kindly list it after 2 weeks, we'll seek instructions.
2 weeks, my lord.
You are appearing for whom?
RBI.
RBI.
I am appearing for the administrator of Guru Raghavendra Bank. Respondent number 4.
ಏನಿದು what objections can you raise on this one? What objections can you raise?
No objections.
They are saying
We
you
are
have to
just,
join the
we have just got the copy right now.
You join the petitioner, that's all, please. my lord.
You have received a copy today.
Today.
At the request of learned counsels for the respondents, release this matter on 12th of June.
After 2 weeks.
So
my
2
lord.
weeks, my lord, is undergoing knee surgery, my lord. Senior counsel is engaged.
ಎಲ್ಲಾರಿ application consider ಮಾಡಕ್ರಿ.
Please, please.
Yes.
Please. Pass over matter. Serial number 38, Pavan Chandra Shetty P. N.
Kindly pardon, my lord, morning I was held up.
That's all right. Please. Again, they are saying it's a property belonging to the trust.
Lord, that is,
ಹಂಗಿದ್ರೆ what can be done?
that is wrong submission, my lord. Document.
The municipality is saying it does not belong to us.
Let them file the affidavit, my lord. This property is not belong from them ಅಂತ ಅವ್ರು ಹೇಳಿ ಸ್ವಾಮಿ. Then
ಅಂತಲ್ಲ ಈಗ document, what document they filed?
let them, they have filed, my lord, one written statement, the memo. Memo dated 24/4/2024. Last time your lordship has seen the survey sketch. Survey
ಅಲ್ಲ.
sketch ಒಂದು ಹಾಕಿದ್ರಲ್ಲ.
Learned counsel had come up with some information.
My lord, according to them, if they are say so, my lord, it is belong from the.
Let us see.
Please.
Properly.
Address.
Yes.
If
230 PM matter. Serial number 56, H.N. Basavaraju.
That petitioner counsel, my lord.
For final disposal,
Yes, it is to be, my lord. It
Yes.
is.
Yes.
Lord, the controversy is this, my lord. Petitioner before your lordships is a primary society. The members of managing committee are before your lordships in the petition in my case. Fourth respondent belongs the federal society, that is District Milk Union, Ramnagar.
Bangalore Cooperative Milk Union.
Yes.
Amul.
Bangalore Cooperative Milk Union. This is the federal society. And we are all affiliated to this fourth respondent.
You are a primary society.
But primary society.
Which is the secondary society?
Which is secondary society is the fourth respondent. Apex society is the Milk Federation. Apex society is the Karnataka Milk Federation. The elections to the managing committee was held during 2018.
Managing committee of?
Fourth respondent Milk Union. That period is, of course, it is expired by this time. But because of notification issued by the government, now, my lord, the present board is continued till election process is completed. Now, according to our information, 6th, they are going to render it relaxed tomorrow. Tomorrow or day after tomorrow. In the meantime, my lord, the September 2023, a general body meeting was convened by the Milk Federation. This fourth respondent, District Milk Union, in which, my lord, several amendments are proposed to the bylaw of the society. One bylaw number, agenda number 10, my lord, it is relates to amendment to the re-alterations of constituencies of Ramnagara constituency is concerned. Ramnagara constituency. In which, my lord, the agenda says something. Then, my lord, agenda was placed before the general body meeting schedule. It was approved and then matter was sent to the registrar for acceptance. This is one of the mandate under the law. Your lordship is aware under the scheme of the Cooperative Society that after amendment of bylaw is proposed and accepted by the board general body, it has to be accepted. Unless and until it is registered by the registrar, it has no effect at all. This is the legal position. Then, my lord, when it is forwarded to the registrar, the primary society, which I am representing, they convened the meeting of the managing committee. They have taken a decision that this society is sought to be included within the radius of Bangalore South District constituency after eliminating from Ramnagara constituency. But that was not the agenda. Agenda is otherwise. Contrary to the agenda, they wanted to do that. We filed an objection. It cannot be done. All these things. When the matter is said to be considered by the registrar, first writ petition before your lordships was filed by one of the society. It came up before Honorable Justice Anant Ramnath Hegde. He was holding the roster on that day. Then he instructed the learned government advocate whether proposal of amendment has been accepted by the registrar or is it yet to be accepted. You verify and make a submission next day itself. When the next day matter came up for consideration, the government on instruction, they said it is accepted on the very same day itself. That is, when the order was passed by this honorable court on the same day. Therefore, my lord, other writ petitions are also filed before this honorable court, challenging that amendment approved as accorded by the registrar. My lord, this is, we challenge. My lord, your lordships may kindly see. Prayer may kindly be seen for a moment at page 21.
The connected writ petition is also filed by another.
Yes, another primary society.
On the same issue.
Yes, on the same issue. In which, my lord, certain impleading applications are sought to be filed by the private directors. Of course, we opposed it on the ground that private directors of a primary society are not individually members of the society. Society on delegation, therefore society is the member, not the primary member. Ultimately, my lord, we have shown our magnanimity before your lordships lost the case. I said, anybody want to argue, they can argue. Any kind of objection to be raised, they can raise. Only our anxiety is matter has to be disposed of on or before 6th of this month. That is time to file objections. Upon no objections are served yet, my lord. Nam case
But we have filed objections and we have raised preliminary objections to the maintainability of the report. In the first place, yes, 28-22,
He's addressing the arguments in 70.
I appear for
73-90.
the impleaded respondents. 28-22.
ಅದು ಇವ್ರದಲ್ಲ.
ಅದರಲ್ಲಿ
Taravana ಅವ್ರ case.
may I request the court to kindly see the prayer just to
No, that is why the learned senior counsel is saying I have not received a copy. ಅವ್ರದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ. You have filed it in.
He's addressing.
all are strongly opposing me, but objection is not served on me.
73-19.
28-22 has become infectious.
yes. Yes. Kindly see page 19 in 28-22. Only 1 minute I'll just show.
We will come to that. We will come to that.
Allah, the prayer doesn't survive.
If that is so, we will consider.
The registration is complete. Certificate is issued. They want a prohibition against issue of the registration.
Yes.
And also, this is an appealable order. Allegations of forgery, fraud, collusion are made. They are not matters which can be gone into in.
My lord, without referring to all these factual aspects, straightly on illegal issue, we could able to demonstrate the lordship may not drive us to the appellate jurisdiction because of the nature of the executive order passed by the first respondent joint registrar is concerned. Secondly, my lord, a acceptance of bylaw is, though it is an executive function, division bench of this court have taken the view that it is neither a mechanical nor a casual. It requires.
Quasi-judicial function.
Yes. My lord, where the division bench further said, why such an importance is, though it is not in the law, we wanted to supplement to the law is explained by the division bench in 1994, my lord. I can refer to that. My lord, before going to that, just I will narrate the factual aspect, then I will take your lordship to the legal aspects are concerned. My lord, may I kindly see page 21 prayer, my lord. We sought for quashing of the general body proceedings and acceptance of registration, accepted a registrar of these two release, my lord, we sought for in the writ petition. My lord, now I would like to take your lordship straight away. May I kindly go to, my lord, page 82, annexure D, my lord. Yes. Page 70.
70.
70. '69 may kindly be seen, just earlier page. My lord, it's a 2022-23 Samanya Sabha General Body Meeting, notice dated 9/9/2023, 11/8/2023. Meeting was convened on 9/9/2023. This is the general body of the 4th respondent district milk union. Then, my lord, may kindly go to next page. This is, my lord, agenda of the meeting which was scheduled or tabled on that day. There are about, my lord, 29 subjects are there, which we are concerning is, my lord, item number 10. ಒಕ್ಕೂಟದ ಉಪವಿಧಿಗಳ ತಿದ್ದುಪಡಿ ಬಗ್ಗೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಬೈಲಾ ಆಫ್ ದ ಸೊಸೈಟಿ. My lord, this amendment commencing from, my lord, the proposed amendments commencing from page 72, 14.2. Then, my lord, we are concerning with 14.3 at page 73, my lord. We are concerned with item number 3 in that, my lord. Ramnagara Kshetra. This was before the proposed amendment is introduced. This is the structure of Ramnagara constituency. ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ರಾಮನಗರ ತಾಲೂಕು ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು, ದೇ ಆರ್ ದಿ ಪ್ರೈಮರಿ ಮೆಂಬರ್ಸ್, ವೋಟರ್ಸ್ ಆಫ್ ದ primary Ramnagara constituency is concerned. Then, my lord, what is proposed to be amended is just opposite to same, my lord, para 3, column number 3, item 3, Ramnagara Kshetra. Could you allow this, my lord?
Yes.
ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 5 ಮತ್ತು 7 ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು ಹಾಗೂ ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಪಂಚಾಯಿತಿಯ ಬನ್ನಿಕುಪ್ಪೆ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು, ಕೂಟಗಲ್ ಹೋಬಳಿಯ ಜಾಲಮಂಗಲ ಮತ್ತು ಅಕ್ಕೂರು ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ ರಾಮನಗರ ತಾಲೂಕು ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು ಕ್ಷೇತ್ರ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಟ್ಟಿರುತ್ತವೆ. So far as our society is locating within the territorial limits of Bidadi municipality. Bidadi municipality is concerned, society is fallen within the categories of ward number 5 and 7. They are included within the location of Ramnagara constituency. ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 5, 7 ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು. This was included. This is the proposal. Then, my lord, this bylaw was accepted.
ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ನಂಬರ್ 5 ಮತ್ತು 7 ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಎಲ್ಲಾ ಹಾಲು ಉತ್ಪಾದಕರ
5 ಮತ್ತು 7ನೇ ವಾರ್ಡ್ ನಲ್ಲಿ ಬರೋ ಎಲ್ಲಾ ಸೊಸೈಟಿನೂ ರಾಮನಗರ ಕ್ಷೇತ್ರಕ್ಕೆ ಸೇರಿಸಬೇಕು ಅಂತ ಬರೆದ್ರು. There are others also, Bannikuppe and other things. Now we are concerned that I am concerning with this Kallugopanahalli, which is within the radius of ward number 1 in Bidadi municipality. Ward number 1 is not proposed to be altered insofar as this proposed amendment is concerned under the agenda itself.
Allah.
Bangalore South.
ಯಾವ ಕ್ಷೇತ್ರಕ್ಕೆ? ಎಲ್ಲಿ, where is the proposal?
Proposal to Bangalore South is at item number 12, my lord, at page 76. What was structured proposed before proposed is at first column. Bangalore Dakshina Kshetra, could you allow this, my lord? Page 76.
The proposal starts from 14.3, is it?
Yes, 14.3.
14.3.
Yes.
ಓದಿ ಮೇಲ್ಗಡೆ.
ಒಕ್ಕೂಟದ ಆಡಳಿತ ಮಂಡಳಿ ಕೆಳಕಂಡ ಮತಕ್ಷೇತ್ರಗಳನ್ನು ಪ್ರವೇಶಿಸುವ 13 ಚುನಾಯಿತ ನಿರ್ದೇಶಕರು ಹೊಂದಿರತಕ್ಕದ್ದು. ಮತಕ್ಷೇತ್ರಗಳು ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಆನೇಕಲ್ ಕ್ಷೇತ್ರ, 2 ಚನ್ನಪಟ್ಟಣ ಕ್ಷೇತ್ರ, 3 ರಾಮನಗರ ಕ್ಷೇತ್ರ, 4 ಕನಕಪುರ ಕ್ಷೇತ್ರ. These are the constituencies. This is. Then amendment which you are concerned in the impugned proceedings is item 3, Ramnagara constituency. That was also subject matter of an amendment proposed in the meeting. Earlier, how it is structured is, ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಒಂದು ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರೋ ಪ್ರೈಮರಿ
ಮಾತ್ರ ಬಿಟ್ಟಿದ್ರು.
ಬಿಟ್ಟು ಉಳಿದಿದ್ದೆಲ್ಲ ಸೇರಿಸ್ಕೊಂಡಿತ್ತು. ಈಗ ಅವ್ರೇನ್ ಮಾಡ್ಬೇಕು, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಅಂದಿದ್ದೇನೆಂದ್ರೆ, ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 5 ಮತ್ತು 7 ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಎಲ್ಲಾ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು ಹಾಗೂ ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಪಂಚಾಯಿತಿ ಬನ್ನಿಕುಪ್ಪೆ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು, ಕೂಟಗಲ್ ಹೋಬಳಿ ಜಾಲಮಂಗಲ ಅಕ್ಕೂರು ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯ ಹಾಲು ಉತ್ಪಾದಕ ಹೊರತುಪಡಿಸಿ ರಾಮನಗರ ತಾಲೂಕು ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು ಒಳಪಟ್ಟಿರುತ್ತವೆ. ಅಲ್ಲಿಗೆ ಬಿಡದಿ ಹೋಬಳಿ ವಾರ್ಡ್ ನಂಬರ್ 1 ಏನಿತ್ತೆ, ಆ ವಾರ್ಡ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಬರೋ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ is still continued with Ramnagara constituency. That was the proposed amendment. It could be further clarified, may go to item number 12, madam.
You come under Ramnagara Taluk Biddi Hood.
Biddi municipality ward number 1 ಒಳಗಿರೋ ಸೊಸೈಟಿ. ಅದು ರಾಮನಗರ ಸೊಸೈಟಿ ಕ್ಷೇತ್ರದಲ್ಲೇ ಇತ್ತು. ಅದು ಈಗಲೂ ಅಲ್ಲೇ ಇದೆ. ಅದು ಅಲ್ಲೇ ಇರಬೇಕು ಅಕಾರ್ಡಿಂಗ್ ಟು ಅಜೆಂಡಾ.
Let us see.
Then they quickly go to 12, madam. Column number 12.
Page number 76.
76. ಇದು ಬೆಂಗಳೂರು ಸೌತ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯನ್ಸಿ.
Yes.
ಇದೇನಂದ್ರೆ ಅಲ್ಲಿರೋದನ್ನ ತೆಗೆದು ಇಲ್ಲಿಗೆ ಹಾಕೋದಕ್ಕೆ ಇದು ಇಂಪಾರ್ಟೆಂಟ್ ಅಷ್ಟೇ. ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಇದು ಪ್ರಪೋಸ್ಡ್ ಅಮೆಂಡ್ಗಿಂತ ಮುಂಚೆ ಇದ್ದ ಸ್ಟ್ರಕ್ಚರ್. ಇದು ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಕ್ಷೇತ್ರ, ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು, ಕೆಂಗೇರಿ ಹೋಬಳಿ, ಆಗರ, ಕುಂಬಳಗೋಡು, ಸೂಲಿಗೆರೆ, ಗೊಲ್ಲಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ, ಬಿಬಿಎಂಪಿ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು, ಉತ್ತರಹಳ್ಳಿ ಹೋಬಳಿ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು, ಕನಕಪುರ ತಾಲೂಕಿನ ಹಾರೋಹಳ್ಳಿ, ಮರಳವಾಡಿ ಹೋಬಳಿ ಸಹಕಾರ ಸಂಘಗಳು, ರಾಮನಗರ ತಾಲೂಕು ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಎಲ್ಲ, these are all the added to the Bangalore South constituency. Now what is proposed is next at ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು, ಕೆಂಗೇರಿ ಹೋಬಳಿ, ಉತ್ತರಹಳ್ಳಿ ಹೋಬಳಿ ವ್ಯಾಪ್ತಿ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು, ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಬಿಬಿಎಂಪಿ ವ್ಯಾಪ್ತಿ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು 1 ಕ್ಯಾಟಗರಿ. ಎರಡನೇದು ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 5 ಮತ್ತು 7 ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು. ಅಂದ್ರೆ ವಾರ್ಡ್ ನಂಬರ್ 5, 7 ಸೌತ್ ಬೆಂಗಳೂರು ಸೌತಿಗೆ ಶಿಫ್ಟ್ ಆಗಬೇಕು ಅಂತ ಅಮೆಂಡ್ಮೆಂಟ್. ದಿಸ್ ಇಸ್ ದ ಅಮೆಂಡ್ಮೆಂಟ್ ಪ್ರಪೋಸ್ಡ್. ಇಟ್ ವಾಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. Then, my lord, what happened was,
Yours is
ward number 1,
ward number 1.
Biddi municipality.
So according to you, it was not
It remains
included,
with Ramnagara.
was not included in the amendment.
Yes, it is not the subject matter of an amendment. It is not proposed to shift to Bangalore South constituency, and it was not the subject matter at all.
Yes.
Then agenda was, meeting was scheduled on 9/9/2023. Your lordship will get the meeting proceedings at page 82. Annexure D. This subject will at page 94. It is in respect of 14.2, subject number 10 ಮೇಲೆ ತಾವು ನೋಡಿ. ವಿಷಯ 10 ಒಕ್ಕೂಟ ಉಪವಿಧಿಗಳ ತಿದ್ದುಪಡಿ ಬಗ್ಗೆ. ದಿಸ್ ಇಸ್ ದಿ ಸಬ್ಜೆಕ್ಟ್. ಮೀಟಿಂಗ್ ನಲ್ಲಿ ರೆಸಲ್ಯೂಷನ್ ಆಗಿದೆ. ಬೇರೆ ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿ My lord, your lordship may kindly go to page 96. ಪೇಜ್ ಮೇಲೆ 95 14.3 ಇದೆ ತಾವು. ಅದರೊಳಗಡೆ ಐಟಮ್ 3 ರಾಮನಗರ ಕ್ಷೇತ್ರ. ಇದು ಅಲ್ಲೇನು ಪ್ರಪೋಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ಬರ್ಕೊಂಡ್ರು. ತೀರ್ಮಾನ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ, ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ಸಂಖ್ಯೆ 5 ಮತ್ತು 7 ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಎಲ್ಲ ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಪಂಚಾಯಿತಿಯ ಬನ್ನಿಕುಪ್ಪೆ so and so, which are all added there. There is no complaint against which now. Now then go to Bangalore South. At page 99. Then my lord here, Bangalore Dakshina Taluk, Kengeri Hobli, Uttarahalli Hobli Taluk, Swans. One, two, three. Only then, 103 page. This is one, two. Yes. My lord, this is the resolution passed. In which, my lord, this resolution which we have produced, this Bidadi Municipal Council, Ward number 1 is not there, 5 and 7 is only there. There is no dispute. Then, my lord, your lordship may kindly come to page 102. Page 103, my lord, Ramnagara Kshetra. Contention is, lordship required to record a finding, whether it could be procedurally justified or not. We will take your lordships to the procedure on that context. Then, my lord, this was sent to the registrar for its approval.
Yes.
Before it sent it to the approval, my lord, page 112, Annex F may kindly be seen. This was the letter addressed by our primary society to the joint registrar. This is on 24/1/2024. Page 112. This is Bangalore Sahakari Halu ಒಕ್ಕೂಟದ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣಾ ಸಂಬಂಧ ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಮಾಡಿರುವ ಒಕ್ಕೂಟ ಉಪವಿಧಿಗಳ ತಿದ್ದುಪಡಿ ಕುರಿತು ಸಂಘದ ಠರಾವು. This is the resolution we have passed, followed by the covering letter. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಮನಗರ ಮತಕ್ಷೇತ್ರ ವ್ಯಾಪ್ತಿಗೆ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 5, 7 ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು ಮತ್ತು ಬಿಡದಿ ಹೋಬಳಿ ಮಂಚನಾಯಕನಹಳ್ಳಿ ಪಂಚಾಯಿತಿ ಮತ್ತು ಬನ್ನಿಕುಪ್ಪೆ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿ ಎಲ್ಲ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘಗಳು, ಕೂಟಗಲ್ಲು ಹೋಬಳಿ ಜಾಲಮಂಗಲ ಅಕ್ಕೂರು ಹಾಲು ಉತ್ಪಾದಕ ಸಂಘಗಳನ್ನು ರಾಮನಗರ ಕ್ಷೇತ್ರದ ವ್ಯಾಪ್ತಿಯಿಂದ ಹೊರತುಪಡಿಸಿ ಬೆಂಗಳೂರು ಸಹಕಾರಿ ಹಾಲು ಒಕ್ಕೂಟದ 22-23ನೇ ಸಾಲಿನ ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಉಪವಿಧಿಗಳಿಗೆ ತಿದ್ದುಪಡಿ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಒಕ್ಕೂಟದ ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಕ್ಷೇತ್ರ ವ್ಯಾಪ್ತಿಗೆ ರಾಮನಗರ ಜಿಲ್ಲೆ ರಾಮನಗರ ತಾಲೂಕಿನ ಬಿಡದಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 1 ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಸೇರಿಸಿ 22-23ನೇ ಸಾಲಿನ ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆಯ ಠರಾವನ್ನು ಉಲ್ಲಂಘಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಹಿಂದೆ ಇದ್ದಂತೆ ಅದನ್ನು ಅಲ್ಲೇ ಮುಂದುವರಿಸಬೇಕು. This was our representation. My lord, this is the resolution by the board of directors. No, my lord, the important question is, I would like to raise, based on the order of the registrar, page 123. May kindly see the date, 31/2024. Registration. Karnataka Sahakara ಸಂಘಗಳ 12/2 ಮೇರೆಗೆ ಹಾಗೂ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋ ಬೆಂಗಳೂರು ಪ್ರಾಂತ್ಯ ಬೆಂಗಳೂರಾದ ನನಗೆ ದತ್ತವಾಗಿರುವ ಅಧಿಕಾರದನ್ವಯ ಸಂಘಗಳ ಒಕ್ಕೂಟ ಸೋ 9/9/23 ಸಾಮಾನ್ಯ ಸಭೆಯ ತೀರ್ಮಾನದ ರೀತ್ಯ ಕೆಳಕಂಡ ಉಪವಿಧಿಗಳಿಗೆ ತಿದ್ದುಪಡಿಯನ್ನು ಷರತ್ತುಗೊಳಪಟ್ಟು ಅನುಮೋದಿಸಲಾಗಿದೆ. This was his order. My lord, when some 2 or 3 writ petitions are filed earlier to 30th, that is on 29th or 28th, when those petitions came up for consideration, Lordship said to the government advocate, learned government advocate, better whether proposal is yet to be considered or already considered. You get an information, tell the court. They said at 2:30 we will indicate, but next day at 2:30 they said registration is accepted. Then other side said it's an appealable order. Somebody said other repetitions become infructuous. So many other technicalities exposed. I'm not going to debate on that present. Now, my lord, whole area is regulated by 2 provisions of the Karnataka Cooperative Societies Act. One is Section 12, another is Rule 6 of the Cooperative Societies Rules. May I kindly see, my lord, how the statute is structured so far as amendment of bylaws are concerned. Cooperative societies.
Rule 12.
Section 12. Section 12.
Who is appearing for respond number 4 society?
PL Sanjeev.
Huh?
PL Sanjeev. Objection
He is not here today. Huh?
Your Lordship, senior is the other two.
Will be coming.
Yes, he'll be coming.
All right.
My lord, Section 12, I read it in its entirety, my lord. Section 12, amendment of bylaws of a society. A cooperative society may amend its bylaw in conformity with the provisions of this act and the rules made thereunder from time to time, provided that every cooperative society shall make amendment to its bylaws in conformity with the amendments made to this act or the rules from time to time within 90 days from the date of coming into force of the said amendments. Every proposal of such amendment shall be accompanied by such fee as may be prescribed, or different fees may be prescribed for different class of cooperative societies. 1A. Then, my lord, 2. Every proposal for such amendment shall be forwarded to the registrar. If it is registrar is satisfied, may kindly underline the word satisfied. This is very important. It requires an interpretation. This is interpreted by the division bench. I can show it to your lordships later. Proposed amendment. A is not contrary to the provisions of this act and the rules. 2, does not conflict with the cooperative principle. 3, satisfy the requirement of sound business. 4, will promote the economic interest of the members of the society. 5, is not inconsistent with the principles of social justice within period of 3 months from the date of receipt of the proposal, register the amendment. Next, 2A. If the registrar is unable to dispose of such application within the period specified in subsection 1, amendment of bylaw shall be deemed to have been registered. Then 3. When the registrar registered the amendment of the bylaw society where amendment, these are all, my lord, may not necessary. I will take your lordships to 5 and 6. If it appears to the registrar, may kindly, that any amendment of the bylaw of a cooperative society is necessary, my lord, language is otherwise, and desirable to give effect to the provisions of the act made thereunder, registrar may, by order, direct a society to make the amendment to the proposed bylaws are concerned. This is when society failed to propose an amendment, which is necessary for the purpose of implementing the act. The power is conferred upon a registrar to direct the society, you do it. This is subsection 5. Then my lord, subsection 6. If such amendment is not by any cooperative society within so and so, then there are consequences are provided. Now, my lord, according to section 12, it is very clear. First, an amendment of bylaw should be deliberated at general body meeting. General body meeting presupposed by an agenda. Agenda should indicate the subjects. That was the agenda. It has to be deliberated. Resolution has to be forwarded to the registrar within stipulated time, along with these particulars. Then, my lord, registrar sitting in an approval authority, assuming for a moment it's an executive act, but application of mind is expected by the statute saying that he has to form a satisfaction. Where the word satisfaction is required to be formed, application of mind is another element. These two are the same side of two sides of the same coin. This is. Then his application of mind to what extent? 1, 2, 3, 4, 5, 6 categorized. This is. Then my lord, they regulate this provision or operate this provision. Rule 6 is formulated, my lord, by the rules. May kindly go to Rule 6 of the Cooperative Societies Rules, my lord.
Yes.
My lord, where a cooperative society proposed to amend its bylaw, no such amendment shall be made, save as by resolution passed by 2/3 of the majority of members present in voting in a general body meeting. 2, no such resolution shall be valid unless notice of 15 days with the text of existing bylaw, the text of proposed amendment, reasons therefore, has been given to the members of the society in accordance with the bylaws. This is the requirement so far as amendment proposals are concerned. Rest of the provisions may not be necessary. Yes, my lord, now first and foremost question for myself is this. One preliminary objections there intending to raise. I think because I have not seen the counter, I don't know what is the nature. It appears to be amendment of bylaw, if it is accepted the registrar, it is amenable for an appeal under section 106. Absolutely no dispute at all. We are agreeing with that. Now my submission is, we made a statement in the writ petition. Why we are seeking dispensation of alternative remedy, enabled to invoke your lordship's extraordinary jurisdiction under Article 226. Can I take the pleading to that effect, ma'am?
Yes.
Let para 22, a separate heading is provided. It is submitted that order under section 12 of the Cooperative Society Act would be amenable for scrutiny in an appeal contemplated under section so and so. Indisputably, proceedings improved as well as clarification, certification issued by the registrar is an order covered under section 12 of the Act. However, petitioners are advised not to file a remedy of appeal because of a peculiar facts and circumstances involved in the present case. Facts pleaded in the writ petition clearly demonstrate that while the amendment was considered by the Federal Society in a general body meeting so and so, primary societies which are functioning within the limits of ward number 1, 5, and 7 of Bidji Town Council excluded, which inclusive of petitioner society. The proposed resolution further indicates that which are such societies would be included within the territorial limit of Bangalore South Milk Union after removed from the Ramnagara district. That resolution was accepted by the general body while it was forwarded to the registrar. Approval as provided under the law, village Kallugopanhalli was inserted by way of manipulation. Though it was not the subject matter approved by the general body in the meeting dated 9/9/2023. Upon notice of these manipulation, a correspondence was addressed before the registrar who is the authority to approve the amendment. In addition to that, question of jurisdiction had also been raised because of the fact that in view of the scheme provided under the Act, election process to the society commences 195 days prior to the expiry of the term of the present members of the managing committee. Since the election to the Federal Society would be due in the month of April 2024, election process has been commenced. Commencement of such process, alterations or delimitations process was undertaken without consulting the election authority under whose control supervision election ought to be conducted. My lord, these are all the reasons stated. Ultimately, apparent on the impugned order which I read to your lordships, it's any ordinary person could say there's a lack of application of mind in approving that rather than arguing by a senior counsel by me. Like me, I wanted to say. Therefore, my lord, we invoke 226. This is the submission we made. Then, my lord, what's the law on the point? Your lordship may kindly see, my lord. ILR 1994, Karnataka 2525. It's a division bench judgment. Section 12 and 3 was considered. Can I read it? Section 12 and 13. Amendment of bylaw, enlarging area of operation overlapping that of other cooperative unit. Supervisory authorities to exercise due adequate control.
Head notes peda.
Aye, para ಓದ್ಬೇಕಾ? Paragraph 8. As far as the aspect of the matter is concerned, it is necessary for us to lay down that situation of rural India in particular requires to be taken cognizance of insofar as several of the business needs of those regions are catered to by the cooperative units. Apart from rendering service, however, these units have also become power centers with various affiliations and have therefore become vulnerable to political control and serious infighting. Instances are many where courts have come across situations wherein due to unhealthy infighting, such cooperative units have been virtually destroyed. It is therefore very essential that supervisory authorities exercise due diligence, adequate control over all such situations. More importantly, economic viability and desirability of permitting either a new society or existing society requires to be carefully, correctly, dispassionately assessed on the basis of reliable data. It is true, no area is to be treated as the personal fieldom of any particular existing unit, but the consequences of permitting other to enter the area requires very careful evaluation, particularly in a situation where it may lead to cutthroat competition. It may result virtual collapse of destruction, etc. These aspects of matter cannot be assessed by the minister in a vacuum, where the existing society have their area of operation defined. Certainly have a say in the matter of permitting other competitors, they are not given instance be able to enforce any such prohibition. Unless the pre-existing society are heard, registrar himself will not be able to assess the possible damage, destruction, and to this extent, therefore, appellants were justified in their plea. Joint registrar was error in having sanctioned the amendment of the bylaw without notice to them. My lord, this is the judgment. Then, my lord, in 1980, my lord, one more judgment by the division bench. I'm sorry, it's the single bench. Sorry. My lord, paragraph 8 here again. It is also answering to section 12 and 13 of the Act. Para 7 may kindly be.
Yes.
Sri Javli supported the action of respondent number 1, urged that on a true construction of section 12 and 13 of the Act, a notional registration of bylaw from an earlier date was impermissible. 8. A bylaw being subordinate legislation cannot be made in derogation of rule of Act. May kindly may not disease. A bylaw can be framed under and in accordance with the provisions of the Act. A legislature can enact a law retrospectively, but a subordinate legislative authority cannot make a law retrospectively unless same is expressly authorized by the enabling Act. In my opinion, legal principle that a decree made by a superior court in reversal of the decree of the lower court should be deemed to take effect from the date of institution of the plaint on the data so and so. Now pass the exam. Then 9. A statute is the will of the legislature. Fundamental rule of interpretation. All others are subordinate. Statute is to be expounded according to the intent of them, and that is made it. If the words of the statute are in themselves precise, unambiguous, no more is necessary than to expound those words, etc., etc. This is another division bench judgment. These two I cited. A single bench, I'm sorry. First is the division bench, later is the learner single bench. I'm sorry, madam. Ultimate argument on first point which I addressed to Lordship is act or a power conferred upon the registrar to approve the bylaw of a society on perusal of the statute appears to be executive action, but it is coupled with formation of an opinion. When a formation opinion is required or warranted in law, application of mind is very much necessary. In the present case, the resolution was passed on 9/9/2023. Society passed a resolution, raised its finger for amendment is concerned on 24th April 2024. On the day when we raised our finger, this bylaw was not accepted. Then on 30th/4/2021, he accepted the bylaw. Two things I wanted to brought to your Lordship's notice is, despite we alarmed him, see, this is the illegality have taken place, you look into that. What is the nature of illegality is, what is not in agenda, what is not in regular resolution, which is added and manipulated, send it to you. You please examine that aspect of the matter. Why we wanted to say is, our society wanted to sail with Ramanagara constituency. It was not proposed to be amended, enabled to join with another constituency. Now, because of approval and later manipulation, it is thought to be joined with other constituency. We have an objection. At least, forget about others who are not filed objection. We could have been heard in the matter. This is one. Secondly, see the acceptance order. Put it depicting minimum application of mind, at least to the extent of fingers which are raised. My lord, this is first my submission. Secondly, my lord, I ignored. Second point I wanted to raise is this election process and power of election authority. Can it be interrupted when process commenced and any alterations to the delimitation constituency could be permissible without consultation and without concurrence of election authority? This is the second proposition I wanted to address. Let us see how the law is composed. My lord, slightly I would like to take your lordships to Section 39 of the Cooperative Societies Act. My lord, 39 capital A, my lord, chapter 5 capital A, Roman capital 5A. At every general elections of the members of the board and election of the office bearers of a cooperative society, including any casual vacancy to the extent applicable, shall be held under the superintendence of a cooperative election authority. Then the general elections of the members of the board of the cooperative shall be held in 4 stages. Then, provided that cooperative election authority may start preparatory work for preparation of electoral rolls for and conduct of elections during the last 6 months prior to expiry of term of office of the board of a cooperative society. This is first part. Then, my lord, section 39 AA may kindly be seen. The state government shall by notification in the official gazette constitute a cooperative election authority consisting of a cooperative election commissioner and a secretary. Subsection 2.
Yes.
The superintendence, direction, and control of the preparation of electoral roll. My lord, first part. Then, my lord, conduct of all elections of the cooperative society in the state shall be vested with the cooperative election authority. Then, my lord, a cumulative reading of section 39 capital single A and double capital A. It's given hints 2 items. One is the election process, which at the initial stage commencing from preparation of voter list, commencing at least 195 prior to the date of expiry of the term of the office which is existing as of now. That means, my lord, 4th April or April 2024 is the term which expired to the present committee. Election process commence.
Can you data?
April 2024.
Particular date?
Particular date, my lord, appears to be 28th April. I'm not sure, but it would be. That means, my lord, November 2023. 13th November 2023 would be the first day of 195th day commences. 13th November 2023, that was the first day of commencement of 195th day. Now, my lord, this is then, my lord, this area is regulated under the rules. How a time schedule, commencement of process, how that has to be commenced, who has to commence, what you have to be done, everything is provided under Rule 13. My lord, may kindly go to Rule 13. My lord, I would like to request your lordship to go to 13 capital B, my lord, Rules 13 capital B. At page 183 in that book it appears.
Rule?
Rule 13 capital B.
Preparation of electoral.
Cooperative Election Authority. The Cooperative Election Authority may formulate guidelines for preparation of electoral rolls and for conduct of elections of all cooperative societies in the state. Every cooperative society shall furnish such documents and information which the Cooperative Election Authority may require from time to time.
Yes.
Then go to 13 capital D main. The election officer shall, after due verification, send a consolidated list of all cooperatives in the district where elections are due at least 120 days before the date of expiry of the term of office of the board to the Cooperative Election Authority, indicating therein the following particulars: name and address of the society, number of elected directors, date of expiry of term of the office, proposed places where the elections are to be held, etc. These are all the information to be provided. Then 2, the Cooperative Election Authority shall, on receipt of such form from the election officer containing the list of cooperative societies, their elections are due, publish the calendar of events for preparation of election roll and conduct of elections at the board of the cooperative society, indicating the name and addresses of each cooperative society. Well, on reading of the subsequent provisions, it mandates a timetable should be prepared for the purpose of completing the process of election from the stage of commencement. Number 1. Number 2, then what we called that a provisional, indicating your elections to the board of directors would be scheduled on so and so date. That also to be notified. This is the mandate of Rule 13D. Then what procedure contemplated under 13(2)(2)(a) may kindly be seen. The election officer shall take publication steps for publication of voters list who are not eligible to vote in the following manner, namely, for publication of draft ineligible electoral list, the chief executive every cooperative to prepare notice in respect of members not attending 3 out of last 5 annual general body meeting, not utilizing such minimum service, etc. 2, the chief executive of every cooperative shall send above prepared notice to all ineligible members of 15 days prior to 6 months to the date of election of the board by registered post, and other opportunity shall be given to such members. 3, the chief executive of every cooperative shall submit the list of ineligible voters to the election officer along with their objections, and also to produce the records pertaining to absence from general body, etc. Then chief executive officer of every cooperative shall state in his notice that ineligible voters can appear before the election officer between 30 days to 60 days from the date of the notice. Election officer has to hear or dispose of objection. Final list of eligible voters shall. These are all the procedure contemplated under Rule 30. Why I am saying so is, my lord, bylaw could be amended, absolutely no complaint by us. I cannot also, if I say so, I become the fool man. But you should amend according to law, it's our grievance. We have a serious objection to 2 aspects. One is, bylaw you have manipulated what is not in the agenda, you have added into the bylaw and got it approved. That is absolutely error. Secondly, the approving authority who accepted the bylaw, he has not applied the mind. At least, despite a complaint caveat was lodged before him. Thirdly, election process have already commenced by preparation of electoral roll. Then that a process have been commenced. These alterations of delimitations and shifting one from another These are all, if you are invariably to be done, you can done with the consent of the election authority. My first submission is it cannot be done. If it is to be done, you do it only with the consultation of, because once, my lord, 195 days commences, the functions surrounded between the two officers of a cooperative department. One is the society of the cooperative society, another is the election authority, with the electors. This is the only role, and no other body is having any authority to interpole or interfere. In the context of this, my submission is, when once Rule 13D is put into force, when it is operation or it is holding the field, these things are not permissible because ultra-virus act. This is my submission. No, may not know. A point could be raised by the other side, whether preparation of voter list, could it be an election process or not? Well, now this is answered by the Supreme Court in 2000. Later on, it is followed by the learned single judge of this court, where the very proposition what I am addressing, it is addressed by the senior professor, my lord, against me, and I compliment on that day he succeeded, we lost the matter. Let me kindly go to 2001, volume 8, SCC 509.
Yes. Para?
Para 10 may kindly be seen. I made, if a lordship's leave, can I read it from para 8 minutes?
Right.
At page 516.
Yes.
It was then urged that tribunal constituted under the Act has no power to go behind the preparation of the electoral roll. Therefore, the writ petition is maintainable. Learned Counsel also strongly relied upon the decision in the case of Bar Council of India, where Learned Counsel also referred to Section 100 of the RP Act, and the decision of the Sriravant Kuar Chaudhry's case. In sum and substance, argument is that since the breach of rule in preparation of electoral roll cannot be questioned in the election petition before the election tribunal, the tribunal therefore writ petition is maintainable. My lord, answer is at para 9. If the contention of the appellants is that this was a breach of rule of certain mandatory provisions of the rules were not complied with while preparing the electoral roll, the same could be challenged under Rule 81D4 of the rules, etc. Then may kindly go to para 10. In the case of Bar Council of India, so and so, there is no substance in the lord's submission made on behalf of the appellant. Manner of resolving the dispute as to the validity of election is provided for a Rule 34 of Delhi Bar Council rules. This is not an appropriate and adequate alternative remedy to dispute the writ petitioners on that account. Firstly, no clause of 34 overs covers the challenge of election on the ground it has been done in this case. Secondly, election tribunal will not be competent to so and so. Then para 11. In the aforesaid case, this court held that writ petition under Article 226 of the Constitution should not be rejected on account of alternative remedy by way of election petition where, firstly, the challenge is not a ground under the Act or the rules for filing election petition. Secondly, validity of a rule is challenged being ultra-virus and invalid. It is true that tribunal being a creature of an act of the rules, limited jurisdiction, it is not open to so and so, but it is not the case here. Therefore, the decision in Bar Council, it is no help to anybody in case of so and so. Then, my lord, the ultimate answer is paragraph 12. In view of our finding and preparation of electoral roll being an integral intermediate stage in election process of a managing committee of a specified society, make a note, madam. In view of our findings, that preparation of the electoral roll being an intermediate stage in the process of election of managing committee of a specified society, and the election process having been set in motion, it is well settled that High Court should not stay the continuation of an election process, even though there may be some alleged illegality, breach of rules while preparing electoral rolls, etc., etc. Therefore, my lord, this, of course, my lord, we lost the battle. There, what happened was without completion electoral rolls, my lord, elections was thought to be conducted certain society to the state. Somebody have complained to the government. See, this is not fair. No, there is no fair election process in progress. May kindly take note of that. Then, my lord, wherever the election process commenced, that was postponed by the government by a notification. We challenged that. In a batch of writ petitions, my lord, we have argued. This was argued before Honorable Justice M.I. Arun also. Contention we have raised is, referring to the judgment of the Constitution Bench in Lakshmi Bhattcharan Bharati's case, a defect in voter list may not be the reason to postpone the election. That's the principle. Secondly, the process of electoral roll, which it is in progress, it is an independent, and it cannot be, on making that reason, the elections cannot be postponed. It's our argument. When I'm referring to Rule 13, as well as Section 39 capital A, 39 capital AA, the other side, it is heeded by my lord Professor Senior Counsel Ravi Verma Kumar also. After he appeared, we taken a lot of setback there. And the next, after we lost, happily we complimented Mr. Professor also. There, this court learned single judge have taken the view, these rules are mandatory in nature, which has to be followed. Then, my lord, other batch of writ petitions were filed by Tagaraj Nagara Cooperative Bank members, where I have argued the matter, where, my lord, this honorable court have taken the view, referring to this Maharashtra judgment only, it is a matter to be adjudicated in a dispute under Section 70, not in a writ petition under Article 226. Of course, I rendered an effort, referring to that is Ashok Kumar versus Election Commission of India's case, where I argued before your lordship similar matter. We contended that it is not for stalling the election. Our anxiety is election function should be completed smoothly. Therefore, it is available to scrutiny under Article 226 as explained by the Supreme Court in Ashok Kumar case. That was not accepted. We carried the matter to the division bench. It was also confirmed. But I will place those judgment to your lordships along with a memo. This is the two submissions which I undertake to address. There is one more submission which required to be made by two councils, my lord, that is my colleague, Mr. Ravi Shankar, Senior Counsel, and Mr. Jaikumar S. Patil. They are on the point that they proposed as we deliberated. Our captain is here.
Now, it is for the fourth respondent society to defend its action.
Sanjeev.
Huh?
Sanjeev.
And of course, the learned AGA regarding the orders passed by the joint registrar.
Okay, sir. Okay.
ಏನಿದು
ಈಗ ಮಾಡಿದ ಹೊಸ ವಾರದ ರಿಟ್ ಪಿಟಿಷನ್
ಅಲ್ಲ, I don't think it's necessary to go in. One ನಿಮಿಷ. We will put the important issue to the respondents. Let them answer.
ಇದು ಒಂದು ಕ್ವಶನ್ ಸೇರಿಸಿ ಕೇಳಬೇಕಾಗುತ್ತೆ. ನಾನು 2 ನಿಮಿಷದಲ್ಲಿ ತೋರಿಸ್ತೀನಿ. kindly
take this map.
Yes.
ಇಲ್ಲಿ ಒಂದು ಪಿಂಕ್ ಕಲರ್ ನಲ್ಲಿ ತೋರಿಸಿರೋದು ಮೇಲ್ಗಡೆ ಟಾಪ್ ನಲ್ಲಿ ಪಿಂಕ್ ಕಲರ್ ನಲ್ಲಿ ತೋರಿಸಿರೋದು ಬೆಂಗಳೂರು ಸೌತ್ ತಾಲೂಕಾ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಆಸ್ ಇಟ್ ಎಕ್ಸಿಸ್ಟೆಡ್. ಈಗ ಅದನ್ನ ದಕ್ಷಿಣದ ಕಡೆಗೆ ಅಂದ್ರೆ ಕೆಳಗಡೆಗೆ ಇದು ಮಾಡ್ಕೊಂತ ಬಂದು ಕೆಳಗಡೆ ದೊಡ್ಡೇರಿ ಅಂತ ಕಾಣುತ್ತೆ.
They want to extend it.
ಹೌದು, ದೊಡ್ಡೇರಿ ಅಂತ ಕಾಣುತ್ತೆ. ದೊಡ್ಡೇರಿ, ಬನ್ನಿಕುಪ್ಪೆ, ವಜ್ರಹಳ್ಳಿ ಇಲ್ಲಿವರೆಗೂ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
ಆ ಪಿಂಕ್ ಲೈನ್ ಡ್ರಾ ಮಾಡಿದಾರಲ್ಲ ಅದು ಪೂರ್ತಿ.
ಅದು ಇಲ್ಲ, ರೆಡ್ ಅಲ್ಲಿಗೆ ಹೋಗ್ಲಿಲ್ಲ. ಈ ಕಲರ್ ನಲ್ಲಿ ಇಟ್ಟಿದ್ದೀವಿ, ಸಿಮೆಂಟ್ ಕಲರ್ ನಲ್ಲಿ ಇಟ್ಟಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಕೊಂತ ಬಂದು ವಜ್ರಹಳ್ಳಿ ಅವರೇಗೆರೆವರೆಗೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ಆಮೇಲೆ ಕೆಂಚಿಗನಹಳ್ಳಿ ಬಿಟ್ಟು, ತಿಮ್ಮನ ದೊಡ್ಡಿ ಬಿಟ್ಟು, ಕೆಂಚನ ಕುಪ್ಪೆ ಬಿಟ್ಟು, ಹಲಸಮಾರ ದೊಡ್ಡಿ ಬಿಟ್ಟು ಒಂದು ಎಲ್ಲೋ ಲೈನ್ ನಲ್ಲಿ ಒಂದು ರೌಂಡ್ ಹಾಕಿದ್ದೀವಿ, ಓವಲ್ ಶೇಪ್. ಕಲ್ಲಗೋಪನಹಳ್ಳಿ ಒಂದನ್ನ ಅಲ್ಲಿ ಒಂದು ಸೊಸೈಟಿನ ಸೇರಿಸಿ. ಈಗ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಆಸ್ ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಅಂಡ್ ಆಸ್ ಇಟ್ ಈಸ್ ಡನ್, ಫಿಸಿಕಲ್ ಕಾಂಟಿನ್ಯೂಟಿ ಇಲ್ಲದೆ ಇದ್ದು ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿನ ಇದರಲ್ಲಿ.
No, see, what I propose to ask the other side is, let us not go into the details of all this. Adu,
in one sentence.
See, opportunity of hearing should have been given to you. First of all, there should have been a proposal.
That is.
A proposal ittaga, you would have had an opportunity to raise an objection. Since there was no proposal at all, you did not have the opportunity to raise an objection. However, without there being a proposal, they have forwarded the resolution, and therefore.
ಅದನ್ನ ಮಾಡಬೇಕಾದ್ರು.
Yes.
ಈ ಫಿಸಿಕಲ್ ಕಾಂಟಿನ್ಯೂಟಿ ಬಿಟ್ಟು
ಅದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಮೇಲೆ ನಿಮ್ದು
ಅದು ಒಂದೇ ಸೊಸೈಟಿ ಅಂತ ಸಿಲೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಬಿಕಾಸ್
ಆರ್ಬಿಟ್ರರಿ ಆಕ್ಷನ್
ನಿಲ್ಲಬಾರ್ದು,
ಆಯ್ತು,
ಅಲ್ಲಿಯವರು ಯಾರೋ ಒಬ್ಬರಿಗೆ ನಿಲ್ಲಬಾರ್ದು.
No, we are only on the first principles.
Yes, that's that. It's only that. Adding to that, application of mind ಇದ್ದಿದ್ರೆ ಫಿಸಿಕಲ್ ಕಾಂಟಿನ್ಯೂಟಿ ನಾವು ಇದೆಯೋ ಇಲ್ಲೋ ಅಂತ ನೋಡ್ತೀವಿ.
Yes, yes. Have you, has anyone sought to raise objection regarding ward number 5 and 6?
No, 5 and 6 ಇಲ್ಲ.
No, it is only regarding ward number 1.
Yes, ward number 1 you have revenged. ಕಲ್ಲಗೋಪನಹಳ್ಳಿ.
All right.
ಕಲ್ಲಗೋಪನಹಳ್ಳಿ ಒಂದೇ.
So therefore, it is for the fourth respondent and the learned AGA to answer this. First of all, the fourth respondent has to answer on the first principles as to whether there being no agenda, how could you include a board and ask for an amendment?
He may be asked to get that file, my lord, relating to approval is concerned.
Bandru.
Oh, Sanjeev had come.
Allah, we did not ask for all that. Because you have produced the agenda which was sent on notice. It does not contain ward number.
Correct.
That they cannot deny now. Yes, Mr. Sanjeev.
My lord.
If you admit
Well,
that in the notice for amendment.
Yes, ma'am.
Or discussion in the agenda, ward number 1 was not included.
Yes, ma'am.
If you accept that position,
Lord,
then
they themselves.
would it be permissible to add a certain ward?
Yes.
Send it for amendment?
Yes, ma'am.
It would be totally in violation of the principles of natural justice.
My lord, may I request, my lord, 2822 of 2024 ಒಳಗೆ I filed my objections.
ಏನು objection?
ಇದ್ರೊಳಗೆ I have produced all that extracts of the attendance register of the petition.
ಅದಲ್ಲ sir. If you admit that in the notice.
It was notified. It was not.
Ward number 1.
Allala.
See, if you show there was ward number 1, they are out. No difficulty. This repetition itself is not maintainable, that is being drawn. Please wait, sir. You are going on arguing the same point. Please see Whirlpool's case, Supreme Court judgment. There are three circumstances under which the argument of availability of alternative remedy can be rejected outright. There are many circumstances in this case where that argument cannot be sustained. We will come to it later. Yes. Yes, Mr.
Well, para 5 olaga, I just read out that in my objections. It is
If
submitted.
you
that-
admit that ward number 1 was not contained in the agenda, then you are required to answer.
ಅದ ಅಜೆಂಡಾನೇ ನಾನು ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ಅದೇ agenda ಅಲ್ಲಿ, if you admit ward number 1 did not find place, then the question is, how did you include it in the final resolution?
May I request, my lord, one paragraph on the agenda, I just read out.
Yes.
It is submitted that the said in GABM, various subjects were discussed, including amendment to the bylaws. With regard to the proposal to bring the MPCS of various taluks within the jurisdiction of different constituents. Further, though as per item number 10 of the agenda, discussions were held proposing to bring ward number 5, 7 of Ramnagara Taluk Bidadi CMS within the jurisdiction of Bangalore South constituency from Ramnagara constituency. At that point of time, Srimati Renukamma, the president, that is the petitioner, and delegate of the petitioner society spoke and proposed to add the petitioner society, which is in ward number 1, into the jurisdiction of Bangalore South constituency, just like in respect of ward number 5 and 7. And in this regard, discussions were held and unanimously passed a resolution to add the petitioner society, which is in ward number 1 of the Bidadi CMC, which was earlier under the jurisdiction of Ramnagara constituency, into the jurisdiction of Bangalore constituency. An extract of the proceedings GM dated 9/9 is produced here with marked as annexure 2.
In the matter of amendment to the bylaws.
Yes.
These kind of argument.
This could not
cannot
have,
be
yes,
sustained.
yes.
There has to be a specific amendment contained.
Yes.
Only that can be carried out. No question of ivaga for every general body meeting or even a special general body meeting, there will always be the last part of it which says any other matter with the consent of the approval of the chair. But that will not apply to an amendment.
That is there in
For an amendment, there has to be a specific agenda. The members should be put on notice. It cannot be done by statement made by the president of the society. Angala agadilla.
agenda other subjects anta
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. That will not apply to an amendment to the bylaw. That cannot be accepted.
Otherwise also, my lord, now it is already, the bylaw has been amended.
The only way out is to put them back into the same constituency. You continue the elections, then you make a fresh proposal.
How the elections are already held? The elections to those societies have already been held.
ನಮ್ಮ ಸೊಸೈಟಿ
ಅಲ್ಲ ಇವ್ರದ್ದು ಹೋಲ್ಡ್ ಆಗಿದೆ ಎಲೆಕ್ಷನ್ಸ್
ಸೆಕೆಂಡರಿ ಸೊಸೈಟಿ ಎಲೆಕ್ಷನ್ ಬಗ್ಗೆ ನಾವು ಅಳುತ್ತಾ ಇರೋದು.
already been
You are
held.
not following our cry, I don't know.
It has been held.
Sorry.
Election to
The primary society has been held.
Federal society.
has not been held.
It's a primary society has been held.
Adalla sir, it's not about that one. They are aggrieved of the inclusion of them into Bangalore
My lord,
South
what happened, my
constituency,
lord, this is the first
for
step.
which elections are not held.
ಇದು ಮಾಡಿಲ್ಲ.
Therefore, you permit them to participate in
Hello, my
the
lord.
election in the as per the earlier
My lord, it
constituency.
is not for the first time because of the.
I'll have to set it aside. There is no, it's not at all difficult for this court to set aside this amendment.
My lord, earlier also, because of the increase of the members, my lord, this has been done.
ನೀವು
It is not done ಅಂತ.
ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ. You make a fresh proposal after this election. You propose and we want to include them in the Bangalore South. You do it in accordance with law. Let them raise a challenge. But as of now, this amendment which has been carried out without there being an agenda cannot be sustained.
Lord, may I request, my lord, I'll just find out tomorrow, your lordship may take it up in the morning.
Mr. AGA, please read the Whirlpool's case in the Supreme Court judgment. There are three circumstances and under which this argument will not be sustained. ನೀವು ಎಲ್ಲದಕ್ಕೂ ಇದನ್ನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎತ್ತಿ ಇದ್ ಮಾಡಕ್ ಆಗಲ್ಲ. You should understand the problem.
One aspect I want to.
When actions are carried out illegally without affording an opportunity of hearing, violation of principles of natural justice, this argument of availability of alternative remedy cannot be sustained.
My lord, may I request, my lord, if there is any document which notice have been served in advance, I will produce it also, my lord.
Notice agenda
Agenda.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಇಲ್ಲೇ ಇದೆ ನೋಡಿ. ನಿಮ್ಗೆ ಹೇಳ್ಬೇಕು ನೋಡಿ.
ಇಲ್ಲೇ ಕೊಡ್ತೀವಿ ನೋಡಿ. ನಿಮ್ಮ
ನಿಮ್ಗೆ ಹೇಳ್ಬೇಕು.
ಅದನ್ನ ಈಗ ನಮ್ಮ ಅಜೆಂಡಾ ಉಪಯೋಗಿಸ್ತಾ ಇದ್ದೀವಿ. ಅದೇ ನಮ್ಮ ಅಜೆಂಡಾ ಕೇಸ್.
I'll give a direction, setting aside this amendment and permit you to carry on with the election with them in the previous constituency itself. And I'll also give you liberty to, in the future, want to make some amendment, you do it in accordance with. It's as simple as that.
May request.
ಏನು ಎಲೆಕ್ಷನ್ ಏನ್ ಡಿಸ್ರಪ್ಟ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಸರಿ, ನಾಳೆ ಮಾಡಿ.
All right,
ನಾಳೆ.
no problem. ಬರ್ಕೊಳ್ಳಿ.
Before that, my lord, I have one objection, my lord, to this writ petition.
So Siddharth, what is this?
Lord, this
You are a government advocate. Please understand. You have certain limits. You, in these type of cases, you should act like a Queen's Counsel.
I agree, my lord.
You should not go on raising objections like this, as if the officers of the cooperative society are involved in the matter. ಆತರ ಏನು ಇಲ್ಲ ಇಲ್ಲಿ. Why do you want to simply unnecessarily raise objections? Please keep quiet. Yes. On hearing the learned senior counsels for the petitioners, when this court expressed its prima facie opinion that the impugned amendment, insofar as ward number 1 is concerned, being included into the Bangalore South constituency, cannot be sustained, learned counsel for respond number 4 seeks for a short accommodation to secure instructions and make his submissions. Full stop. Release this matter tomorrow at 2:30 PM.
Very well, I'm grateful.
Could it be on Monday, tomorrow and day after some day?
ಅಲ್ಲ ಇನ್ನೇನಿದೆ, what is there in this?
ಅಲ್ಲ Monday ಆಗ್ಲಿ ಅಂತ.
No, if they accept it,
No, it is.
elections can go on, there is no difficulty.
It is principle. ಇಲ್ಲ ಈಗ as of now, there is no election scheduled.
No, elections can go on
ಈಗ
without any difficulty. That's
all
what I
the
say.
Announce
elections to cooperative societies have been postponed
Ah.
till 6th. So after 6th, government has to take a decision.
New order
Therefore,
has to be passed.
Please call it on Monday. All that I am praying is.
10th of June 2024 at 2:30 PM. Full stop. Calendar of events in respect of the society in question shall not be announced till the next date of it.
Better
society,
Better respondent
My
society.
lord, may I request.
Secondary society.
Till date, no order has been passed, interim order. Monday ಮಾಡಿ, Mondayನೇ senior ಕೇಳ್ತಾ ಇರೋದು Monday, otherwise I was waiting. ಅಲ್ಲ, my lord, there should be a fresh order by the government.
Monday, if you still want to argue the matter, you can argue the matter. I will pass orders, no difficulty.
But there was no interim order, my lord.
ಆದ್ರೆ ಏನಂತೆ, so what?
ಅದ್ ಸರಿ.
ಅಲ್ಲ entry ತಾವು ಮಾಡ್ಬಿಟ್ರೆ it will become a precedent.
ಅದಕ್ಕೋಸ್ಕರ
It will open a floodgate. It will open a floodgate. All
we
the
can-
societies are waiting.
I have expressed that I have heard the learned senior.
ಅಲ್ಲ
counsel for the
in that
petitioner.
event,
Friday.
ಆಗ್ಬೋದು.
entry ಮಾಡ್ರು ಬೇಡ.
Interim order ಬೇಡ.
ಅಲ್ಲ it will
Till
become-
then. ಅಲ್ಲಲ್ಲ, ನಾನ್ ಹೆಂಗೆ ಒಳ್ಳೆ ಕತೆ ನೀವು. ಇಲ್ಲ, ನೀವ್ ಯಾವಾಗ್ಲೂ gentleman, ನಾವು gentleman ಅಲ್ಲ.
What happened was, when we challenged at the stage of approval itself, saying that the registrar is doing this mischief.
Lord,
Lord,
six
then I
verbo-
wanted to say this. Then what happened? The learned government advocate said, I will come back to the court by taking instructions and prevented the court from passing interim orders. Matter was posted after 2 days. After 2 days, the order which is presently impugned was passed and then placed before the court. So he took time to ensure that there is an order is passed and then placed before the court. My writ petition has not become infructuous because there is an amendment application filed and the amendment application is in place. Now, I just want to say that because no, I stand by what I said. If not for the date which was taken by him, this honorable court said, without the agenda, where is any question of change? This what was expressed. So let
Friday-
the want to be in place. Not
No, no, Friday it makes no difference, madam.
So I really fail to understand.
ಆಯ್ತು ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
ನಾಳೆ
See, even if you do something, I'll ensure you that I'll pass orders protecting you. Nothing to.
Particularly, I wanted
On.
to say, their apprehension would be if your lordship granted interim order, we send higher bill. We will never send higher bill for. I will promise you.
ಆಯ್ತು 7th of June.
Please.
At 2:30.
Please.
ಹೆಸರು
Number 44, PP Vivekananda.
ಆ ಇವರಲ್ಲಿ ಬರ್ಲಿಲ್ವನ್ರಿ? Serial number 38.
Serial number 38. Not your matter.
You are appearing for the municipality.
Municipality on behalf of Abdullah, my lord, I am not.
Now, what information do you have?
No, I am told, my lord, whether the properties belong to municipality or not. The
No,
information,
what information do you have?
not much, my lord. It is regarding only the ownership of that disputed land. That is not belong to the municipality.
ಅದಕ್ಕೆ ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ? Anything in writing?
No, no. If the 1 week time is granted, Abdullah is filing a statement, it seems.
Lord, one submission. Based on the direction of this honorable court, dated 24/4/2024, they have brought one sketch before this honorable court. That
ಅಲ್ಲಲ್ಲ,
is-
sketch ಅಲ್ಲ. See, we want something from which we can come to a conclusion.
Yes, ma'am.
That the property belongs to so and so.
Yes, ma'am. Belongs to.
ಅದಕ್ಕೆ ನೀವು sketch ಅಲ್ಲಿ ನೋಡಿ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ,
So they have to bring some document.
My lord, may I make one submission?
Yes.
According to the sketch, my lord, this survey number is 93/1B3. 93/1B3, my lord, as per the document placed by the respondent commission, that is a municipality, Udupi municipality. The city municipal commissioner has stated that, my lord, this particular drainage pipeline, the 2.5 inch pipe ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, PVC pipe, ಅದು 93/1B3 ಅಲ್ಲಿ ಹೋಗ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಇಂಪ್ಲೀಡಿಂಗ್ ಆಗಿರೋ ಪ್ರತಿಷ್ಠಾನ ಅವರದ್ದು ಅಲ್ಲ ಸ್ವಾಮಿ.
ಅದನ್ನ ಆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡೋದಕ್ಕೇನೆ to ascertain that one, I am asking what information has been given to you.
Yes, ma'am.
ಇವಾಗ ನೀವು ಸುಮ್ನೆ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ, I brought my lord.
Either they should bring some document.
ಅವರೇನು
First
ಹಾಕಿಲ್ಲ.
people have to bring a document, or the municipality has to bring a document.
My lord,
Or if you have some document to show,
Yes, ma'am.
no, the property belongs to municipality, you can also produce it.
Yes, my lord.
No difficulty.
I am placing before this honorable.
ಏನ್ document?
That RTC, that particular survey number, the RTC stand in the name of my lord, Ratna, not belong from the implead application. Impleading application. Ratna is the, my lord, the owner of the another owner of the, my lord, very same adjacent property. They don't have raised any objection. Only impleading applicant made a raised obligation. This properties belong from us. Please. What officer? Everyone copy. Impleading applicant.
93/1B3.
Yes, my lord. It is in the stand in the name of Ratna, wife of Divangata B. Vittal Sherigar, not in the, my lord, impleading applicant. Impleading applicant is, my lord, Sri Krishna Pratishtana Parisara Seva Samiti.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ.
When it is, my lord, bypassing some other person, my lord, Sri Krishna Pratishtana Samiti, my lord, impleading applicant does not have any role, my lord, to say about the, my lord, bypassing
No, I
the.
have clearly directed last time itself that the would-be city municipality is directed to secure instructions in writing as to whether the property where the sewage line is drawn earlier, is the property belonging to the municipality or whether it belongs to the newly impleted respondent number 4?
It is not newly implemented.
ನೀವು ತಂದಿಲ್ಲ, ಅವರು ತಂದಿಲ್ಲ. On the other hand, he is furnishing a RTC which shows the name of some Ratna.
Ratnam, my lord.
That is 93/1B3, madam.
Yes, ma'am.
ಹೌದು.
Yes.
Kindly look at this, madam. My plaint which I have
ಆಯ್ತು
produced.
sir, I had passed an order last time. What document have you produced now?
Well, my implementing application may be kindly seen.
ಅದರಲ್ಲಿ documents of title.
ಅಲ್ಲ ನನ್ನ ಓನರ್ಶಿಪ್ ನಾನು ಸರ್ವೆ ನಂಬರ್ ಪ್ಲೈಂಟ್ ಅಲ್ಲೇ ಹಾಕಿದ್ದೇನೆ. It's a plaint where suit I have filed against the municipality with regard to this action. That means this, on this property, it cannot be laid down.
Yes.
Page 732 of my implementing application. Description of the plaintiff scheduled property. Now he says that, let him take anybody's land, but not on this land.
ಗೊತ್ತಾಯ್ತು. If it is a property
Immovable
belonging
property
to,
is the Pratisthana, immovable property.
you will not be permitted to.
93/1B1A, my lord.
Page number?
Page number 32 of my implementing application.
Thirty-two.
Yes, my lord. The plaint filed before the court, Sri Krishna Pratisthana, OS 186/23. Kindly look at the description of the plaint property, page 32. Immovable property situated in Shivalli village, Udupi Taluk, covered in survey number 93/1B1A, converted measuring 65.
ಹಾ. ಇದ್ಯಾವುದು ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು? 1B3.
Yes, ma'am. 1B3. Yes, ma'am. Because the survey map is, my lord, according to their own document, municipality document, dated 24/4/2024.
ಬರ್ಕೊಳ್ಳಿ.
My lord may be kindly peruse, my lord.
All right, all right.
Then, my lord, one submission, one memo ಹಾಕಿದ್ದೀನಿ ನಿನ್ನೆ. Our application ಅಲ್ಲಿ injunction order trial court has rejected. Your lordship may kindly peruse the observation of the learned trial court, my lord. I have placed it before it is in the record. 360 ಗೆ ಹಾಕಿದೆ ತಮ್ಮ ಮುಂದೆ.
ಹಾ.
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 9 ಬನ್ನಿ ಸ್ವಾಮಿ. Paragraph number 11 of the, my lord, learned trial court has, my lord, vacated the interim order, injunction order. 11. May I read, my lord? The defendant has produced proceedings taken place 27/7/12/2011 and endorsement dated 22/2023. The proceedings clearly shows that the application of Sri Shashikant Balakrishna Jogi, the CMC, has permitted to connect the UGD to his building, subject to condition in the year 2011 itself. The plaintiff has not produced any document to show prima facie whether the plaintiff has objected to the said permission as on the date of the proceedings or not. The endorsement produced by the defendant shows that municipality has only given permission to reconnect the said UGD, which was already existing as per the proceedings under order dated 27/12/2011. As such being the case, the prima facie document shows that defendant has not given any permission to lay underground drainage pipe or any other pipes on the application of Sri Shashikant Balakrishna Jogi. According to the pleadings, the plaintiff prima facie alleged against the said Shashikanta Balakrishna Jogi and Vimala Jogi with respect to the interference of plaintiff A scheduled property, and document shows that on the basis of application given by the said person, permission to connect the UGD has been granted as per the order dated 27/12/2011 and also granted permission to reconnect the same as per the order dated 22/2/2023. The defendant being a authority is duty bounded to promote social and economic development and to promote safe and healthy environment has acted upon as per the request of the above said person. Such being the case.
ನೀವು ಅಲ್ಲಿ ಒಂಥರ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ ಒಂಥರ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಿದ್ರಿ. ಹಾ?
Your lordship may kindly
Who
see.
can they send you with this kind of instruction?
Your lordship may kindly see annexure L ಅಲ್ಲಿ annexure L 22/2/2023.
And you are not a party to this suit.
Not a party to, my owner is the building owner is the parties to the suit.
And
That
this
is Shashikant Jogi.
and this annexure L is also passed with regard to reconnection, that I am not a party.
My lord,
Subsequently impleed ಮಾಡ್ಕೊಂಡ್ರಾ?
ಇವ್ರು ಬಂದು ಇಂಪ್ಲೀಡ್ ಆದ ತಾವು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲೋ ಮಾಡಿದ್ರಲ್ಲ.
ಅಲ್ಲ ಸೂಟ್ ಅಲ್ಲಿ.
ಸೂಟ್ ಅಲ್ಲಿ, ಎಸ್. ಸೂಟ್ ಅಲ್ಲಿ ಸಬ್ಸಿಕ್ವೆಂಟ್
filed by the MUT against the municipality.
ಆಮೇಲೆ ನಾವು ಬಂದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋ
ಇದ್ರಲ್ಲಿ ಸೂಟ್ ಅಲ್ಲ ಹಾಕೊಂಡಿದ್ರು. So this order has been passed
against the ಮಟ್ ಅಲ್ಲ, Krishna Matt Parisara Pratishthana.
No, that
Is
order,
a
order
trust.
is no appeal.
It is not belong from Matt, my lord. Krishna Mattadalla adu.
ಅಲ್ಲ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ the one that you read out now, you have made submission.
We have made submission, my lord. We have made, we are implementing application under order one rules.
So your submissions also have been considered.
Yes, my lord. Then, my lord, one submission, my lord.
That is the case, then if the parties are directly before the civil court in respect of the same issue, then it has to be decided by the civil court.
Then one submission, my lord. Last date of hearing ಅಲ್ಲಿ ಅವರು ಒಂದು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು by the direction of this honorable court, my lord. 24/4/2024 ಅದರಲ್ಲಿ ಒಂದು ಸ್ಕೆಚ್ ಅಲ್ಲಿ ರೆಡ್ ಇಂಕ್ ತೋರಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಆ ಪೋರ್ಷನ್ ಸರ್ವೆ ನಂಬರ್ 93/13 ಅದರಲ್ಲಿ ಮಾತ್ರ 132 ಉದ್ದ ಪೈಪ್ ಲೈನ್ PVC ಪೈಪ್ ಲೈನ್ ಹೋಗ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ 93/1B3 ಅದನ್ನ ಪ್ರಿಫರ್ ಮಾಡಿದವರು ಮುನ್ಸಿಪಾಲಿಟಿ ಅವರು, ಅವ್ರದ್ದು ಸರ್ವೇರು, ಅವ್ರದ್ದೇ ಇಂಜಿನಿಯರು, ಅವ್ರದ್ದು ಪೊಲೀಸ್ ಕೂಡ ಹೋಗಿದ್ದಾರೆ, ಟೌನ್ ಪೊಲೀಸ್. ಆವಾಗ 93/1B3 ಅಲ್ಲಿ ಹೋಗ್ತದೆ. 93/13 my lord, it is belong from Ratna, not belong from Pratisthana. ಶ್ರೀಕೃಷ್ಣ ಪ್ರತಿಷ್ಠಾನ ಅವರದ್ದಲ್ಲ.
No, anyway,
No, what?
If the same issue is before the civil court,
Yes, ma'am.
then the matter has to be decided by the civil court because it will have the full opportunity to call for evidence.
Till then, my lord, I may be permitted, interim order may be absolute, my lord.
How can you take in mind?
ಅಲ್ಲ, ಅವರದ್ದು ರಿಜೆಕ್ಟ್ ಮಾಡಿ, ಬಟ್ ಏನ್ ಮಾಡಿದ್ರು ಫೋರ್ಸಿಬಲಿ ದೇ, ಮೈ ಲಾರ್ಡ್, ಶ್ರೀಕೃಷ್ಣ ಪ್ರತಿಷ್ಠಾನ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಮೇಡ್ ಎ ಹ್ಯೂ ಹ್ಯಾವ್ ಇನ್ಫ್ಲುಯೆನ್ಸ್, ಮೈ ಲಾರ್ಡ್, ವಿತ್ ಕಮಿಷನ್. ಕಮಿಷನ್ ಕೇಮ್ ಅಂಡ್ ರಿಮೂವ್ಡ್ ಮೈ ಪೈಪ್ಲೈನ್. ಪೈಪ್ಲೈನ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದನ್ನ ತೆಗಿಬಾರ್ದಿತ್ತು. ಮೈ ದಟ್ ಇಸ್ ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್. ಒಂದ್ ನಿಮಿಷ.
What he says that ರತ್ನ ಅವರ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇಟ್ಸ್ ಮೈ ಅಪ್ಲಿಕೇಶನ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ RTC ಅವ್ರು ಯಾರ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ, ಬಟ್ ಮೇಡಮ್ ದೇ ಆರ್ ಮೇಕಿಂಗ್ ಎನ್ ಅಟೆಂಪ್ಟ್ ಟು ಸಿ ದಮ್ ದೇ ಆರ್ ಟೇಕಿಂಗ್ ಇನ್ ದಿ ಪೈಪ್ಲೈನ್ಸ್ ಇನ್ ಮೈ ಲ್ಯಾಂಡ್.
ಅದನ್ನ
That is why they have to seek for him. If they are having any easement right of anything, my lord, they have to seek for either declaration that they have a right over my property.
Civil court has rejected your application for temporary injunction.
That is no under appeal, madam. My appeal is pending. It is before the middle.
And they are also now they have implemented themselves before the.
What they want to, they have to disrupt this well settled area that under beneath this my land they want to take, which I have protested.
My lord, my humble submission, my lord.
Now, so far as so
Municipality has made submissions which go against you.
My lord,
They are defending the matter before the civil court.
yes, my lord. But what my
And
learned,
they have said this underground drainage line was laid way back in the year 2011.
ಯಾರ ಜಾಗದಲ್ಲಿ ಅಂತ ಹೇಳಿ.
Therefore, that has to be decided in
That
this.
is decided. But by what my
If the municipality succeeds,
yes.
now that these people also have implemented there, let the matter be decided by the civil court.
Please,
My lord,
one submission.
one humble submission.
What my learned friend is making the reference with regard to annexure L is concerned, that my lord, there was an annexure. This was given to them, my lord, Shashikant Ojek, without hearing us. Who are the owners? This later they amended, now say that ನೀವು ಈಗ 24ರಲ್ಲಿ ಕೊಡ್ತಾರೆ, 17/5/2024 ನೀವು ಅವರ ಪರ್ಮಿಷನ್ ಇದ್ರೆ ತಗೊಂಡು.
One humble submission, my lord. One existing pipeline is there. Where is the question of removing the same, my lord, by forcibly? My lord, already from 2011 it is in existing.
Now,
And subsequent,
now your lordship may say,
I make a complete my submission, my lord, please. My lord, as per annexure B of the writ petition running page number 18. From 2011, my lord, it is existing. Then, my lord, as per my lord, your lordship may kindly permit to read, that is running page number 42, annexure J, my lord. ವಿಷಯ: ಕುಡಿಯುವ ನೀರಿನ ಜೋಡಣೆ ಕಡಿದು ಹಾಕಿ ನೀರು ನಂತರ ಪೋಲಾಗುತ್ತಿರುವ ಬಗ್ಗೆ ಹಾಗೂ ಒಳಚರಂಡಿ ಜೋಡಣೆಯನ್ನು ಕಡಿದು ಹಾಕಿದ ಬಗ್ಗೆ. ಇದು ಸ್ವಾಮಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇರೋದನ್ನ ತುಂಡರಿಸ್ತಾರೆ ಇವರು ಅವ್ರ ಹತ್ರ ಹೇಳ್ಸಿ. ಆಮೇಲೆ ನಂದು ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗುತ್ತೆ. ಇದು ಯಾವಾಗ ಸ್ವಾಮಿ? 23/3/22. ದೆನ್ ಮೈ ಲಾರ್ಡ್, ಅವರು ಸಿಟಿ ಯೋಜನಾ ನಿರ್ದೇಶಕರು, ಸಿಟಿ ಮೈ ಲಾರ್ಡ್ ಡೆವಲಪ್ಮೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಹ್ಯಾಸ್ ಮೇಡ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂಡ್ ಡೀಟೇಲ್ ವರದಿ. ಐ ಮೇ ಪರ್ಮಿಟೆಡ್ ಟು ರೀಡ್ ಮೈ ಲಾರ್ಡ್. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಡುಪಿ ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬೈಲೆಕೆರೆ ರಾಜಾಂಗಣದ ಕಾರು ಪಾರ್ಕಿಂಗ್ ಬಳಿ ಇರುವ ಶಿವಾನಿ ಬಿಲ್ಡಿಂಗ್ 1ನೇ ಮಹಡಿಯಲ್ಲಿ ಮನೆ ಮತ್ತು ನೆಲ ಮಹಡಿಯಲ್ಲಿ 2 ಮಳಿಗೆಯನ್ನು ತಿಂಗಳಿಗೆ 60,000 ರೂಪಾಯಿ ಬಾಡಿಗೆ ಪಡೆದಿದ್ದು, ಕುಟುಂಬದ ಸದಸ್ಯರೆಲ್ಲರೂ ಇದನ್ನೇ ಅವಲಂಬಿತರಾಗಿರುತ್ತಾರೆ. ಸದರಿ ಮಳಿಗೆಯಲ್ಲಿ ಭಾರತ್ ಜನರಲ್ ಸ್ಟೋರ್ ಮತ್ತು ಕ್ಯಾಂಟೀನ್ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಬಾಡಿಗೆ ಪಡೆಯಲಾಗಿರುತ್ತದೆ ಹಾಗೂ ಅರ್ಜಿದಾರರ ತಂದೆಯವರಿಗೆ ಹೃದಯ ಚಿಕಿತ್ಸೆ ಆಗಿದ್ದರಿಂದ ಆರೋಗ್ಯದ ಬಗ್ಗೆ ಚಿಂತಿಸಬೇಕಾಗಿದೆ. ವಿಷಯ ಹೀಗಿರುವಾಗ ದಿನಾಂಕ 26/3/2021 ರಾತ್ರಿ ಸುಮಾರು 7 ಗಂಟೆಗೆ ನಗರಸಭಾ ಅಧಿಕಾರಿ / ಸಿಬ್ಬಂದಿಗಳು ಹಾಗೂ ರಾಜಕಾರಣಿಗಳು ಸದರಿ ಸ್ಥಳಕ್ಕೆ ಬಂದು ಆವರಣದಲ್ಲಿನ ತಗಡಿನ ಶೀಟನ್ನು ನೆಲಸಮಗೊಳಿಸಿ ಡ್ರೈನೇಜ್ ಸಂಪರ್ಕವನ್ನು ಕಡಿತಗೊಳಿಸಿರುತ್ತಾರೆ. ಹಾಗೂ ಜನರಲ್ ಸ್ಟೋರ್ ಮತ್ತು ಕ್ಯಾಂಟೀನ್ ಪ್ರಾರಂಭಿಸಲು ಉದ್ದಿಮೆ ಪರವಾನಗಿಯನ್ನು ನೀಡದೆ ನಿರಂತರ ಮಾನಸಿಕ ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದಾರೆ. ನಗರಸಭೆ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳು ರಾಜಕಾರಣಿಗಳು ಮಾಡಿರುವ ದೌರ್ಜನ್ಯದ ಬಗ್ಗೆ ನ್ಯಾಯ ಕೊಡಿಸಬೇಕೆಂದು ಹಲವು ದೂರು ನೀಡಿದರೂ ಯಾವುದೇ ಪ್ರಯೋಜನವಾಗಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಯಿಂದ ಪಡೆದ ದಾಖಲೆಗಳ ಪ್ರತಿಯಲ್ಲಿ ಶ್ರೀ ರಾಘವೇಂದ್ರ ಕ್ಯಾಂಚಿನ್ ಇಸ್ಮಾಯಿಲ್ ಎಂಬುವರಿಂದ ಪೌರಾಯುಕ್ತರ ದೂರನ್ನು ಪಡೆದಿರುವುದು ಸದರಿ ದೂರಿಗೆ ಸಂಬಂಧಿಸುವುದಿಲ್ಲ. ಹಾಗೂ ಕಿಡಿಗೇಳುಗಳು ಸದರಿಯವರ ಕುಡಿ ನೀರಿನ ಸರಬರಾಜಿನ ಸಂಪರ್ಕವನ್ನು ತುಂಡರಿಸಿ ನೀರು ಚರಂಡಿಗೆ ಹರಿದು ಹೋಗುವಂತೆ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮೂಲಭೂತ ಸೌಕರ್ಯವಾದ ನೀರು ಮತ್ತು ಒಳಚರಂಡಿ ವ್ಯವಸ್ಥೆಯನ್ನು ಮಾಡಲು ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಉಲ್ಲೇಖ 1ರ ಪತ್ರದಲ್ಲಿ ದೂರು ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈಗಾಗಲೇ ಉಲ್ಲೇಖ 2ರ ಪತ್ರದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಂಡು ಕ್ರಮದ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರಿಗೆ ಹಿಂಬರ ನೀಡಿ ಈ ಕಚೇರಿಗೆ ವರದಿ ನೀಡಲು ಸೂಚಿಸಲಾಗಿದ್ದರೂ ಇಲ್ಲಿಯವರೆಗೆ ಯಾವುದೇ ವರದಿ ಸಲ್ಲಿಕೆ ಆಗಿರುವುದಿಲ್ಲ. ಉಲ್ಲೇಖ 3ರ ಪತ್ರದಲ್ಲಿ ಸದರಿ ದೂರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕ್ರಮ ಕೈಗೊಂಡಿರುವ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಜನಸ್ಪಂದನ ವಿಭಾಗಕ್ಕೆ ಹಾಗೂ ನಿರ್ದೇಶನಾಲಯಕ್ಕೆ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಉಲ್ಲೇಖ 1ರ ದಿನಾಂಕ 10/3/2022 ಮತ್ತು ಉಲ್ಲೇಖ 3 ಪತ್ರದ ಪ್ರತಿಯನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸುತ್ತಾ ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಶೀಲಿಸಿ ಕೂಡಲೇ ನಿಯಮಾನುಸಾರ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಹಾಗೂ ಕೈಗೊಂಡ ಕ್ರಮದ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರಿಗೆ ಸೂಕ್ತ ಹಿಂಬರ ನೀಡಿ ಸರ್ಕಾರದ ಜನಸ್ಪಂದನ ವಿಭಾಗಕ್ಕೆ ಹಾಗೂ ನಿರ್ದೇಶನಾಲಯಕ್ಕೆ ಈ ಕಚೇರಿಗೆ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದೆ. That is, my lord, planning director has made a report. When existing, my lord, pipeline drainage and as well as, my lord, water line is there, repeatedly, my lord, based on the, my lord, implementing applicant instruction, my lord, our commissioner ಅವರು ಬರೋದು ಅದನ್ನ ತುಂಡು ಮಾಡಿ ಹೋಗು. Then, my lord, very next page, my lord. Annexure K 14/3/22 ಉಡುಪಿ ನಗರಸಭಾ ವ್ಯಾಪ್ತಿಯ ಕುಂಜಿಬೆಟ್ಟು ವಾರ್ಡಿನ ಶಿವಾನಿ ಕಾಂಪ್ಲೆಕ್ಸ್ ಕಟ್ಟಡಕ್ಕೆ ಒಳಚರಂಡಿ ಜೋಡಣೆ ಕೋರಿದ ಕುರಿತು ನಗರಸಭೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1 ಅರ್ಜಿಯಲ್ಲಿ ಉಡುಪಿ ನಗರಸಭೆಯ ವ್ಯಾಪ್ತಿಯ ಕುಂಜಿಬೆಟ್ಟು ವಾರ್ಡಿನ ಶಿವಾನಿ ಕಾಂಪ್ಲೆಕ್ಸ್ ಕಟ್ಟಡಕ್ಕೆ ಒಳಚರಂಡಿ ಜೋಡಣೆ ಕೋರಿರುವ ಮೇರೆಗೆ ಒಳಚರಂಡಿ ಜೋಡಣೆ ಕಲ್ಪಿಸಲು ಮಠದವರ ಒಪ್ಪಿಗೆ ಪತ್ರ ಹಾಗೂ ಕಟ್ಟಡದ ಲೀಸಿನ ಕರಾರು ಪತ್ರ, ಲಾಡ್ಜ್ ಬಗ್ಗೆ ಪ್ರವಾಸೋದ್ಯಮ ಇಲಾಖೆ ಅನುಮತಿ ಪತ್ರ ಅಗತ್ಯವಿದ್ದು ಸದರಿ ದಾಖಲೆಗಳನ್ನು ಈ ಕಚೇರಿಗೆ ಹಾಜರುಪಡಿಸಲು ಹಿಂಬರದಲ್ಲಿ ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ಇದು ಅವ್ರದ್ದು ಇನ್ಸ್ಟಿಗೇಷನ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇರುವಂತ ಉಡುಪಿ ಕಾರ್ಯಾಲಯ, ನಗರಸಭಾ ಕಾರ್ಯಾಲಯ. ಈ ಬಗ್ಗೆ ನಿಮ್ಮ ಸಮಾಜದಲ್ಲಿ ಮೂಲಭೂತ ಸೌಕರ್ಯವಾದ ಒಳಚರಂಡಿ ಮತ್ತು ಮರು ಜೋಡಣೆ ನೀಡುವಂತೆ ಕೋರಿದ್ದು ನೀವು ಸದರಿ ಜಾಗದ ಬಾಡಿಗೆದಾರರಾಗಿರುವುದರಿಂದ ಜಾಗದ ಮಾಲೀಕರೇ ಅರ್ಜಿ ಸಲ್ಲಿಸುವಂತೆ ಹಾಗೂ ಸದರಿ ಜಾಗದ ಬಗ್ಗೆ ಈಗಾಗಲೇ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ದಾಖಲಾಗಿದ್ದರಿಂದ ಯಥಾಸ್ಥಿತಿಯನ್ನು ಕಾಪಾಡಿಕೊಳ್ಳಬೇಕಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಹಂತದಲ್ಲಿ ಯಾವುದೇ ಅನುಮತಿ ನೀಡಲು ಅವಕಾಶ ಇರುವುದರಿಂದ ಈ ಮೂಲಕ ತಿಳಿಸಿದೆ. ನವ್ಯ ಪಿ ಆಚಾರ್ಯ, ದಟ್ ಈಸ್ ಪಿಟಿಷನರ್, dated 14/3/2022. Next page, my lord.
ಎಲ್ಲ ಈಗ
1 ನಿಮಿಷ ಸ್ವಾಮಿ. Next page, very next.
In the order of the civil court.
Yes, my lord.
When the municipality itself has taken the stand.
Yes, my lord.
That we have provided underground drainage lines way back in the year 2011 itself.
Please, man.
How can they now take a different stand here?
ಏನ್ ಮಾಡೋ ಸ್ವಾಮಿ ಅವರು ಇದು 7ನೇ ರಿಟ್ಟು ಸ್ವಾಮಿ, ರಿಪೀಟೆಡ್ಲಿ ಹಾಕಿ ಸಾಕಾಗೋಗಿದೆ ಸ್ವಾಮಿ. Because of this order of this one.
One submission, my lord.
One
Who is
submission.
this Shashikant Balakrishna Jogi?
But he is the original owner of the neighboring owner.
The building owner.
Now the petitioner before the your lordship he is a tenant who is on the lease deed, she is running.
ನಾನು ಅಲ್ಲಿಂದ
Original owner is not before the court.
Correct.
This tenant is now before the court.
In the
Now-
name of the original owner itself, a connection was given way back in the year 2011. Is the submission made by the municipality
It is-
before the civil court?
It is for their land. Now what the proposal now is they want to take is mela on the neighboring land which
No,
belongs to the
no,
Krishna Mat Pratisthana, where they made the disturbance in my land.
No.
And well, after making the arrangements that it is belongs to my private property, my lord, it was removed by the municipality.
My lord.
Because they cannot take the private lines well on my property. Now that is why the court, the municipality said, Annexure K,
No.
with regard to this issue, the list is before the civil court. Unless the civil court gives a finding, we cannot provide you the connection in my land.
Then, my lord.
That is the list, my lord, going on before the civil court.
The suit schedule property?
My lord, Eloshment annexure, my lord, that is annexure. Page 33, my lord. Annexure R11. Annexure R11. Annexure R11. Description of the plain property, my lord.
1B, 1A.
Yes, my lord.
65 cents.
Yes.
And the land in which they are drawing the lines now
Yes.
is not this property.
Yes, ma'am. This
They intended to take lines, that is why he protested and filed the suit.
With
How, ಇದರಲ್ಲಿ?
Same property.
Yes.
Then the municipality is has taken a stand. It belongs to it and connection has been given way
That
back
has
in
to
the-
be, that has to be decided and that has to be established
Let it
before
be
the court.
decided by the
That is
civil-
why, my lord, he shall not be permitted to take lines on my land,
Sir, it was already taken in the year 2011.
not in my
It
land.
has been disconnected at your instance.
No, it's not in survey number 93 for 1B1A. Where is the proof, my lord, evidence placed by them that it has been taken in 93 for
Let
1B1A?
it be that,
Yes.
let it be considered.
That by
You
the
will have
civil
to be
court.
given an opportunity.
That by the civil court, my lord.
Adane,
They have to establish that they have a lawful right.
be established.
They have to
Now,
be established.
municipality has taken a stand that a connection was given way back in the year 2011 itself. It cannot be contradicted now.
Because my apparent,
Ultimately, if you succeed,
but
ultimately, if you
my lord,
succeed,
what,
all the lines will be removed.
my lord, what my apprehension is,
Till the suit is
Disposal.
decided,
Yes, ma'am.
it shall remain like this.
Yes,
And they will not be permitted to disconnect it.
yes,
In fact, I'll direct them to reconnect it now.
please.
Let the suit be decided. If you succeed,
my
it
lord,
will be removed.
not in my property, my lord.
In the same property, sir.
Well, not in 93 bar 1B1, it's a matter list before the court. Well, my application for injunction is pending consideration, that is now before the appellate court. Appellate court, it is before the appellate court, my lord. So that is why my appearance is, till then, my lord, let there be status quo maintained as the contended by the annexure K. Your lordship, kindly see annexure K. Your lordship, kindly see annexure K. That is why they said, because now, unless there is a decision.
Sir, ಇವಾಗ ಇದ್ದಿದ್ದ ಕನೆಕ್ಷನ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ ಅವರು.
ಇಲ್ಲ ಅಲ್ಲ ಅವರು ಈಗ ಈ ಹಳೆಯ ಕನೆಕ್ಷನ್
ಗ್ರೀವೆನ್ಸ್ ಆಫ್ ದಿ ಪರ್ಸನ್.
ನಮ್ಮದ್ರಲ್ಲಿ ಮಾಡಿದಲ್ಲ, ಈಗ ಹೊಸತಾಗಿ ನಮ್ಮದ್ರಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದದ್ದು.
ಅದೆಲ್ಲಿ ಬೇರೆ ಕಡೆ ಇದ್ದಿದ್ದ?
ಇಲ್ಲ,
Kindly see. Malad, he cannot mislead the court by this fashion.
There
Kindly
cannot
see.
be two separate connections, sir.
Well, kindly see, that is why commission is obtained. Commission has filed this report. Kindly see here, my lord. Now, yes, kindly see, my implementing application. Now, my lord, they want to take the proposed line. This is my present line, 91B1A. In this, there is no 2011 connection is not here. It is not here. This is my private property.
ಅದು ಆ ಸೂಟ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು ಕನೆಕ್ಷನ್ ವಿಚ್ ಕನೆಕ್ಷನ್
ಅಲ್ಲ ಅವ್ರು ಯಾವ ಜಾಗದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿಯೂ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಡಿನೇ ಮಾಡಲಿಲ್ಲ. ಇದು ನನ್ನ ಜಾಗದಲ್ಲಿ ಹೋಗಿದೆ, ಇದು ಮುನ್ಸಿಪಾಲಿಟಿ ಜಾಗದಲ್ಲಿ ಹೋಗಿದೆ.
ಎಲ್ಲಿದ್ದು ಡಿಸ್ಕನೆಕ್ಷನ್ ಸರ್, ಯಾಕೆ ಮಾಡಿದ್ರು?
ಅಲ್ಲ ಇದು ಈಗ ಹೊಸತಾಗಿ ನನ್ನ ಜಾಗದಲ್ಲಿ 93 ಬಾರ್ 1A ಮಾಡಿದಕ್ಕೆ ಅವ್ರು ಫೋರ್ಸಿಬಲಿ ಮಾಡಿದಕ್ಕೆ ಯುಲಾಸ್ಮೆ ಕೈಲಿಸಿದೆ. ಮೇಡ್ ಅರೇಂಜ್ಮೆಂಟ್ಸ್ ಟು ಟೇಕ್ ಔಟ್ ದೀಸ್ ಲೈನ್ಸ್ ಇನ್ ಮೈ ಲ್ಯಾಂಡ್.
ಕೌನ್ಸಿಲ್ ಹಸ್ ಜಸ್ಟ್ ನೌ ರೆಡ್ ಔಟ್
Yes, my lord.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 11
ಯಾವ್ದ್ರಲ್ಲಿ?
of that order.
OS.
What disconnection are they talking of?
Well, it's not in my land. Now what I am before the lordship.
Fighting there in the suit for the same purpose.
Well, your lordship,
And it has been recorded with the civil court.
Civil court, my lord, with regard to which, my lord, that has to be decided because it is before the appellate court.
No difficulty.
That has to be decided by the appellate court. That is why, my lord, your lordship, kindly see annexure K. ಈ ಬಗ್ಗೆ ಉಲ್ಲೇಖದಲ್ಲಿ ಸಮಜಾಯಿಸಿ ಮೂಲಭೂತ ಸೌಕರ್ಯವಾದ ಒಳಚರಂಡಿ ಮರುಜೋಡಣೆ ನೀಡುವಂತೆ ಕೋರಿದ್ದು.
Please read paragraph number 11 of the order.
Injunction order.
Just now read it out.
The defendant has proceeded taken place on 27 ಅಲ್ಲ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಡೇಟೆಡ್ 22/2/2023.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
ಅದಕ್ಕಿಂತ ಮುಂಚಿನ ಪೇಜ್
ಎಸ್ ಮ್ಯಾಮ್.
ಏನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 4 ತೋರಿಸ್ತಾ ಇದೆಯಲ್ಲ.
2023 ಹೇಳುದು.
There is mention of some Vimala Jogi.
Yes, ma'am.
ಏನ್ ಮಧ್ಯ
ಆಚೆ ಆಗಿದೆ ಸುಮ್ಮನೆ, ಸಾರಿ.
ಅಲ್ಲ ಎನೆಕ್ಷರ್ ಎಲ್ಲನೇ ಹೇಳ್ತಾ ಇರೋದು ಸಿವಿಲ್ ಕೋರ್ಟ್ ನವರು. ಕೈಂಡ್ಲಿ ಲುಕ್ ಎಟ್ ದಿಸ್ ಎನೆಕ್ಷರ್ ಎಲ್ ಮೇಲೋ. ಎನೆಕ್ಷರ್ ಎಲ್ 22/2/2023 ಎಂಡೋರ್ಸ್ಮೆಂಟ್.
Balakrishna Jogi is the owner of the building.
Yes.
It has been recorded that a connection was given way back in the year 2011 itself.
ಇಲ್ಲ kindly see, that's one mistake.
That is what has been recorded here.
One submission. Mela, the defendant has produced. Mela, kindly see.
Yes.
Further, about that, the plaintiff reliably learned that Vimala Jogi obtained permission of the drainage facility to the said building and the defendant has granted them permission to give connection to the underground drainage pipe running through the municipal road existing on a western side Asia property wide order date 22/2/2023. Now, may I kindly see 22/2/2023 may be kindly see annexure L may be, it may be read along with annexure L, my lord. Annexure L ಅಲ್ಲಿ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಡುಪಿ ನಗರ ಸಭೆಯತೆ ರಾಜಾಂಗಣ ಪಾರ್ಕ್ ಹತ್ತಿರ ತ್ಯಾಜ್ಯ ವಿಲೇವಾರಿಗಾಗಿ ಒಳಚೇರಿಸಲಿಕ್ಕೆ ಅನುಮತಿ ನೀಡಲಾಗಿದ್ದು ಸೋ ಅಂಡ್ ಸೋ ಈ ರಂಗೆ ಕೊಳ ಸಂಪತ್ತು ಮೂಲ ಶರ್ತು ಆಕ್ಷೇಪಣೆ ಇಲ್ಲ ಎಂದು ತಿಳಿಸಿ. ಇದು ಮಾಡುವಾಗ ನಮ್ಮನ್ನು ಕೇಳಲಿಲ್ಲ. This was not well unilaterally municipality granted that somebody's land you take as per your facility you take it. Now my lord, after verification of the record my lord, they say that my lord it is now said ಈಗ ಹೇಳ್ತಾರೆ ಈಗ ನೀವು ಇವರದ್ದು ಯಾರು ಇವರದ್ದು ಯಾರ್ದು ಓನರ್ ಆಫ್ ದ ಪರ್ಮಿಷನ್ ಇದ್ರೆ ನೀವು ತಕೊಂಡು ಹೋಗಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾಕೆಂದ್ರೆ ವಿ ಕ್ಲಾರಿಫೈಡ್ ಬಿಫೋರ್ ದ ಮುನ್ಸಿಪಾಲಿಟಿ ಲುಕ್ ಹಿಯರ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಯುವರ್ ಪ್ರಾಪರ್ಟಿ ಆರ್ ಮುನ್ಸಿಪಾಲಿಟಿ ಪ್ರಾಪರ್ಟಿ, ಇಟ್ ಈಸ್ ಅವರ್ ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ.
ಆಯ್ತು.
ಅಂಡ್ ಇದು ಅನೆಕ್ಷರ್ ಎಲ್ಲಿ ಮಾಡುವಾಗ ಯಾವುದು
Paragraph number 11 budi.
The defendant has produced the proceedings stated 11 and endorsement 23. The proceedings clearly shows that on the application of Shashikanta Jogi, the CMC has permitted connect the UGD to the building subject to the condition in 2000 itself. The plaintiff has not produced doctor show prima facie whether the plaintiff has objected to said permission as on the date of proceedings or not. To which, my lord, this when the proceedings are taken, I am not a party to it.
ಆಯ್ತು. See,
The
ultimately, please understand, ultimately you may succeed in the suit. But so long as there is a protection given to the orders already passed by the municipality, giving the connection way back in the year 2011 itself.
ಅಲ್ಲ ಈ ವೇ ಬ್ಯಾಕ್ ಇನ್ 11,000 ಅವರಿಗೆ ಬರುವಂತ ಪ್ರಶ್ನೆಯೇ ಬರುವುದಿಲ್ಲ. ಈಗ 2011 ಇಂದ ನಮ್ಮ ಜಾಗದಲ್ಲಿ ಜೋಡಣೆ ಇರ್ಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್.
You are fighting the case. This is an order passed in your case.
That is why, my lord, that is why I am before the civil court.
Has been given now.
Please.
That way back in the year 2011 itself,
Yes.
connection was given to the owner of the building, Shashikanta Balakrishna Jogi.
Yes.
It has been disconnected now. Please read it.
ಇಲ್ಲ ಡಿಸ್ಕನೆಕ್ಟ್ ಅವ್ರು ಮಾಡಲಿಲ್ಲ.
Read it, sir.
Kindly see, my lord.
Odi.
The endorsement produced by the defendant shows that the municipality has given permission to reconnect UGD, which was already in existence as per the proceeding 2011. Such being the case, prima facie documents show the defendant has not given any new permission to lay underground drainage pipe or any other pipes on the application Jogi. According to the pleadings, the plaintiff prima facie alleged that the said Shashikanta Jogi and Vimala Jogi with respect to the interference of the plaintiff issued property, and the document shows that on the basis of the application given by said person, permission to connect the UGD has been granted as per the order date 11 and also granted permission to reconnect the same as per 23. The defendant being the authority is duty bound to promote social and economic development and to promote safe, healthy environment has acted upon as per the request of the said person. Such being the case, in the absence of those persons, this court cannot grant any injunction against the defendant. The plaintiff has not made a prima facie case. Well, it says that more of the plaintiff has not challenged the permission given the municipality in the year 2011. Well, which 2011 proceedings, I am not at all a part of proceedings. I was not been heard in the matter. 2011 ನಲ್ಲೇ ಅವ್ರು ಇದ್ದದಿದ್ರೆ ಆ ಡ್ರೈನೇಜ್ ಅನ್ನು 2023 ಅಲ್ಲಿ ನಾನು ಈಗ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿ ಅವರಿಗೆ ಒಬ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡುವ ಪ್ರಶ್ನೆಯೇ ಬರುವುದಿಲ್ಲ.
ನೀವು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿರೋದಲ್ಲ.
ಅಲ್ಲಲ್ಲ.
It has been disconnected by the
ಅಲ್ಲ
municipality.
ಮುನ್ಸಿಪಾಲಿಟಿ ಅಂದ್ರೆ ನನ್ನ ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅವ್ರು 2011 ಇತ್ತು ಅಂತ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ. ದಟ್ ಈಸ್ ವೈ ಇಟ್ ವಾಸ್ ಲೈಯಿಂಗ್ ಆಸ್ ಆನ್ ದ ಇಯರ್.
Issue will be decided finally.
Yes.
By the civil court.
ಅದು
If the sewage line has been disconnected, it has to be reconnected.
Sewage.
You proceed to pursue
sewage line. ಅಲ್ಲ
as and when you succeed.
Yes, my lord, sewage
lines will be disconnected permanently.
ಆಮೇಲೆ ಸೀವೇಜ್ ಲೈನ್ ಫ್ರಮ್ ದ ಇಯರ್ 2011 ಇಂದ 15 ವರ್ಷದ ತನಕ ಲೈನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಅವರಿಗೆ ಇಷ್ಟವರೆಗೆ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಆಗ್ಲೇಬೇಕಿತ್ತಲ್ಲ ನನ್ನ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ. How I can ಮೇಲೆ in the year 2020 all of a sudden I can file a fresh suit to my lord stating that my lord 23 ಅಲ್ಲಿ ನೀವು ನನ್ನ ಜಾಗಕ್ಕೆ ಬಂದಿಗೆ ಲೈನ್ ಕನೆಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ. That is why my suit is for interfere. Don't interfere my land. Don't interrupt anything. Or else, where is the question now, my lord? They are making the proposal to connect this line. That is why I produce the photograph. This is the new drawn line which is sought to be now taken. Kindly look at the photograph. My lord, kindly see. Kindly see this. Look at this, my lord. They are now, my lord, saying that this their compound was they now opened. Where is the question of disconnection? It is their compound. So that is why, my lord, when they want to propose the fresh lines in my land, so I protested and filed a suit for injunction. Kindly look at this, my lord. Why they have to take up the dig up the lines in my land? If it was already there in my land, kindly the connection is made a fresh. ಇಲ್ಲಿ ಕಂಪೌಂಡ್ ಹೋಲ್ ಮಾಡಿದ್ದಾರೆ ಈಗ ಫ್ರೆಶ್ ಆಗಿ.
What is the suit that you have filed against the municipality?
Pardon, my lord.
What is this suit that you have filed
Suit against my lord, they are refraining them from drawing the lines, my lord, with these free lines of this sewage lines in my land. In 93/1. Municipality may say that,
that is the main issue.
Yes, that has to be considered by the list in the before civil court.
Who are alleging
Yes,
that
my
the
lord.
property belongs to me.
Yes.
They cannot permit any other person or they themselves cannot lay a sewage line,
ಅದಕ್ಕೆ ಮಾಡೋದು
drinking water line
my lord,
in my property.
if such is the case, my lord, if your lordship has to believe that of the year 2011, where is the question of the petition making an attempt to draw the new lines? Well, across my land, this property, well, which is already settled in this fashion, by disrupting this well settled possession of the land, taking out a new pipeline. And 1 minute, taking up the new pipelines, my lord, and drawing this sewage water in and across my land. Well, I am entitled to protest it because it's my private property.
Land is belong from.
My lord,
not
I
them,
can
my lord.
understand, well, I can understand if there is certain manhole arrangement is already available with regard to the municipality drainage, my lord, I should not oppose. Because my lord, everybody is entitled to make arrangements for sewage facility, but not in this fashion, my lord, taking the fresh lines across my land by making the new pipeline. So this should be stopped. My lord. That is why my ask before the court. Well, the court has to decide whether I am entitled, they are entitled to take up the pipelines well, through my land. It is before list before the court.
Disconnect ಮಾಡಿರೋದು ಜಾಗ ಇಲ್ರಿ ನಿಮ್ದು.
Yes, my lord.
Please show the photograph.
That is at my writ petition, my lord. Last
Same
annexure,
photograph.
1 ನಿಮಿಷ, please. Annexure M4, my lord, running page number 50. Last annexure, my lord. Last first one. ಇದರಲ್ಲಿ ಪೈಪ್ ಅಲ್ಲಿ ಸೈಡ್ ಕಿತ್ತು ಹಾಕಿದ್ದಾರೆ ನೋಡಿ sir. ಅಲ್ಲ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ.
ಎಲ್ಲಿಂದ?
ಅಲ್ಲಿ ಒಂದು ಹೋಲ್ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಆ ಹೋಲ್ ಕೆಳಗಡೆ ಬಂದು ಸೈಡ್ ಅಲ್ಲಿ ಹೋಗ್ತಿತ್ತು ಸ್ವಾಮಿ, ಅಲ್ಲಿಂದ ಕಿತ್ತು ಸೈಡಿಗೆ ಹಾಕಿದ್ದಾರೆ. ಆ ಹೋಲ್ ಅನ್ನು ಕೂಡ ಆಕ್ಚುಲಿ ಅಷ್ಟು ದೊಡ್ಡ ಹೋಲ್ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಕೀಳ್ಬೇಕು ಅಂತಾನೆ ಆ ತರ ಮಾಡಿದ್ದು. ಅದಕ್ಕಿಂತ ಮೊದ್ಲಿನ ಇದರಲ್ಲಿ ಗೊತ್ತಾಗ್ತದೆ ಸ್ವಾಮಿ, ಒಂದು ಕಲ್ಲು ಶೀಟ್ ಹಾಕಿ ಅದರ ಪೈಪ್ ಅನ್ನ ತಂದಿದ್ವಿ. ಅದನ್ನ ಅಲ್ಲಿ 1 ನಿಮಿಷ ಸರ್, ಪ್ಲೀಸ್ ಪ್ಲೀಸ್. ನೀವು ನಾನು ಆಮೇಲೆ ನೀವು ಮಾಡಿ ಸರ್. M3 ಇಂದನೂ ಕೂಡ ಕಾಣಿಸ್ತದೆ ಸ್ವಾಮಿ. ದೆನ್ ಮೈ ಲಾರ್ಡ್, ಪೈಪ್ ನ M2 ರನ್ನಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 48 ಅಲ್ಲಿ ಆ ಪೈಪ್ ನೆಲ್ಲ ರಾಶಿ ಹಾಕಿದ್ದಾರೆ ಸೈಡ್ ಅಲ್ಲಿ, ಕಿತ್ತ ಹಾಕಿರೋ ಪೈಪ್ ನೆಲ್ಲ. ಅದನ್ನ annexure M1 ಅಲ್ಲೂ ಗೊತ್ತಾಗ್ತದೆ ಸ್ವಾಮಿ.
ಹೆಂಗ್ ಹೋಗ್ತಾ ಇತ್ತು? ಇಟ್ ವಾಸ್ ಗೋಯಿಂಗ್ ಆನ್ ದ ಡ್ರೈನ್.
ಡ್ರೈನ್ ಅಲ್ಲೇ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಮಲ್ಲ. ಇದೀಗ ಡ್ರೈನ್ ಆದ್ರೆ ಸ್ವಾಮಿ, ಇದೀಗ ಡ್ರೈನ್ 1 ನಿಮಿಷ ಸರ್, ಡ್ರೈನ್ ಆದ್ರೆ ಈ ವಾಲ್ ಸೈಡ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇತ್ತು ಸ್ವಾಮಿ, 2 ಇಂಚ್ ಪೈಪ್
ಹೋಗಿ ದೆನ್
ಅಲ್ಲಿ ಯುಡಿಜಿಗೆ ಕನೆಕ್ಷನ್ ಆಗಿತ್ತು.
ಮ್ಯಾನ್ಹೋಲ್.
ಇವರು ಲೀಸ್ ಹೋಲ್ಡರ್, ಇವರು ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ಸ್ ಅಲ್ಲ, ಇವರು ಪಾರ್ಕಿಂಗ್ ಏರಿಯಾದಲ್ಲಿ ಹಣ ತಕೊಳ್ಳೋಕ್ಕೋಸ್ಕರ ಲೀಸ್ ಹೋಲ್ಡರ್, ಇವರು ಟ್ರಸ್ಟ್ ಅವರು, ಪ್ಲೈಂಟಿಫ್ ಅವರು, ಇವ್ರು ಪ್ರಾಪರ್ಟಿ ಓನರ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇವರು ಲೀಸ್ ಹೋಲ್ಡರ್ಸ್, ಇವರು ಪ್ರಾಪರ್ಟಿ ಓನರ್ ಅಲ್ಲ. ಅವ್ರು ಹೇಳಿ ಹಾಗಾದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಓನರ್ ಅಂತ.
ಕೃಷ್ಣ ಮಠ ಪ್ರತಿಷ್ಠಾನ ಬಿಲಾಂಗ್ಸ್ ಟು ದ ಕೃಷ್ಣ ಮಠ ಓನ್ಲಿ. ಪ್ರತಿಷ್ಠಾನ
ಇವರು ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಯಾವ್ದು ದುಡ್ಡು ತಗೊಳ್ಳಿಕ್ಕೆ
handing because of this reason
ಪಾರ್ಕಿಂಗ್ ಏರಿಯಾದಲ್ಲಿ
cannot commercial activities. The Pratisthana is must consist of the pontiff. Swamiji is also one of the office bearer. Now Yelos may kindly see you ಹೇಳ್ತಾ under
ಲೀಸ್ ಹೋಲ್ಡರ್ ಸ್ವಾಮಿ, ಇವರು
exact
ಡಿವೋಟೀಸ್ ಬರ್ತಾರಲ್ಲ, ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಮಾಡ್ತಾರಲ್ಲ, ಅವ್ರ ಹತ್ರ ಹಣ ತಕೊಂಡು ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಅಲ್ಲಿ ಮೇಂಟೈನ್ ಮಾಡ್ತಿರುವ.
This is petitioner's property fully surrounded by the compound wall.
No man.
Kindly look at this. This is the common rainwater drainage.
ರೈನ್ ವಾಟರ್
ಅಬರ್ಟಿಂಗ್ ಇಲ್ಲಿ ಅವರಿಗೆ ಡ್ರೈನೇಜ್ ವಾಟರ್ ಅವರಿಗೆ ಸೀವೇಜ್ ವಾಟರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಿಡ್ಲಿಲ್ಲ. ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ ಇಟ್ ಇಸ್ ಅ ಕಾಮನ್ ರೈನ್ ವಾಟರ್ ಡ್ರೈನೇಜ್. ಇದು this property and my property completely bifurcates each other. He has to establish that before beneath this land as on 2011 in the either under already a pipeline is going and that has been joined the.
If you admit that there is a drainage, stormwater drain running between the two properties.
ಡ್ರೈನೇಜ್ ನಾನು ಒಪ್ತಾ ಇಲ್ಲ. ದಿಸ್ ಇಸ್ ದ ಬೈಫರ್ ಅಲ್ಲ, ಇದು ಡ್ರೈನೇಜ್ ಅಲ್ಲ, ಇದು
ವಾಟರ್ ಡ್ರೈನ್
ಅಲ್ಲ, ಇದು ಮಳೆ ನೀರು ಹೋಗುವಂತ ತೋಡಿ.
ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಡ್ರೈನ್, ಇಟ್ ಡಸ್ ನಾಟ್ ಬಿಲಾಂಗ್ ಟು ಯು.
ಇದು ಕಾಮನ್ ಬೈಫರ್ಕೇಟಿಂಗ್ ದ ಪ್ರಾಪರ್ಟಿ.
If the petitioner is permitted to draw a line on top of the storm water drain and get the same connected to the manhole in the road, what is your difficulty?
ಇಲ್ಲಿಂದ ತಗೊಂಡು ಹೋಗಿ ಅವರಿಗೆ ಮ್ಯಾನ್ಹೋಲ್ಗೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಮ್ಯಾನ್ಹೋಲ್
ಮಾಡಬಹುದಾ?
ನಾಟ್ ಅಕ್ರಾಸ್ ಮೈ ಲ್ಯಾಂಡ್.
All right, Berkeley. Please do the same way. You take it through the drain, get it connected, and let the suit be decided. Please.
ಇವರು ಲೀಸ್ ಹೋಲ್ಡರ್ ಅನ್ನೋದಕ್ಕೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ. Please.
Now you have implemented yourself there. You have implemented in the suit.
Yes, ma'am.
All.
Well, so far my instructions are concerned, I have a doubt that whether they are implemented or not. Because this injunction application between me and the municipality.
There is an observation made by the court itself.
That is regarding the document. Now, with
Which was,
regard,
no, which was read out just now. It says without the presence of those parties.
ಅಲ್ಲ ಅದು observation.
Not decided.
Without other observation ಅಲ್ಲ ನಾನು ಇಂಪ್ಲಿಮೆಂಟ್ ಅವ್ರು ಮಾಡಿದಾರ ಇಲ್ವಾ ಅಂತ ಹೇಳೋದಕ್ಕೆ.
The grievance of the petitioner is that
ಓದಿದ್ದೆ ಬ್ಲಾಂಕ್ ಆಗಿಲ್ಲ ಎಲ್ಲಿ ಬಂತು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
a sewage
Drainage.
pipeline which was connected from the canteen bar shop premises belonging to the petitioner has been disconnected without prior notice and without affording an opportunity of hearing to the petitioner. We stop. The petitioner continues that she has established a small business grocery shop and charts canteen by the name, inward commercially, Bharat Canteen, which is situated at the Tenkapete, Udupi town. Full stop. It is contended that the petitioner is a graduate and she intends to stand on her own leg, and therefore she has ventured into establishing the small unit. Full stop. The petitioner entered into a lease agreement with the owner of the property bearing door number ಅಷ್ಟೆಲ್ಲ ಇದೆಯನ್ರಿ.
ಅದರ್ವೈಸ್ ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, annexure N ಅಲ್ಲಿ ಮೂರನೇ ಕಾಲಮ್ ಮೇಲೆ ಡೋರ್ ನಂಬರ್
ಅದರಲ್ಲಿ
8-2-88
that is also in dispute for the reason. Well, without obtaining the license, she has put up the second construction building of the building. Now they have issued the notice, my lord, for taking eviction process. Without authority, my lord, they obtained sanction plan without license. They put up the second construction of the building. Now recently 27/5, they issued a notice. That without
Hardly.
so ಅದರದ್ದು ಸಮೇತ ಅದರದ್ದು ಡ್ರೈನೇಜ್ ಫೆಸಿಲಿಟಿ ಸಮೇತ ಇವರು ವಿದೌಟ್ ಅಥಾರಿಟಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಟ್ಟಿದ್ದಾರೆ ಮೇಲೆ.
Let the municipality take action in accordance with law. There is no difficulty.
Please. Because my lord, if that is unauthorized construction of building, if these kind of facilities are provided, my lord, this kind without unauthorization, my lord, they are taking it all these drainage facilities.
Door number 8-2-86 D2.
capital D2. Yes.
Shivani complex,
Near Geeta.
Geeta Mandira, Bailakere, Sri Krishna Mat, Car Street,
Car Street.
Car Street. For a period of 5 years, commencing from 15/3/2021. Correct?
Yes, ma'am. Till it is renewed, my lord, license. Till it is.
Full stop. It is contended that the petitioner has been running the shop from the year 2021. Full stop. However, the water connection and drainage connection were severed during the month of December 2021.
It is submitted that for the purpose of business, petitioner made a letter notice through her advocate dated 19/7/2021 for necessary 11 ಅಂತ ಹೇಳಿದ್ರೆ 21ಕ್ಕೆ ಅವರು representation ಮಾಡ್ತಾರೆ 10 ವರ್ಷ ಇಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ. If that would have been the connection. Kindly look at the retention ink page 3. It is submitted that for the purpose of business, petitioner made a letter notice through her advocate dated 19/7/21 for necessary reconnected drainage system. However, the respondent authority not consider the representation.
ಮಧ್ಯದಲ್ಲಿ ಹೊಡೆದಾಕಿದ್ದು ಸರ್ ರೀಕನೆಕ್ಷನ್ಗೆ ಅನೆಕ್ಷರ್ ಜೆ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲಿ ಅರ್ಲಿಯರ್ ಸಿಸ್ಟಮ್ ಡ್ರೈನೇಜ್ ಸಿಸ್ಟಮೇ ಇರಲಿಲ್ಲ ಅಲ್ಲಿ.
ಅಷ್ಟೇ.
Full stop. The petitioner later came to know that the fourth respondent, Pratisthana, is claiming to be the owner of the property, and the disconnection was done at the instance of the fourth respondent. Full stop. It is contended that the fourth respondent has also filed a suit
Page 27.
in OS number 186 of 2023. Against the would-be
City
municipality seeking permanent injunction, to restrain. ಎಲ್ರಿ ಅದು ಪ್ಲೇಂಟ್
ರನ್ನಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 37.
Annexure R11 page.
ಅವ್ರ ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್.
ಹೌದು.
Annexure R11 page 27. Annexure R11 page 27.
ಏನ್ ಹೇಳ್ದೆ? The
Millard, one submission.
officials of the municipality from granting permission to any individual or any member of the public to lay underground drainage pipes or water pipes over the plaint A schedule property, or in any way interfering with the peaceful possession and enjoyment of the plaint A schedule property.
Yes. And contention para 3, my lord, plaintiff. Contention para 3 of the plaint may be listed. The plaintiff further submits that on the eastern side of the plaint A schedule property, there exists a building belonging to the one Shashikanta Balakrishna Jogi and one Vimala Jogi. How para 3 of that plaint document, plaint para 3.
Document.
How plaint in our everments, page 30, ink page 30, my lord. Ink page 30, para 3 ಅಲ್ಲಿ. The plaintiff further submits that on the eastern side of the plaintiff issued property, there exists a building belonging to the one Shashikant Jogi so and so is carrying on the business of lodging hotel shops without proper license. The public visiting the said presence concern over throwing the plastic plates, cups, etc. over the plaintiff property, and the said persons are directing their customers to use car parking space covered by the plaintiff issued for preparing their food for using gas, etc. Further, the said building has no proper drainage facility and sewage water of that building has been causing nuisance to the plaintiff property and in the locality also. There is no road access to the said property. Several complaints were made to the defendant in that regard, and till today no action is taken by the defendant in connection with the said illegalities. And the earlier para speaks about the ownership of the land by the Krishna Mutt, represented by Pontiff, now represented to the Pratishtha. Earlier paragraph. Last bottom.
It is also contended in the plaint that the plaint A schedule property belongs to the Sri Krishna Mutt, Udupi. And the fourth respondent trust herein is managing the affairs of the car parking area.
Yes. Situated in the plaintiff issued property.
ಈ 65 cents ಬರೀ ಕಾರ್ ಪಾರ್ಕ್ ಏರಿಯಾನ
ಅಲ್ಲ ಎಂಟೈರ್ ಲ್ಯಾಂಡ್ ಬರ್ತದೆ. ಈಗ ಅವರು ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಮಾಡ್ತಾ ಏರಿಯಾ ಇರುವಂತದ್ದು ಆ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಬರ್ತದೆ. ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಬರುವಂತದ್ದು ಅದು ಬರ್ತದೆ. ಬಟ್ ದ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಏರಿಯಾ ಕಾಸ್ಟ್ ಮೈಲಾಡ್ ಇನ್ ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಏರಿಯಾ ವೇರ್ ದೇ ಆರ್ ಇಂಟೆಂಡಿಂಗ್ ಟು ಟೇಕ್ ಅಪ್ ಲೈನ್ಸ್.
Next para, learned counsel for the petitioner. Points out in the plaint filed by the fourth respondent that an averment is made in the plaint itself that one Shashikanta Balakrishna Jogi and Vimala Jogi are the owners of the neighboring property bracket ಅಲ್ಲಿ where Shivani complex is put up and the petitioner is a lessee in a portion of the building, close bracket, and that the said owners are carrying on business of lodging, hotel, shops without proper license, etc. Full stop. The learned counsel would therefore submit that the fourth respondent has approached the civil court seeking directions to the Udupi city municipality, but the owners of the building are not made parties, and neither is the petitioner made a party to the proceedings. Full stop. Nevertheless, attention of this court is also drawn to an order dated 19th of January 2024 passed on IA number 11 filed by the fourth respondent hearing for plaintiff.
IA number 2.
IA number 2. Under order 39 rule 1 and 2 seeking to restrain the defendant and its officials from granting permission to any individual or any member of the public to lay underground drainage pipes or water pipes on the plaintiff A schedule property till the disposal of the suit. Full stop. learned counsel submits that the trial court has noticed in paragraph number 11 that the defendant, bracketly, Udupi City Municipality, close, has produced proceedings taken place on 27/12/2011 and the endorsement dated 22/2/2023, whereby it is clear that application was filed by Shrikanta Balakrishna Jogi and the municipality permitted connection of the underground drainage bar sewerage lines to the building subject to conditions, comma, way back in the year 2011 itself. Full stop. Learned counsel submits that the trial court, while noticing that prima facie the documents would reveal that the municipality has not given any new permission to lay underground drainage pipes or any other pipes, and accordingly the application has been rejected. Full stop. The learned counsel would also submit on instructions that the petitioner has implicated herself in the suit. Full stop. The learned counsel would therefore submit that it is clear from the documents available on record that the underground drainage pipes that were laid connecting the premises of the petitioner to the manhole on the main road, which is also known as Sri Krishna
Car parking metro.
Car road.
Car road.
Was subsequently disconnected at the instance of the fourth respondent. Full stop. The petitioner has approached the respondent municipality seeking reconnection of the sewerage lines to enable the petitioner to carry on her business. Full stop. Next para. Per contra, learned counsel for the fourth respondent would contend that even as per the averments made in the memorandum of writ petition, the petitioner entered into a lease agreement only
Next year, see.
on 15/3/2021. And therefore, the petitioner cannot claim that she secured orders at the hands of the municipality for putting up the sewerage lines. Full stop. Even otherwise, comma, it is contended that since the fourth respondent has already approached the civil court seeking permanent injunction and restraint orders against the municipality, comma, the petitioner cannot be permitted to have the sewage lines running on the property belonging to the Krishnamat or the fourth respondent. Full stop. Next para. On the previous occasion, this court had directed the learned counsel for the municipality to
Submit report.
submit any information in writing as to whether the property where the sewage line was drawn earlier is the property belonging to the municipality or whether it belongs to respondent number 4. Full stop. Although learned counsel for the 4th respondent sought to submit that the property does not belong to the municipality, nevertheless, having regard to the stand taken by the municipality before the civil court, it appears that the municipality is defending itself in the suit while contending that the connection was given way back in the year 2011 itself. Full stop. Next para. Having regard to the fact that the 4th respondent has already approached the civil court and orders have been passed by the civil court on the interlocutory applications filed by the 4th respondent herein, this court is of the considered opinion that the petitioner's premises should be reconnected with the sewage lines,
Drainage.
till the disposal of the suit. Full stop. This court, having perused the photographs produced and which have been placed on record, finds that there is a stormwater drain running between the Shivani complex and the property which is described as A schedule property in the plaint. Full stop. This aspect of the matter has not been denied by the learned counsel for the 4th respondent. Full stop. In that view of the matter, the municipality.
One submission, and that drainage, that normal rainwater bifurcates both lands.
Ade ಹೇಳ್ತಾ ಇರೋದು. There is a storm water draining, a
Yes.
drain
Bifurc-
between the two properties. ಏನು ಹೇಳಿದೆ? In that view of the matter, the municipality, Udupi city municipality is hereby directed to reconnect the sewage lines to the premises of the petitioner, which shall run through the stormwater drain,
UGD,
so that it will get connected to the manhole in the main road. Full stop. Next para. The writ petition is accordingly disposed of, directing the commissioner, Udupi city municipality
first respondent
to reconnect the sewage lines to the premises of the petitioners.
limited period.
Not disturbing the plantation problem.
ಅದೇ ಹೇಳಿದ್ನಲ್ಲ, it will run on the stormwater drain.
Please, side out as it.
We had already given the permission to connect my lord, subject to my lord, objection from the land that we already issued.
ಆಗಿದ್ಯಾ?
Yes,
Connect ಆಗಿದ್ಯಾ?
connect
ಇಲ್ಲ,
already. We had
ಅವ್ರು-
given permission to him.
ನಮ್ಮ ಜಾಗದಲ್ಲಿ ಹಾಕ್ಬೇಕಾದ್ರೆ ನಮ್ಮ ಹತ್ರ ಒಪ್ಪಿಗೆ ತಗೊಂಡು ಹಾಕಿ ಅಂತೀವಿ.
We had given a permission.
ಅದಲ್ಲ
ಅಲ್ಲ ಇವಾಗ if it is running on the stormwater drain,
Yes, we have.
I don't see any difficulty.
ಅಲ್ಲ ಸ್ಟಾಮ್ ವಾಟರ್ ಡ್ರೈನ್ ಅಲ್ಲಿ
You are
ತಗೊಂಡು
also not claiming
ಅಲ್ಲ,
that the
storm-
stormwater drain belongs
ಅಲ್ಲ
to
ದೇ
you.
ಆರ್ ಮೇಕಿಂಗ್ ದಿ ಲೈನ್ ಮೈ ಲಾಟ್ ಪ್ರಾಪರ್ ಡ್ರೈನೇಜ್ ಫೆಸಿಲಿಟಿ ಮಾಡ್ಕೊಂಡು ಅವರು ಮಾಮೂಲದಲ್ಲಿ ಪೈಪಿನ ಮುಖಾಂತರ ತಕೊಂಡು ಅವರ ಮುನ್ಸಿಪಾಲಿಟಿಯ ಒರಿಜಿನಲ್ ರೋಡ್ ಸೈಡ್ ಅಲ್ಲಿ ಹೋಗೋತಾ ಅಲ್ಲಿ ಡ್ರೈನೇಜ್ ಲೈನ್ ಇದ್ರೆ ಹೋಗೋದಕ್ಕೆ ನಮ್ ತಕರಾರಿಲ್ಲ. ಅವ್ರು ಹೇಳುದಂತ ಹೇಳಿ ನಾವು ನಮ್ಮ ಪ್ಲೇನ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಬಂದು ನೀವು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅನ್ನು ಡಿಗ್ ಮಾಡಿ ನೀವು ತಕೊಂಡು ಹೋಗಿ ಬರ್ಬೇಕು, ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ ಬರಬೇಡಿ ಅಂತ.
Within 2 weeks or 3 or from the date of seven.
as expeditiously as possible at any rate.
In that
Within
canteen,
a period of 7 days from the date of receipt of a copy of this order.
please.
My lord, your lordship may
One
kindly
small
make.
correction, my lord, we have not disconnected. He himself filed a complaint stating that, my lord, both respondents disconnected in the petition itself, yes. Where your lordship said, my lord, municipality has disconnected. That is not so. Therefore, he filed a complaint stating that both respondents disconnected.
ಅವರ ಇದರಲ್ಲಿ
Municipality
ಇವರ
disconnected.
ಆರ್ಗ್ಯುಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ನಲ್ಲ ಅದರಲ್ಲಿ the learned counsel would also submit that the municipality did not disconnect the sewage lines of the petitioner. Full stop. In fact, it has been alleged by the petitioner that at the instance of the fourth respondent, the sewage lines have been disconnected.
He himself disconnected, as per annexure A.
Deeply obliged. Grateful. Deeply obliged.
All contentions are kept open to be considered before the civil court in the suit filed by the fourth respondent.
With regard to the disposal, no opinion is expressed, so that with regard ಅದೊಂದು ಹೇಳಿ.
All contentions are left.
Shall be uninfluenced ಅಂತ ಹೇಳ್ಬೇಡಿ.
Any observations made during the course of this order shall not affect the rights of any of the parties before the civil court.
Obliged.
Millets with kind leave, Millets.
Interim order may be extended.
Yavudu? Matters that have not reached, there is no need for extending.
Millets with kind leave.
If you open the file now, you will find the previous order. Where is the need for extending it now? Not
Millets serial number 54, Millets covered by the order of this honorable court. Millets last week it had come up, serial number 54. My lords had told that Sir Mad Bunny next date I'll consider for interim order. It's covered by the decision of this court. Millets, my request for either tomorrow or Monday.
ಏನದು?
Millets, the relinquishment of land free of cost anta condition imposed ಮಾಡಿದ Nelmangla town municipality. Millets, similar covered matter ಅಲ್ಲಿ my lords have given order, Millets, that let my plan be considered. I will leave the space, Millets. Interim order, my lords, has a
Serial number 54.
please, but similar interim order has been placed by this.
This matter for orders on 10th of June, Monday.
Grateful. Millets.
47. Huh? 48. Who is there for 48?
Prasad Shetty.
He told me. He has participated or no interim order? Serial number 26 or 27 will order ಮಾಡಿ same order. ಆಯ್ತು ಅದ್ರಲ್ಲಿ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿಲ್ಲ learned AGS submits ಅಂತ ಹೇಳಿ.
Not 47, a date may be fixed, no directions were given to the CMC. Only a date next week, anytime, or not.
No dates.
Put up, sir, document, put up, sir, memo, document. 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 ಒಂದು
ಡೇಟ್ ಕೊಟ್ರಾ?
ರೆಫರೆನ್ಸ್ ಇಲ್ಲ, ನಂದೇ, ನಾನೇ ಕೊಟ್ಟದ್ದು.
ವಿವೇಕಾನಂದ ಅವರೇ,
Interim order.
ಎಲ್ಲ ಬರುತ್ತೆ as it is next week.
But interim order.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಯ್ತಾ?
Madam, 44, sir, 44.
44
ಒಂದು ಡೇಟ್ ಯಾವ್ದಾದ್ರು
next week.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Next week ಬರುತ್ತೆ. IA ಎಲ್ಲ next week ಬರುತ್ತೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
Next week
ಅಲ್ಲಿ ಯಾವತ್ತಾರು ಒಂದಿನ ಬರುತ್ತೆ.
B group ಅಲ್ಲ ಅದು ಅದೇ ಬರುತ್ತೆ. We'll not give dates. Next week ಅಂತ ಕೊಡ್ತೀವಿ. Senior device ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಷ್ಟೇ.
Next week Wednesday.
Any date, madam.
Any
Any date in.
Thank you.
ಒಟ್ಟು 10 ಅಲ್ವಾ ಡಿಸ್ಪೋಸ್
ಓಕೆ 10.
This was